Tabling of documents, dépôt de documents. The Honourable Parliamentary Secretary of the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, pursuant to Standing Order 36.8, I have the honour to table in both official languages the government's responses to 3 petitions.
Introduction of government bills. Déclaration des ministres.
Statements by ministers.
Delegations. Presenting reports from committees, the Honourable Member for Kitchener-Conestoga.
Here, here. Mr. Speaker, I have the honour to present in both official languages the 8th report of the Standing Committee on Environment and Sustainable Development. In accordance with its order of reference of Monday, June 10, 2013, your committee has considered Bill S-15, an act to amend the Canada National Parks Act and the Canada-Nova Scotia Offshore Petroleum Resources Accord Implementation Act, and to make consequential amendments to the Canada Shipping Act 2001, and agreed on Monday, June 27, 2013, to report it without amendment. Thank you, Mr. Speaker.
Well done.
Introduction of private members' bills. Madame Morin, Notre-Dame de Grâce-Lachine.
Ms. Morin, supported by Mr. Davies, asks for leave to table a bill entitled An Act to Amend the Criminal Code, Cruelty to Animals. This motion is deemed adopted. The Honourable Member for NDG, Lachine.
First reading of Senate public bills. Motions. Motion. The Honourable Government House Leader.
Mr. Speaker, there have been consultations among the parties, and I am hopeful that you could find unanimous consent for the following motion, that Bill S-15, an act to amend the Canada National Parks Act and the Canada-Nova Scotia Offshore Petroleum Resources Accord Implementation Act, and to make consequential amendments to the Canada Shipping Act 2001, may be taken up at report stage later this day.
Does the Honourable Government House Leader have the unanimous consent of the House to propose this motion? No? Oh, there's no consent. The Honourable Parliamentary Secretary of the Ministry of the Environment is rising on a point of order.
Mr. Speaker, this bill has the unprecedented support of parties across this House. It has the support of the environmental non-governmental organizational community, Mr. Speaker. It has the support of the Nova Scotia government. And one of my colleagues here who purports to support the environment is blocking the passage of this bill. I'm outraged.
Here, here.
That seems to be a matter of debate, not a point of order. Est-ce qu'il y a des traductions maintenant?
Is there interpretation? Yes, yes.
So that's not a point of order, but anyway. Motions, motion. Presenting petitions. Présentation des pétitions. The Honourable Member Kildone and St. Oh, sorry. Yeah. Yes, you're right. The Honourable Member for Kildone and St. Paul's.
Thank you, Mr. Speaker. Mr. Speaker, I have petitions from several hundred people across Canada calling on the government to request that Parliament amend the Criminal Code to decriminalize the selling of sexual services and criminalize the purchasing of sexual services and provide support to those who desire to leave prostitution. Mr. Speaker, the petitioners have said that the demand for commercial sex with women and children is a root cause for prostitution and trafficking, and child prostitution and violence toward women have increased in countries where prostitution has been legalized. So, Mr. Speaker, I submit these to the House. Thank you.
The Honourable Member for Trinity Spadina.
Mr. Speaker, I have 3 petitions, actually 4. The first one is from people that are mostly seniors that are very concerned about this Conservative government to make changes to the OH security program, changing the age of eligibility from 65 years to 67 years. And they call on this government to reverse it, that measure. The second petition is from people that are very concerned about animal rights. They note that animals are sentient beings capable of feeling pain and are not property, and that stray and wild animals are not sufficiently protected by animal cruelty laws under the property section of the Criminal Code, and therefore they're calling the federal government to recognize animals as beings that can feel pain and move animal cruelty crimes from the property section of the Criminal Code and strengthen the language of federal animal cruelty law in order to close loopholes that allow abusers to escape penalty. The third petition is from people in Oshawa, that they note that the Oshawa Port Authority is ruining the city's waterfront with a 12-story ethanol plant that is rubber stamped behind closed door, that the Oshawa Port Authority is ignoring the will of the local residents, Oshawa City Council, Mayor and Durham Regional Council, and they call on the government to cancel the approved FarmTech ethanol plant and halt all construction and publish all documents pertaining to FarmTech long-term lease and other Oshawa Port Authority lease agreements, and start negotiating with the City of Ottawa for the divestment of the port to the municipality. The fourth petition is constituents in Toronto. They note that 1.5 years ago, Jenna Morrison, who's a pregnant mom, died under the wheels of a heavy truck, and that perhaps her death would have been prevented had the trucks that there are side guards installed on these large trucks. So they are asking the Government of Canada to introduce a regulations under the Motor Vehicle Safety Act requiring side underrun guards for large trucks and trailers to prevent cyclists and pedestrians from being pulled under the wheels of these vehicles. Thank you, Mr. Speaker.
Petitions, the Honourable Member for Kingston and the Islands.
Well, thank you, Mr. Speaker. I have a number of petitions today. The first one is from my constituents of Kingston and the Islands, and it concerns Bills C-38 and C-45, Mr. Speaker, which gutted protection for ecosystems, especially around bodies of water. The petitioners call on the government to recognize the importance of ecosystems to our well-being and prosperity, and they call on the federal government to restore federal statutory protections for fish and other natural habitats. The second petition, Mr. Speaker, from my constituents of Kingston and the Islands concerns climate change. And you might know, Mr. Speaker, that climate change is partially responsible for the low water levels in the upper Great Lakes, and that Canada has shown a lack of international leadership. So the petitioners call on the government, Mr. Speaker, for Canada to show international leadership in reaching agreements to keep the rise in global temperatures, average global temperatures, to under 2 degrees, to take action domestically, to do our fair share, and to measure progress by an independent validator. There are two petitions, Mr. Speaker, from my constituents of Kingston and the Islands concerning genetically modified alfalfa. The petitioners are concerned that the introduction of commercial genetically modified alfalfa will affect non-GM farmers, will affect organic farmers, and may affect international trade. And so the petitioners call on the government to have a moratorium on genetically modified alfalfa until its study on farmers can be properly done. And lastly, Mr. Speaker, a petition from my constituents in Kingston and the Islands regarding corrections. They call on the federal government to adopt rational best practices, including the avoidance of double bunking, in order to reduce recidivism, to improve the rehabilitation of offenders, to improve public safety, and to avoid wasting money. Thank you, Mr. Speaker.
Petitions, the Honourable Member for Renfrew, Nipissing, Pembroke.
Thank you, Mr. Speaker. The signatories on this petition range from Alberta, Saskatchewan, Ontario, and Quebec, and they are calling upon the federal government to replace the chief firearms officers from the provinces and territories with a single civilian agency that is service-oriented so that federal law is applied evenly from coast to coast to coast.
Petitions. The Honourable Member for Burnaby Douglas, just for his initiative.
I thank my colleague for helping me out there. I'm presenting a petition today regarding bringing online petitions to the House of Commons. Mr. Speaker, the constituents who signed this petition said that they believe that the current paper petitioning system is antiquated and inefficient, and they would like the House of Commons to recognize online petitions as it recognizes paper petitions. Mr. Speaker, this is similar to a motion that I've brought forward here in the House of Commons, and I hope the government will take it seriously. Thank you.
Petitions. Petition, the honourable member for Mississauga East Cooksville.
Thank you, Mr. Speaker. I have a petition signed by many Canadians residing in Ontario, many of them Venezuelan Canadians, and there are I would like to bring attention of this House to the fact that since the last presidential election in Venezuela, democratic, human, and electoral rights have been shamefully violated. Therefore, they are asking our government to take a strong stand and help peacefully resolve the current crisis in Venezuela. Thank you, Mr. Speaker.
Petitions. The honourable member for Beauharnois Salaberry.
Thank you, Mr. Speaker. I have a petition here signed by people living in my riding of Beauharnois-Salaberry following changes to the Navigable Waters Protection Act contained in Bill C-45, which has passed, given only 85 lakes, a handful of rivers, and 3 oceans will be protected now versus all of them previously. So Bill C-45 reverses the burden of proof by forcing citizens, groups, and municipalities to bring cases before the courts if their navigation rights have been breached. Consultations will be held with promoters of projects, but under the bill, individuals and groups will be responsible for proving that navigation will be impeded. But these citizens are asking that the minister make his case and that all rivers and lakes be protected and that the environmental assessment process be implemented again. Thank you, Mr. Speaker.
Member for Kelowna Lake Country.
Mr. Speaker, it's an honour to rise on behalf of numerous British Columbians who are calling upon the government to implement the new mandatory minimum sentencing for those persons convicted of impaired driving causing death, to get tougher on impaired drivers, and to requesting the criminal code to be changed to redefine the offence of impaired driving causing death to vehicular manslaughter. And also, while I'm on my feet, I'd like to remind all Canadians as the summer is upon us to drink responsibly and don't drink and drive. Thank you, Mr. Speaker.
Petitions. The honourable member for Vancouver East.
Very much, Mr. Speaker. I'm very pleased to rise in the House today to introduce more petitions, and I've been introducing these petitions throughout the session. I would like to thank the thousands of Canadians who have been signing this particular petition that deals with the dogs and cats that are brutally slaughtered for their fur in a number of Asian regions. Today's petitions come from Saskatoon, from Vancouver, Windsor, Kitchener, right across the country. And as I say, I've been introducing these petitions now for a number of months, and obviously it's an issue that people are very, very concerned about, and they want Canada to join the USA, Australia and the European Union in banning the import and sale of dog and cat fur, and they want to support the private members' legislation that is before Parliament to make sure that this comes about. And I'd like to thank the people who have been organising this petition for their hard and diligent work across the country on this very important issue. Thank you.
Petition. The honourable member for
Petitions.
Thank you, Mr. Speaker. I rise this morning to present 3 petitions. The first deals with the proposed Northern Gateway project, which increasingly has the people of British Columbia and the government of British Columbia and the First Nations of British Columbia standing against it. These petitions are signed by residents of the Montreal area. The second petition, Mr. Speaker, from residents of the Toronto area is calling on the government to refuse to ratify the Canada-China Investment Treaty. This treaty would lock Canada in and future governments for a period of not less than 31 years after ratification. It's time to step back for ratification and actually study that treaty. The last petition, Mr. Speaker, and I'm so encouraged by support from across the aisles, this is a petition primarily from petitioners in the Surrey area in support of my private member's Bill 442, calling for a national strategy to deal with the dreadful human tragedy that is Lyme disease. Thank you, Mr. Speaker.
Petition. The honourable member for Scarborough Rouge River.
Thank you, Mr. Speaker. Today I stand to submit some petitions on behalf of constituents from all over the GTA, from Etobicoke, Richmond Hill, Markham, and of course in the City of Toronto and Mississauga, with respect to the Rouge Park. The current Rouge Park is home to the endangered Carolinian and mixed woodland plain life zones of Canada, the zones with 1/3 of Canada's endangered species, and is also the home to the ancestral home of the Mississauga, Huron-Wendat, and Seneca First Nations and their sacred burial and village sites. And because this is the last chance that we have to create a large national park in southern Ontario, an area with 34% of Canada's population, 77% of its land in agriculture, and human settlements uses only about 1/400th of the lands protected in national parks. The petitioners are requesting many things, but they're also requesting that the Government of Canada conduct a rational, scientific and transparent public planning process to create Rouge National Park's boundaries, legislation and strategic plan, and include First Nations and Friends of the Rouge Watershed on a Rouge National Park Planning and Advisory Board. Thank you, Mr. Speaker.
Petitions. The honourable member for Beaches, East York.
Thank you, Mr. Speaker. It's my pleasure to introduce two petitions to the House today. The first calls upon the Government of Canada to accept the science of climate change and table a comprehensive climate change plan to commit to attaining greenhouse gas emission reduction goals that it has supported internationally and to contribute its fair share to fill the megaton gap. The second petition, Mr. Speaker, again signed by constituents from across Toronto, is with respect to genetically modified alfalfa, and it calls upon the government to impose a moratorium on the release of genetically modified alfalfa in order to allow a proper review of the impact on farmers in Canada. Thank you, Mr. Speaker.
Petitions. The honourable member for Toronto Danforth.
Thank you, Mr. Speaker. I rise to present a petition from citizens in Toronto, especially my riding of Toronto Danforth, who are concerned that the Don River was removed from protection under what was then the Navigable Waters Protection Act by Bill C-45. They call for its re-protection, and they also want to draw attention to the fact that the right to navigation should include non-mechanized vessels such as canoes and kayaks, and they want to commit a commitment from the government to meaningful public consultation prior to approval of any project that affects the Don River. Thank you, Mr. Speaker.
Petitions. Questions on the order paper. The Honourable Parliamentary Secretary to the Leader of the Government in the House.
Thank you, Mr. Speaker. Mr. Speaker, I ask that all questions be allowed to stand.
Agreed? Agreed. Orders of the day.
Government orders, government bills, Senate. Étape du rapport du projet de loi S14 doit viser.
Bill S14, Fighting Foreign Corruption Act.
Being no motions at report stage, the House will now proceed without debate to the putting of the question on the motion to concur in the bill at report stage. Mr. Van Loan for Mr. Baird, seconded by Mr. Fantino, moves that Bill S14, an act to amend the Corruption of Foreign Public Officials Act, be concurred in at report stage. Is it the pleasure of the House to adopt the motion? Yes. Hearing no nays, I declare the motion carried. When shall the bill be now read a third time? Now. So ordered. Mr. Van Loan for Mr. Baird, seconded by Mr. Fantino, moves that Bill S14, an act to amend the Corruption of Foreign Public Officials Act, be now read a third time and do pass. Debate. The Honourable Parliamentary Secretary to the Minister of Foreign Affairs.
Thank you, Mr. Speaker. It is my pleasure to rise today to participate in the third reading debate on Bill S14, the Fighting Foreign Corruption Act. I would like to thank members of the Standing Committee on Foreign Affairs and International Development for considering this bill so quickly, and to our witnesses for their thoughtful contribution to the discussion. Mr. Speaker, I note the chairman of the Foreign Affairs Committee is here, and I just want to say to all the members of the House what a superb job he does chairing that committee. Corruption in all its unsavory forms is an affront to the values of good, honest and hardworking Canadians. Our government's position of zero tolerance in this area is clear. Canada needs to work to root out corruption wherever it lies, and these amendments to the Corruption of Foreign Public Officials Act, or the CFPOA, offer a vital contribution in this regard. Mr. Speaker, before I address the important amendments proposed in Bill S14, I'd like to first provide a sense of the considerable efforts Canada is already making in this area. It's a good story for Canadians and for Canadian businesses, and our government is convinced that the enactment of Bill S14 will only make it better. If I may, Mr. Speaker, I'd like to first establish where we are now. That is, firmly committed to combating foreign corruption in all of its guises. Our government's approach to tackling foreign bribery centres on two main thrusts: its prevention and its enforcement. This draws in contributions from a wide spectrum of stakeholders, including federal departments, Crown corporations and other agencies, all of whom collaborate closely. These actors have all worked constructively together to develop and implement the range of regulatory and legislative tools already in place to advance this worthy and indeed critically important cause. Canada is truly engaged in a whole-of-government approach to combating corruption. Clearly, Mr. Speaker, the best means of addressing corruption is working to prevent it from occurring in the first place. Consultation and outreach figures heavily in such preventative work, and a number of government stakeholders are already engaged in this area. I'd like to highlight a few of them and their contributions, if I may. The Department of Foreign Affairs, for one, looks to prepare its diplomats to deal with the issues of corruption before they serve abroad. Through the provision of information and training, the Department educates its ambassadors and political and trade stream officers concerning the Canadian Corruption of Foreign Public Officials Act and Canada's international obligations in the area of corruption. In March 2010, DFAID adopted and provided to its missions around the world a policy and procedure for reporting allegations of bribery abroad by Canadians or Canadian companies. That policy was adopted and circulated to provide guidance to Canada's missions on what they should take as appropriate measures when confronted with allegations that a Canadian business or individual had bribed or attempted to bribe a foreign public official and or committed other bribery-related offences. The policy essentially instructs Canadian officers at mission to relay any such information received to departmental officials back in Ottawa, who in turn transmit the information to law enforcement authorities here as per an established set of standard operating procedures. It should also be noted that DFAID regularly dispatches its legal officers abroad to deliver presentations and serve as panelists in various fora with a view to advancing the anti-corruption cause and building awareness of the wide range of Canadian activity in this area. As just one example, Canadian legal experts from DFAID delivered a presentation to the 2011 Conference of States Parties to the UN Convention Against Corruption concerning legal mechanisms for freezing the assets of corrupt foreign officials and for combating the bribery of foreign public officials. Mr. Speaker, as noted earlier, DFAID is joined by other departments and stakeholders in such important preventative work. Public Works and Government Services Canada, for example, recently added the bribing of a foreign public official under the CFPOA to the list of offences that render companies and individuals ineligible to bid on contracts. That change became effective in November 2012, and it is hoped that it will serve as an added deterrent to companies and individuals contemplating or engaging in such activity. Our government, through the combined initiative of several federal departments, also took steps in early 2012 to host a workshop in Ottawa on the subject of foreign bribery, with invited experts from various sectors, including NGOs, academic institutions, Canadian companies, and law firms. The workshops, entitled New Ideas for Canada's Fight Against Foreign Bribery, was designed to help innovate and develop better measures for enhancing efforts in this area and saw over 30 participants join officials in a discussion of several foreign bribery-related areas of interest. The consultation covered topics such as the recognition of a resistance to the solicitation of bribery, voluntary disclosure, books and records offences, the discouragement of facilitation payments, advocacy concerning SMEs, education, and training and focused awareness raising, as well as the discussion of the possibility of amending the CFPOA. The consultation enabled the government to register preventative messaging with Canadian companies firsthand and to really contemplate how to best improve the enforcement of the CFPOA and seek stakeholder support in working to prevent bribery before it occurs and to detect it when it does. The workshop provided a pivotal platform for enhanced engagement and cooperation with these stakeholders as we looked to upgrade efforts in this area. We continue to draw on the invaluable input received. The amendments before us today reflect some of that solicited feedback, and we will probably mine some of the good ideas heard for some time to come. Mr. Speaker, prevention is, of course, only half of the story. Our government is working hard to ensure that we effectively enforce what already exists in the way of legislation and other instruments established to advance the fight against foreign corruption. The legislative centerpiece of Canada's work on foreign corruption is, of course, the CFPOA, which has been enforced since 1999. I believe we are all familiar by now with the reasons for the CFPOA's development and its role in honouring Canada's international obligations in this area, as well as the principal purposes it serves and the main activities it criminalizes. I will not repeat those here. Rather, Mr. Speaker, I would like to use some of my time today to very briefly flag the indispensable contributions that our key law enforcement agencies are making to the enforcement of that existing legislation governing the corruption of foreign public officials. The RCMP serves as the primary enforcement body for the CFPOA, and since 2008 has had an international anti-corruption unit in place enforcing and raising awareness about the CFPOA. With a team placed in both Ottawa and Calgary, the latter owing to its position as the largest hub for Canada's extractive industries and related business, this unit will only get better and more effective with the benefit of Bill S-14's enactment. Canada's Public Prosecution Service, of course, works hand-in-hand with the RCMP to tackle corruption. Since 2006 and its creation, the PPSC has stationed one of its counsel in Ottawa with the explicit mandate to advise and assist the RCMP's two teams in Ottawa and Calgary with their anti-corruption investigations. This collaboration is paying off. We've seen 3 convictions, and there are another 2 cases pending and 35 more under investigation. The penalties are increasing significantly with each conviction, and I think we can expect this trend to continue as our legislation gets tougher and we get better at identifying and holding these offenders to account. We are on the right track, Mr. Speaker, and Bill S-14 will only drive us further in that positive direction. Mr. Speaker, having touched on what exists already and where we are at, I'd like to turn now to where we are going next. Bill S-14 is fundamental to our continued progress, and these reforms will make a significant contribution to our ongoing work to ensure that Canadian companies refrain from bribing foreign public officials and continue to act in accordance with the highest legal and ethical standards in the pursuit of freer markets and expanded global trade. This bill is compelling evidence of our government's commitment to this work, and its passage would send a crystal clear signal to other countries of our expectation that they should hold their own companies to the same account. These 6 amendments to introduce nationality jurisdiction, specify which authority can lay charges, eliminate the facilitation payments exception, clarify the scope of the CFPOA, increase the maximum penalty, and create a new books and records offence. If I may, Mr. Speaker, perhaps I'll just refresh the House's memory as to what each of these amendments provides for in turn. The first amendment, which introduces nationality jurisdiction, seeks to expand the limited reach of the existing Act. The CFPOA's current requirement is that the prosecution demonstrate a real and substantial link between Canadian territory and the offence charged, effectively to circumscribe the number of corruption cases which we can bring to justice. The assertion of nationality jurisdiction will allow us to tackle possible foreign bribery engaged in by Canadians or Canadian companies, regardless of where that bribery may take place, by enabling us to prosecute them on the basis of their Canadian nationality alone. The Second Amendment provides the RCMP exclusive authority to lay charges under the Act. This will permit the RCMP to ensure that there is a uniform approach taken to the pre-charge stages of the CFPOA cases throughout Canada. It will also put Canadian businesses on notice that it is clearly the RCMP that is the lead law enforcement agency as far as investigations are concerned. The Third Amendment proposes to eliminate the facilitation payments exception currently provided for under the CFPOA. In essence, any payments made to expedite or secure the performance by a foreign public official of any act of a routine nature do not constitute bribes for the purposes of the current Act. Such facilitation or grease payments to move along a foreign public official's performance of something he or she is already beholden to perform are plainly open to abuse and should also be characterized as bribes, which are payments specifically made to extract a business advantage and are already illegal under the Act. Indeed, bribes are illegal under the legislation of every OECD country, and this is important to recall as regards any concern that this amendment would place Canadian companies at a competitive disadvantage internationally. As noted in the bill, the entry into force of this specific amendment will be delayed to further address any such concern in recognition of the fact that some other countries continue to permit facilitation payments, and most importantly, to provide Canadian companies with a fair and reasonable amount of time to adjust their own practices, internal policies, and operations should that prove necessary. The Fourth Amendment, which proposes the elimination of the words "for profit" from the definition of business, would again work to ensure that the reach of the CFPOA is not unduly restricted. It clarifies that the scope of the CFPOA is plainly not limited to bribes paid by for-profit enterprises or in the course of profitable businesses. This is key if we are to target those who pay bribes on behalf of companies which may not earn a profit in a given year, as well as organizations with a not-for-profit raison d'etre. These entitled entities will be caught within this proposed change. The Fifth Amendment is straightforward, an increase in the maximum jail term for a foreign bribery offence under the Act of 14 years. It is currently set at 5. The current possibility of unlimited fines for such offenders will remain untouched. The new books and records offence that comprises the sixth proposed amendment is meant to prevent individuals and companies from cooking the books. While there are offences under the Criminal Code that criminalize falsification of books and records, they are not specific to foreign bribery, and Canada is required to put such specific measures in place in order to honour its obligations under international anti-corruption treaties to which it is a party. The amendment adds another enforcement measure to our toolkit and would be punishable with a maximum of 14 years imprisonment and unlimited fines, i.e. the same severity as in the place for the offence of foreign bribery. Mr. Speaker, Bill S-14 was adopted by the other place as tabled, and I would offer that it is plainly in the national interest that this House do the same. If adopted, the amendments I have just described would clearly and unequivocally demonstrate to interested parties, both in Canada and abroad, that corruption is simply not the Canadian way of doing business, nor should it be the way of doing business anywhere. Ensuring a level playing field for international business is crucial to the global fight against foreign bribery. Legislation such as Bill S-14 is vital if economic growth and expanded global trade and prosperity are to flourish. Indeed, foreign bribery works to undermine that growth, trade and prosperity, and to corrode the rule of law that is the foundation for the market freedom so absolutely vital to a trading nation such as Canada. Mr. Speaker, Bill S-14 seeks to ensure that our companies continue to embrace the highest legal and ethical standards in pursuing their business internationally. Canadians expect no less, and rightly so. Our government firmly believes that Canada can compete with the best and win fairly. S-14 is an expansion of that belief and our twin commitment to both strengthening the fight against corruption and securing jobs, economic growth, and long-term prosperity for all Canadians. I ask all honourable members of this House to work with us to ensure its passage into law as quickly as possible. Thank you, Mr. Speaker.
Questions and comments? Question and commentaire. The honourable member for Ottawa Centre.
Thank you, Mr. Speaker. I thank my colleague who sits on the Foreign Affairs Committee with me for his intervention. We've certainly talked a lot about corruption recently in this place, and I've mentioned this before. It's interesting this bill comes from the Senate, bill on corruption. But, Mr. Speaker, let's look at what this bill is doing. What it's trying to do is bring us up to speed with other jurisdictions, with other countries. And there's some problems here because we actually haven't gone far enough. My colleague will know where we rank in terms of transparency internationally. We're low. We need to go further. And so what we've said on this side is we need to strengthen our transparency measures. Just out of the G8, we see a communique coming forward. We'll be interested to see where Canada stands. So my question is this all the government is intending to do? Because it's clearly not enough. We've seen cases, we've only had 3 cases of corruption actually dealt with in the last number of years. I think he mentioned that in his comments. We need to not only strengthen the legislation and amend it, but we need to go further. So the question is the government satisfied just with this? That's going to be the status quo and they're okay with it? And secondly, enforcement. You cannot deal with corruption unless you're going to put resources. This government has cut resources to actually deal with this issue, be it in the Department of Justice, where they've cut and hollowed out resources, or be it with the Canada Revenue Agency, where they've cut resources. So 2 questions. Is this all the government has on corruption? And secondly, what about enforcement?
Parliamentary Secretary.
Well, I thank the honourable member for the question. As he knows from the hearings at the Foreign Affairs Committee, this legislation arose out of some criticisms that were made of the current Canadian legislation by the OECD in its report in 2008. We heard from testimony from a number of witnesses, including Ms. Janet Keeping, who's the president of Transparency International Canada, that this legislation very well addressed those criticisms that were raised in the OECD report. That was also reiterated and confirmed by government officials that had drafted the legislation based on the OECD report. So I think it does address the outstanding issues with our current Corruption of Foreign Public Officials Act. In addition, the government has created the Special Enforcement Unit at the RCMP to deal specifically with foreign bribery, and there are 50 personnel working there, both in Ottawa and Calgary. There are also special legal experts, both the Department of Foreign Affairs and other departments, such as the Department of Justice, who are made available to the RCMP and all government departments to deal with allegations of foreign corruption. There's always more that can be done, Mr. Speaker. The Prime Minister made a very important announcement on transparency in London last week. And legislation will be coming forward in that regard with respect to requiring Canadian companies to disclose what payments they make to foreign governments. So there's always more that can be done. We're certainly open to suggestion from that honourable member, his party, and any other international organization that sees a way in which we can improve our legislation, because, of course, this is key to Canada succeeding as a trading nation. Canadians can compete fairly and succeed. They do every day, and we want to enforce that all the time. Thank you, Mr. Speaker.
Come on tide. Questions and comments. The honourable member for Timmins, James Bay.
Thank you, Mr. Speaker. I think my honourable colleague will agree that Canada's international mining presence it's a major driver in our economy. We can actually set the standards for what could be seen as the best in the world. Unfortunately, Canada's reputation has suffered because of the actions of some bad actors, and it's damaged the legitimate companies, and it's damaged our interests. I think it's really important that the government takes this seriously to show the world that the Canadian standard is something that we should be proud of. So I'd like to ask my honourable colleague, number one, in terms of the issue of bribery and corruption, we have very large corporate interests overseas, but we also have the small players, and it's some of the small players who've gotten us into trouble. Should we be looking at different thresholds for what has to be revealed? Because when you're a smaller player, 10,000 euro could be a huge amount of money in terms of putting a deal in your manner in a way, as opposed to 100,000 euro, because a lot of the areas that they're moving into are, and sometimes it's been a little bit of bandit country, so money is being used all the time to grease wheels. I'd like to ask him about thresholds for development, the development companies, the smaller players, the juniors versus the bigger players, whether we need two standards. And the other question is enforcement, because it is happening overseas. It's happening in some pretty rough and tumble places where where the rule of law simply has not existed. So how do we ensure that we have the transparency for being able to say that we will hold these companies to account?
Parliamentary Secretary.
Thank you, Mr. Speaker, and I thank the member for his question. He's right. Canadian companies are amongst the largest and most prolific in the extractive industries in the world. A statistic I believe I heard recently was that 50% of all the major mining companies in the world are actually Canadian-based, which I think is something to be very proud of. He mentions threshold levels. I'm really not quite sure what he's referring to. The legislation doesn't set any minimum amount for bribery. All bribery is illegal, whether it's $1 or many millions of dollars. So we don't have any minimum standard. We expect all Canadian companies, large and small, to live up to the highest ethical standard. There is a very strict focus on small and medium-sized enterprises. I mentioned that in my speech earlier. We have done a lot of training and outreach to small and medium-sized enterprises across Canada to make sure that they are also aware of the Corruption of Foreign Public Officials Act and their obligations they're under. But we'll continue to do so. Enforcement is important. As I said, there are 50 individuals in the RCMP, both Ottawa and Calgary-based, and legal officers who are looking at the corruption of foreign public officials full-time, ensuring that Canadian companies, large and small, continue to live up to the highest ethical standards. Thank you, Mr. Speaker.
Question and comment time. The Honourable Minister.
Well, thank you, Mr. Speaker. And as someone that has come from a law enforcement background, I can well appreciate and wholly support the thrust of this particular bill, what it intends to do, and more so how it is in keeping with the kinds of standards that we are employing in our dealings with foreign aid, for instance, development aid, and so forth. But the other thing that I wanted to, the item I wanted to ask my colleague, Mr. Speaker, is if he can also speak to the issue of enforcement as it relates the cooperation that I know exists and is in place between the international law enforcement community, and how the Canadian aspect of this particular initiative, the enforcement aspect, of course, how that would play into the international law enforcement community to investigate and track and chase down some of these allegations and the need to do international investigations. If you could speak to that issue as well, please. Thank you, Mr. Speaker.
The Honourable Parliamentary Secretary.
Well, thank you, Mr. Speaker, and I thank the Minister for his question. Of course, Canada and the RCMP are members of Interpol. They have officers stationed with Interpol in various places around the world, and they cooperate with Interpol and other foreign police forces to deal with allegations of bribery. In addition, all of our diplomats abroad have been trained, specifically trained on the Corruption of Foreign Public Officials Act, and investigate any allegation they hear from anyone in the countries they serve in that any Canadian or Canadian business has been involved in bribery or attempted bribery. They report it back home here to Ottawa to the RCMP, and the RCMP would then take it forward with their counterparts in whatever country the bribery is alleged to have taken place in. So it's obviously very important that international police forces cooperate very closely on these types of allegations to ensure that the evidence is discovered to bring forward successful prosecutions. I believe that's happening now. That's why we've seen several successful prosecutions recently, and I understand there are at least 35 more investigations currently underway. Thank you, Mr. Speaker.
Amount time. Questions and comments. The Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I thank the Parliamentary Secretary for his speech. I certainly support this bill. I think Canada needs to bring our enforcement standards to the level that the OECD would see us at the highest level of enforcement. But my question is a more general one to the Parliamentary Secretary. I think we have to face the fact that we have some problems that we never thought we would see as Canadians, where corruption is becoming a larger issue. People are seeing it. We have the instance of SNC-Lavalin. We know that AECL used officials in the past. They say, well, they were at arm's length, but we did have a South Korean contractor go to jail for the work in trying to entice that country to buy a CANDU reactor. We've fallen on the Transparency International's Corruption Perception Index from 6th place, and we're still among the best in the world. We're at 10th place. But at the time when we see charges of bribery and arrest of municipal officials in different places across Canada, we've seen, I think, a disturbing trend of lack of ethics, the kind of things that aren't governed by a rule book, but come from the sense that you actually care about how you're seen in the world and conduct yourself in ways that you'd be proud for your children to hear about, not just those ways that you hope you're all right if you don't get caught. I'd like to ask the Parliamentary Secretary if there isn't something more that can be done in terms of leadership to clean up our act as a society and practice good ethics, habituate ourselves to values instead of to vices in the way we organize our lives.
Honourable Parliamentary Secretary, you have about a minute.
Thank you, Mr. Speaker, and I thank the honourable member for her question. Enforcement is very important. The Prime Minister made a very important announcement in London last week about legislation that will be presented soon requiring Canadian companies to disclose all payments that they make to foreign governments. I think that's a big step forward. The enforcement provisions under Bill S-14 and the penalty provisions under Bill S-14 are very important. They're going to be amongst the highest penalties in the world. Some have wondered why they should be. In fact, the penalties here under S-14 will be higher in some cases than the penalties for domestic corruption, but that just means that the Canadian Criminal Code probably needs to be updated as well. We're setting the bar higher with this bill. And we're sending a clear and strong message to Canadian companies and to people all around the world that Canada will not tolerate this kind of corruption, either here at home or abroad. Another measure that I mentioned in my speech is that Canadian companies which engage in foreign bribery and are convicted of foreign bribery will no longer be able to bid on Canadian government contracts. That's a huge disincentive, Mr. Speaker, for them to do these kinds of things abroad. So we think the combined suite of penalties and enforcement mechanisms we're introducing here today will send a really strong message to Canadian companies and everyone in the world they need to compete fairly and ethically to succeed. Thank you, Mr. Speaker.
Reprise the débat, resuming debate. The honourable member for Ottawa Centre.
Thank you, Mr. Speaker, and rise to speak yet again to Bill S14. We have mentioned this on this side of the House before, that we support the bill. We believe that we can go further, as I mentioned in my comments and questions to the Parliamentary Secretary. And as I have done in all of these bills, I do have to start off with our concern and my concern as to the way in which this bill came to us, Mr. Speaker. We have a bill on foreign corruption coming to us from the other place. That's the indication is, of course, when it has S in front of the bill number, it's coming from the Senate. And it's been commented numerous times since we've been debating the bill that the government should have saw fit that this bill start here in the House. After all, the elected representatives, I think, are the best people to actually look at corruption, notwithstanding what's happening in the other place. To speak of corruption, every day there's another story of corruption in the other place. So I have to start my comments off by underlining that point. The government seems to not even blush anymore when they send bills over from the other place, but at least on this bill they should have some contrition on the fact that there's a bill, an Act to amend Corruption of Foreign Public Officials Act. We're going to try and crack down on foreign corruption, but we have a bill coming from the other place, unelected body, where they're actually mired in corruption right now. And it's rather stark to see this happen with this government who claimed they were going to be different, and now they've just become like the other guys. They just, bring in closure, use the Senate, abuse the Senate to do their toil, and that's what they've done with S14, and no one even blushes anymore, Mr. Speaker. It's just business as usual with this government. Use the Senate to do their bidding, even on something as important as foreign corruption. The bill itself, Mr. Speaker, as has been mentioned, it simply brings us up to the minimum standard of our allies. The government was embarrassed, not only from the critique that some of us have been providing on this side of the House in terms of how the standards for our companies abroad have fallen in terms of enforcement on things like corruption, on corporate social responsibility. We just saw a news report last night about what happened in Bangladesh, and we shouldn't forget that. And NDP had hearings at the Foreign Affairs Committee called for, and we'd like to see more done in that. But it's about Canada actually getting in the game again and actually leading. This doesn't go far enough. So the bill itself is, as was mentioned, I'll just give a quick resume. The bill makes 4 major changes to the Corruption of Foreign Officials Act, increases the maximum sentence, as was mentioned by the Parliamentary Secretary. It eliminates an exception of so-called facilitation payments, and this is basically paying someone to, grease the wheels to get a contract moving. We saw that actually, interestingly enough, the allegations happened in Montreal. Maybe we should be applying those rules a little more forcefully here, and maybe the government should be taking a look at who their candidates are when they actually recruit them. Hopefully they'll do a better job on that, and who they hire as their staff when their ministers go out and hire ex-candidates. But the bill creates a new offence for falsifying or concealing books or records. I'm going to touch on this as we just got the communique of the G8. Just came out half an hour ago. I got access to it. And that's important. And in fact, I think the G8 communique, if the government's going to live up to what it signed on to, they'll have to actually amend this bill further, because there's an incentive in this communique for the government to do more in this area, to be more transparent in terms of books and records. And finally, the fourth piece of this bill is establishing the national jurisdiction that would apply to all of the offences under the Act, such that Canadian nationals could be prosecuted for offences committed overseas. So you can't go overseas and do something that you couldn't do here. Mr. Speaker, so those are the aspects of the bill. I think it's important to put it into context. As I mentioned, we just received the communique from the G8 conference, and it touches on many of the aspects we're dealing with in S14. It's a 10-point communique. It starts off with the first point. I'm not going to read all of them because they're not all directly related to the bill we're debating. But the first point that the G8 leaders signed on to was that tax authorities across the world should automatically share information to fight the scourge of tax evasion. When you're talking about corruption of foreign officials, a lot of it has to do with the way in which money moves around. So I am delighted to see that this is in the communique. We'll look further to see if the government's going to take this seriously. Number two is countries should change rules that let companies shift the profits across borders to avoid taxes. A multinational should report to tax authorities what they pay and where. This has been mentioned already by the Parliamentary Secretary, some more transparency for companies' operations. Companies should know who really owns them, and tax collectors and law enforcers should be able to obtain this information easily. If we don't have this in place, the S14 provisions will be very difficult to enforce in some cases, because if we don't know who owns companies, we don't know who's influencing the companies, and we don't have a full profile. In other words, if we're trying to establish that there was payment of corruption with a company to an official, if we don't know who the company is, it's very difficult to prosecute that, Mr. Speaker. What we do know, and what we've heard from the G8 meetings, is that Canada was fighting this, and it's something that we should be fighting back and getting the government to comply. It turns around the issue of beneficial ownership, Mr. Speaker, and this is where the term basically is where you have a company that is hidden behind a shell. And what the G8 is looking at, and Mr. Cameron is pushing for, is, and that's what number 3 in the communique is about, is that there's full disclosure. You can no longer have this method of hiding behind this kind of parlor trick of a beneficial ownership. So what that means is having a public registry of all companies sourcing exactly who owns them. We don't have that right now. And what I see in the communique is Prime Minister Cameron saying, personally, I would hope that the whole world will move towards public registries of beneficial ownership. Aid agencies say that private registries would be the second best. In other words, that there would be a registry, but it wouldn't be public, but it would be in government. We're hearing that only the UK and the US have committed to have these public registries. So I hope that the government will take this seriously, because if you're going to deal with foreign corruption, you have to have transparency. And if we're serious about this communique we've signed on to, then what we have to have is a public registry of all companies, who owns them and where they sit, because otherwise we will not be able to live up to the spirit of transparency. The other issue is developing countries should have the information and capacity to collect the taxes owed them, and other countries have duty to help them. This is really critical when it comes to this issue of being able to influence foreign officials, because often what you'll hear on the ground in emerging economies, developing economies, is that officials are able to take advantage of their power of being able to approve projects, etc., mainly because there's not a requisite tax system with the proper enforcements and oversight, and so they can get away with it. And this is where it leads to corruption, when you don't have the proper oversight. This number 4 in the communique of the G8, making sure developing countries have the information and capacity to collect taxes owed them, is extremely important, because obviously it helps benefit their citizens, but it also it's a way in which you can deal with the potential for corruption. Because if you have full disclosure and sunlight, if you will, on who owes the taxes, whether they've been paid, then it is a disincentive, and it's a disincentive for officials to try and use their power for corruption. The other one is very important to us in the NDP, and it's around number 5 of the communique. And it's the extractive companies should report payments to all governments, and governments should publish income from such companies. We heard positive message from the government that they will get behind this. We need to see legislation. From what we've seen, there's no requirement that these reports are to be made public from what we've heard from the government. Again, it's important that we fully embrace transparency here and not just go halfway. So when extractive companies, and by the way, mining companies have said that they would sign on to this. I'm hoping that all the extractives get behind this. Minerals, number 6, very near and dear to my heart, is minerals should be sourced legitimately, not plundered from conflict zones. Mr. Speaker, this is the whole issue around conflict minerals. As you know, right now, massive corruption and human rights abuses going on in places like the east of the Congo, where minerals that go into all of our devices that we use, like our BlackBerries and our cell phones, are actually coming from a conflict zone. So that, in essence, we're all carrying a piece of the conflict unknowingly for many people in all our electronics, because we don't have proper sourcing of minerals. And what the communique says here is that minerals should be sourced legitimately, not plundered from conflict zones. So this means that this is a challenge to this government. Are they going to get on board? Bill C-46 I put forward would allow us to comply with what we've seen in the United States with Dodd-Frank's, where they actually have legislation in place now to make sure that all minerals are sourced from legitimate sources and not aiding and abetting conflict. The Europeans are moving in this direction. The OECD, which we talked about in terms of this bill, has provided guidelines on ensuring that there is proper and appropriate oversight when it comes to sourcing minerals. So number 6 is very important, and it's something I've worked with a lot of people, including people in this place, to get Canada on board and at least get us up to the standard that's been established by others. Number 7 is very important when it comes to the communique that was just put out. Land transactions should be transparent, respecting the property rights of local communities. Mr. Speaker, when it comes to corruption of foreign officials, one of the biggest trends we've seen in the last while is the acquisition of land by foreign countries, particularly in developing countries. There's a massive land grab going on right now, particularly in Africa. I'll name some countries. China's big into this right now, and they're banking land, they're taking over land, and we need to make sure that local communities are respected. We certainly have a debate around this. Let's be honest. We're not perfect here in Canada. You know, when we talk about social license for companies to be able to do their work in terms of the extractives, oil and gas, we need to be respecting local communities. But this is extremely important and urgent issue when it comes to developing countries, because we're seeing these massive land grabs. And what it means is the access to food. It's about food security. And it's about certain countries banking land and keeping an eye on their needs for minerals, oil, gas, etc., and in some cases even for food. So number 6 of this communique, number 7 is very important, that land transactions should be transparent. Number 8, government should roll back some measures on trade that they think would be helpful for trade. Number 9 is about making sure that things are streamlined, particularly at borders between countries. We certainly know that issue with our friends south of the border. And, Mr. Speaker, I don't have to tell you, representing your constituency, that this is extremely important. But number 10, the last part of the communique from the G8, government should publish information on laws, budget, spending, national statistics, elections, and government contracts in a way that is easy to read and reuse so that citizens can hold them to account. That's actually for us. Now, I'm going to read that one again, Mr. Speaker. It's very cogent, because if we're going to talk about fighting corruption abroad, we need to be transparent at home. So what the G8 has signed on to is that government should publish information on laws, budgets, think Parliamentary Budget Officer here, Mr. Speaker, spending, national statistics. This is very interesting considering what we've done to Stats Canada. Elections, and government contracts in a way that is easy to read and reuse so that citizens can hold them to account. Number 10 is something that I think is urgently needed to bring into force here. So, Mr. Speaker, I've listed these G8 points that just came out in the communique because I said in my comments prior to when I questioned the parliamentary secretary, this bill does not go far enough. If we're going to seriously deal with corruption abroad, and we're going to actually be leaders, then it's not good enough just to get up to a minimum standard. That's not the Canadian way. I feel that we're living in the past with this government. The way this government seems to operate is that, and the parliamentary secretary said it well himself, the reason they brought forward this bill was because the OECD had cited us as being laggards. So it wasn't until that happened that this government decided to bring forward this legislation. That's not the Canadian way. We should be leading on this. We should be saying, let's take a look at our practices. How do we stand in terms of the standards of other jurisdictions? Everyone knew that we were laggards. Transparency International has been citing us for quite a while. So what we need to do, and take a look at this 10-point communique of the G8, is are we going to actually go to at least the standard of our allies? I'd like to see us go further. I'm concerned, for instance, that when it comes to the issue that Prime Minister Cameron cited on companies really knowing, companies should really be transparent as to who owns them so we can deal with tax evasion. What we're hearing is that we're not going to do that, that we're not going to publicly publish who owns what company. Well, as I mentioned, we need to deal with corruption seriously. You need to have the full daylight. And if the government's only going to go halfway in this initiative, we'll again fall back. And we'll be back in this House debating a bill to bring the standard up yet again. The government should actually embrace what both the UK and the US are planning to do and have public registries as to who owns which companies and stop the shell game and particularly this practice of beneficial ownership. The other is to make sure that we are transparent when it comes to extractive. You know, the government talked about signing on to the initiative of ensuring that all payments that are made exchanges between governments and between companies, foreign governments and Canadian companies, are going to be transparent. But to whom? Is it going to be kept within government, or is this going to be public? Do we have to ATI this? Or is the government actually going to do what other governments have done and make it transparent? And the one I mentioned before, and that is to ensure that we get up to the standard of other countries when it comes to the issue of conflict minerals, so that we no longer are looking the other way when it comes to the sourcing of the supply chain for many of the things that we rely on in our technologies. If we are serious about it, then I think we would embrace these initiatives that I just mentioned, being fully transparent on who owns what companies, being fully transparent and pushing transparency when sourcing minerals in terms of the supply chain of our electronics, be fully transparent when it comes to looking at payments between companies and governments abroad. Then we will be at the same standard as our allies. If we don't go to that standard, Mr. Speaker, then we'll be left with what we're doing here, and this is trying to catch up. And I have to say this in a, if I will be a bit partisan, what we've seen from this government is that we become laggards. We sign on to international treaties, but then we don't follow up with implementation that lives up to the treaty. S10, which we've debated, we've been called out by Norway and the Red Cross, the fact that the cluster munitions treaty that we signed on to is actually under the implementation legislation, S10, will undermine that international treaty, Mr. Speaker. Think about that for a second. The International Committee of the Red Cross never comes out and criticizes government. They just did yesterday. They said that S10, the cluster munitions treaty that we signed on to, the implementation bill for that treaty, is actually going to undermine the treaty. It's shocking. So, I'm very concerned that when we sign on to this communique for the G8, that we actually follow up and live up to the spirit of what we've signed on to and not undermine it. I'll give you another example when it comes to international treaties. The arms trade treaty we agreed to, and then we find the gun lobby take it over by this government. It's astonishing. And so instead of, embracing the future, these guys are living in the past, Mr. Speaker, and they're affecting our reputation. And instead of getting on board with progress, they're holding us back, and just because of their ideology. So, Mr. Speaker, this bill will be supported by us simply because it's the least this government can do. What we want to see is full transparency, and when we see the follow-up to the communique on the G8, we will be holding this government to account to at least come up to the standard of our allies. Personally, and I'm sure I speak on behalf of my colleagues, we'd like to see Canada actually lead, not be laggards, and that's something that I think most Canadians would want to see. Thank you, Mr. Speaker.
Questions and comments? Question commentaire. The Honourable Minister.
Thank you, Mr. Speaker. I trust the member opposite knows better, and quite frankly, I find his broad brush accusations of corruption in the other place obscenely disingenuous. People who live in glass houses should not be casting stones. And I happen to know that the overwhelming majority of Canadians, senators included, are decent, hardworking, honest people that deserve much more respect than what the member opposite has decided to cast in their way. For the member opposite to suggest otherwise, I believe, is nothing more than a mean-spirited political exercise in character assassination. In light of the member's self-defined righteous value system, can he then explain to Canadians how it is that his leader failed to immediately disclose his involvement in an attempted bribery offer some 17 years ago, and how can the member consider such hypocrisy worthy of this honourable place?
The honourable member for Ottawa Centre.
Well, I didn't mean to exercise the minister to the extent that he seems to be so exercised. I simply made a comment, didn't mention one senator. I said it is ironic, a literary device, irony, about the fact that we're dealing with the bill. We'll go over it slowly. Bill S10, which is a bill to deal with corruption, and it's coming from the other place. And that's all I said, Mr. Speaker. So maybe he's feeling defensive about payments from the Chief of Staff of the Prime Minister to a senator. I don't know what he calls that. I don't call it enlightened behavior. What I do call enlightened behavior is when you have a party that's saying, let's bring us up to an ethical standard and let's have integrity in terms of how we do our business, and not to, and actually when you make a mistake, you own up to it. We haven't seen that from this government. And, in case he wasn't listening carefully, I didn't name any particular senator. I said the irony. And so I would encourage him not to get too exercised about just using, maybe I'll use a metaphor later, but don't take it personally.
Showing commentaire, questions and comments. The honourable member for Saanich Gulf Islands.
Mr. Speaker, and I appreciate very much, as I always do, the articulate and thoughtful presentation by the member for Ottawa Centre. I'm wondering if he could respond to the same question I asked the Parliamentary Secretary earlier. I think we're seeing a general problem, and I never thought I'd see the day, for instance, Mr. Speaker, that academics would forge the research that they do in order to get grants. And there's a decline in our general sense of my grandfather's day that all I have is my good name, people used to say, and it used to mean something. And whether it's that we think that as long as you're, celebrities seem to think that as long as they're in the media, it doesn't matter if the stories they're telling about themselves are good or bad or indifferent. But the standard to which we hold ourselves is falling. There's no question about that. And the response from the minister, as if the member for Ottawa Centre had said something outrageous. Analogies and irony and metaphor have a place even here. But so my question to him is, what would, Mr. Speaker, this member do and all Canadians do to, when we hold up a mirror to ourselves and look at ourselves, know that we are the ethical country we think we are? How do we get rid of corruption, which seems to be on the increase across Canada?
The honourable member for Ottawa Centre.
Thank you, Mr. Speaker. I thank my colleague for her question. I want to touch on maybe two aspects of her question. One is domestically what we can do. We need to be a lot more ethical in our standard, obviously, as politicians. We have to make sure that the people that we're appointing to senior posts are going to be the living up to that ethical standard. I think of the case of Arthur Porter. Here's someone who was appointed to oversee national security, essentially, to ensure that there's accountability there. And now we find him in a jail in Panama. I think that could have been avoided. We think on this side we should have a public appointments commission that would actually allow for vetting of appointments of senior officials like this. And the government is so stubborn on this. They just avoid it because their guy, Gwen Morgan, who they thought was, somehow objective from partisanship, I'll leave others to look into that, was the only person who in the entire, out of over 30 million people, there was only one person who could do the job. So they picked up their toys and went home, and they killed the Public Appointments Commission. That's the problem with this government. So we should have that in place. We should have all staff of ministers abiding by an ethics code like they do in the UK. That was part of the NDP's platform in the last election. We should have ethical standards for advisors, and we should have more accountability in ministers' offices, and we should allow Parliament to be a little more, autonomous from the executive branch. And clearly, we've seen problems with that with this government. That would be a start, and later on, maybe we could talk about what we could do internationally.
Commentaires, questions and comments. L'honorable député de Macarel-Fortin.
Monsieur le Président, la corruption est un mal qui ressemble beaucoup à un cancer. Et malheureusement, lorsqu'on permet à des entreprises canadiennes de trop facilement s'en sortir lorsqu'ils corrompent, ça déteint non seulement sur notre vie à l'intérieur au Canada, mais aussi sur nos institutions et notre représentation. Trop souvent, à l'intérieur de nos ambassades à l'étranger,
Est-ce que ça marche? Si le député pourra continuer pour une minute.
Je reprends ou je continue?
Continuer.
OK. Et le problème, c'est que malheureusement, à l'intérieur de nos ambassades...
Attends une minute.
Ah, OK.
Somebody do something.
Pas de problème technique de fin de session.
Pas de traduction.
La traduction ne marche pas.
OK.
On a un technicien qui est en chemin. C'est défectueux dans la boîte.
There's actually a problem with the box in the translator's booth, so we'll have to suspend for a few minutes.
OK, on va parler. Veux-tu écouter ici? OK, ça fonctionne ici. On va vérifier si le son va après une piste.
That's French coming through on English.
Oh, I'm talking French there. Testing English, 1, 2, 3, English?
English is coming through, yeah.
OK. OK, broadcast English. OK, ça a l'air de marcher. Hein? OK.
It appears that we are ready to go. Ça regarde que on est prêt, monsieur.
The member for Marquard-Fortin, please continue. Thank you, Mr. Speaker. Essentially, what I was saying is that if we want to fight corruption, we need to talk about the unfortunate, inappropriate behavior because the government offers foreign students, if they are children of government officials from abroad, they have opportunities to immigrate rather. So will our diplomats seek to enforce this legislation and to apply it and ensure that they don't open themselves up to criticism in this regard?
Member for Ottawa Centre.
Thank you, Mr. Speaker, and thank my colleague for his patience in getting the question out. It was a good one. You know, when we talk about accountability and we talk about oversight, it's really important that all our officials abroad are going to be, and I heard the Parliamentary Secretary talk about the training of our diplomats to deal with issues like the one we're discussing today. But it needs to have really strong oversight when it comes to you know, the government of the day being able to assure its citizens that everyone who's working abroad is doing it for the public good. And that's why we've touched on the need for more ethics in ministers' offices, for instance. You know, I think it's high time that, you know, the staff and advisors to ministers are going to be providing the highest ethical standard they can provide to their ministers. We've asked to see that happen. The same has to happen when it comes to, you know, our diplomatic corps. We need to see that they're going to be abiding by the highest ethical standard. I'm more concerned right now, however, but between the relationship between some who are involved in, you know, commerce abroad and dealing with foreign governments, and simply because the rules haven't been clarified. And business will tell you, if there's clear rules, they will follow them. The problem with this government is they haven't clarified the rules, and that's what we need to see more of.
Questions and comments? The Honourable Member for Châteauguay-Saint-Constant. Well, thank you, Mr. Speaker. I'd like to start out by congratulating the member for Ottawa Centre, my colleague, for his excellent work as official opposition critic on foreign affairs. And at the same time, I'd like to point out that the minister can't appreciate the good work done by my colleague because he was somewhat upset by certain comments that my colleague mentioned, but my colleague was right in saying that this bill doesn't go far enough. It will hardly enable Canada to climb the ranks. Transparency International has ranked us quite low with respect to what the country is doing with its approach to corruption. So my colleague mentioned a number of aspects that were extremely interesting and important, and I'd like him to elaborate on them. He said that Canada is dragging its heels in terms of adjustments that are required as a result of international agreements that it signs. Canada is lagging behind. It hasn't adjusted its legislation or amended it to bring it up to speed and in compliance with international treaties. Oftentimes, Canada doesn't respect these treaties. It doesn't modify its legislation in accordance. What can the honourable colleague tell us about Canada's image, the hit that it's taken? What can Canada do to improve its image, because it has been terribly tarnished in the past?
We out of time for your minute.
Well, just simply put, start living up to the treaties we sign on to, making sure that when we bring in legislation to actually enact these treaties, we're not undermining these treaties, and sign on to the ones that we agreed to, like the Arms Trade Treaty. Maybe will get us going on providing more credibility in the international community. Our international image is suffering simply because this government's seemingly living in the past. It's time to get on with living in the real world and getting on with the standards that we've seen set by our allies. And on the G8, let's hope that this communique is not just going to be words, that we'll actually see action from it. Thank you.
Resuming debate, to the prise de débat, the honourable member for Charlottetown.
Thank you, Mr. Speaker. I'm pleased to add my voice to the debate on Bill S-14, an act to amend the Corruption of Foreign Public Officials Act. Mr. Speaker, this bill makes 6 much-needed amendments to the Corruption of Foreign Public Officials Act. First, it will remove the words for-profit from the definition of business so that bribes involving non-profits and charities are included in the Act. Secondly, it will increase the maximum sentence of imprisonment applicable to the offence of bribing a foreign public official from the current maximum of 5 years in jail and unlimited fines to 14 years and unlimited fines. Third, it will eliminate the exception contained in the Act for what's called facilitation payments. These are payments for carrying out acts of a routine nature. So that exception will be eliminated. Fourth, it will create a new offence relating to books and records and the bribing of a foreign public official or the hiding of that bribery. Fifth, it will establish nationality jurisdiction that would apply to all of the offences under the Act, so that all Canadians, permanent residents, Canadian companies, etc., can now be charged for crimes taking place in foreign countries. And finally, it will designate the Royal Canadian Mounted Police as the agency with the exclusive ability to lay charges associated with the Act. This specifically refers to the RCMP International Anti-Corruption Unit. And these changes, as you've already heard, Mr. Speaker, are meant to bring Canada in compliance with the OECD Conventions on Combating Bribery of Foreign Public Officials in International Business Transactions that this country ratified in 1998, as well as other international obligations. The Liberal Party will be supporting this bill as they did through the Senate. Mr. Speaker, despite widespread calls for Canada to step up its foreign anti-bribery measures during the 7 years that the Conservatives have been in power, they've really only just begun to deal with the shortcomings of this statute that they propose to fix by this bill.
S14 updates Canada's anti-corruption laws and puts them in line with Canada's international anti-bribery convention commitments made with the OECD, as well as others made through the United Nations and the Organization for American States. But in addition to meeting our commitments to various anti-bribery conventions, Bill S14 allows Canada to be a country that demonstrates a high level of ethical standards for other countries. There are important preventative measures that governments should be taking to ensure that the RCMP has the resources to successfully investigate cases relevant to S14. A private member's bill C-474, proposed by the Liberal member from Scarborough-Guildwood, is one such measure, but sadly it is being opposed by the government. Bill C-474 will attempt to make revenue transparency the norm in resource extraction industries. This transparency would allow for S14 to be more preventative instead of reactive. Bill S14, presently before the House, will result in more prosecutions and convictions for foreign bribery offences. And Canada is a bit of a laggard in this regard, Mr. Speaker. Even accounting for size differences in population and economy, Canada falls behind, having only prosecuted three cases compared to other major economies. 227 cases prosecuted in the United States, 135 in Germany, 35 in Switzerland, 24 in France, 18 in Italy, and 17 in the United Kingdom, as an example. So, Mr. Speaker, this bill, as was indicated, will amend the Corruption of Foreign Public Officials Act, which was passed in 1998 and came into effect the next year. Its passage meant that Canada ratified the OECD Convention on combating bribery of foreign public officials in international business transactions, and the Corruption of Foreign Public Officials Act also implemented Canada's international obligations under the United Nations Convention Against Corruption and the Inter-American Convention Against Corruption. In 2002, there were several technical amendments that were made because of, to the Act because of amendments to the relevant sections of the Criminal Code. Now, the OECD Working Group on Bribery has produced at least 3 follow-up reports on Canada's progress. The Phase 1 report was released in July of 1999, the Phase 2 report in March of 2004, and the Phase 3 report just in 2011. And each of them commented on Canada's progress and set out areas where Canada needed to improve to stay on par with our international neighbours. In the Phase 1 report in 1999, it was focused on the implementation of the Corruption of Foreign Public Officials Act. It was almost entirely positive. It stated that overall the working group is of the opinion that the Canadian Act meets the requirements set by the Convention. It did address issues that might need to be discussed during the Phase 2 evaluation in 2004, including the exemptions for acts of a routine nature, that's the facilitation payments that I referred to earlier, the effectiveness of the penalties, including monetary sanctions, the lack of the nationality jurisdiction, and all of these things that were referenced in that Phase 1 report in July of 1999 are now contained in Bill S14. 5 years later, the recommendations contained in the Phase 2 report included the following: giving one of the agencies responsible for the Corruption of Foreign Public Officials Act's implementation a coordinating role, reconsidering the Section 3 sub 4 exemption for facilitation payments that I referred to earlier, to redefine the word business in Section 2 to include those not for profit, and to reconsider the decision to not establish nationality jurisdiction for the crime of bribing foreign officials. And as you can tell, Mr. Speaker, all of these things, again, the recommendations from the working group have been included in the provisions of S14. In 2008, the RCMP formed an International Anti-Corruption Unit, which became responsible for investigating bribes of foreign officials. It has 2 7-man teams, one in Ottawa and one in Calgary, Calgary being the centre of Canada's resource extraction industry. And they work with the Public Prosecution Service of Canada, which does the actual prosecutions in foreign bribery cases. And as of May of this year, there are 35 ongoing foreign bribery investigations. Also, as of May this year, there have been only 3 convictions against companies in the oil and gas sectors, with fines of $9.5 million and $10.35 million in 2 of those cases. One was, as you would know, Mr. Speaker, the case of Griffith, an engineering company that had an inappropriate financial relationship with the former ambassador from Chad's wife, and Nico Resources for bribing a Bangladeshi official. SNC Lavalin, Canada's premier engineering firm, was recently convicted on bribery charges in Bangladesh and has been barred from competing for World Bank contracts for the next decade. In 2009, an attempt to implement similar changes to those in the bill before us today passed second reading and was at the committee stage when it died after the Prime Minister prorogued Parliament in December of 2009. So that brings us then to the Phase 3 report of a couple of years ago from the OECD working group. And it again found problems in several areas, including only counting bribes for the purpose of gaining a business advantage for profit, and these sanctions were not effective, proportionate, and dissuasive. The extraterritorial jurisdiction issue, which I mentioned in connection with the nationality jurisdiction, which only applied to bribery carried out overseas if there was a real and substantial link to Canadian territory, and that considerations of national economic interest, the potential effect upon relations with another state, or the identity of the natural or legal persons involved are only prohibited if improper. Mr. Speaker, in 2011, Transparency International Global Corruption, in the Transparency International Global Corruption Report, Canada fell in the lowest category of countries since it had little or no enforcement in terms of following the OECD bribery standards, and was the lowest ranked member of the G7. So, as indicated, the measures contained in S14 are long overdue, are needed to bring Canada into line with its international obligations, and are measures that the Liberals will be supporting. Thank you very much for the opportunity to speak to this bill, Mr. Speaker.
Questions and comments? Question et commentaire. The honourable member for Vancouver East.
Well, thank you very much, Mr. Speaker, and I listened with interest to my honourable colleague's comments on this bill, and I would certainly agree with him that this bill is long overdue, and I just wonder whether or not he had also picked up on the communique from the G8 that my colleague from Ottawa Centre mentioned earlier in the debate, and one of the items that he focused on in looking at the G8 communique was the need to have a public registry, a need to have much better transparency for companies operating abroad, and to get away from this idea, or not idea, but the practice that you can hide behind a shell company. So even if you do want to enforce the law, it's hard to know to whom it should be enforced against. And so I wonder if my colleague agrees that we need to actually go further than this bill and to adopt measures such as a public registry to avoid shell companies being set up.
The honourable member for Charlottetown.
Thank you, Mr. Speaker. And yes, I share the concerns expressed by the member. This is a real opportunity, with Canada being such a significant player in the resource extraction industry worldwide, not just to meet and to be level with its international obligations, but to lead. And an excellent example was just cited with respect to transparency. I do believe that the private member's bill brought forward by the member from Scarborough-Guildwood goes a long way to that goal as well, of being an international leader with respect to transparency, with respect to ethical conduct. And oftentimes it isn't good enough just to be level, and I think in our case there is a real opportunity to lead, and it's one that should be seized both with respect to the initiatives that emanated from the G8 and with respect to the initiatives contained in the private member's bill C-474. Thank you.
Questions et commentaires.
Questions and comments. The honourable member for La Salle-Mar. Thank you, Mr. Speaker. In its 2012 report, Transparency International mentioned the fact that active implementation was a good way to combat this type of corruption of foreign public officials. I'd like to ask my colleague, and we know also that it's the RCMP that has to do these investigations and report and so on. So I'd like to ask my colleague what he thinks of the fact that in budget after budget there have been cuts, not just to border services, but also to the RCMP. And I was wondering if he had anything to say about that.
Merci, Monsieur le Président.
Thank you, Mr. Speaker, and thanks to the member for that question. It's always the problem here when we constantly see budget cuts, and they are always cuts to services that are so important to the public. This is yet another example. You have to have the resources, you have to have enough resources to do such important work as in this area here. I think most of the time not enough consideration is given, and there aren't enough good ideas and enough effort made before those cuts are made.
Concerns expressed by my colleague from the NDP that all too often, with this single-minded focus on trying to balance the books as a result of the financial mess that we've been thrust into by this government, that we see very important frontline services, very important international obligations compromised because of some wrong-headed and misguided assessment of priorities, and absolutely share her concern in that regard.
Questions and comments. Questions et commentaires. The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I appreciate the speech from my honourable colleague from Charlottetown. I just wanted to raise again, it seems that we are increasingly seeing bills come before us in the House that properly should have begun in the House and then gone to the Senate. And I'm finding it strange. It's been raised before, but I'm wondering if my honourable colleague from Charlottetown can, having served much longer than I have in this place, shed light on how it is that we're seeing this increased number of bills that come from the Senate as opposed to originating where they should in the House.
The honourable member for Charlottetown.
Mr. Speaker, I have very high regard for the member from Saanich and Gulf Islands, but I need to commence with a correction. I have been in this House exactly the same amount of time as she, having been elected for the first time in May of 2011.
You're just so impressive in this.
And I guess because of that relative newness, I can't speak from a position of experience with regards to whether it's normal or whether it isn't normal for bills to be emanating from the Senate. In my view, this particular bill is something that has gone partway through the House, but was killed by prorogation. The fact that it is back before us is important. The House has had an opportunity to scrutinize it. It's fair comment that perhaps it's a troubling pattern that there are so many bills emanating from the Senate, but because this one is necessary, I don't think that we should be preoccupied by the manner in which it came before us. It's important to have it here, to get it done, to get Canada on an equal playing field with its allies internationally. Thank you.
Questions and comments? The honourable member for Saint-Hubert, Saint-Bruno, Saint-Hubert. Thank you, Mr. Speaker. First of all, I should point out that this is a Senate bill. In a report in 2011, Transparency International ranked Canada last among G7 countries when it came to foreign corruption. The organization pointed out that Canada had done little or nothing to implement anti-corruption legislation. My question for my colleague is the following. Does he think there have only been 3 convictions under Canadian legislation for foreign cases of corruption? Does he agree that this is a source of embarrassment for our country? The honourable member for Charlottetown.
Merci, Monsieur le Président.
Thank you, Mr. Speaker. If I understood the question correctly, it has to do with our world ranking under the rules on corruption. And, of course, we have to be somewhat concerned about that ranking. But that's why it's important to take the steps that are in this bill. So it's true, she's right, to be concerned about our ranking and our past record, but that's why we need to support this bill. Of course, it's not perfect. There are other improvements that could be made and are probably necessary, but this is a good start. Thank you, Mr. Speaker.
Before resuming debate, I understand there's an intervention by the Honourable Government House Leader on a point of privilege.
Thank you very much. I rise to respond briefly to last night's further intervention by the Honourable Member of Kingston and the Islands on the question of privilege related respecting Bill C-54, Not Criminally Responsible Reform Act. My intervention will be brief, and I hope it will be the final of many interventions on this point. On the report which was tabled on Thursday, the Honourable Parliamentary Secretary to the Minister of Canadian Heritage pointed out last night that the Honourable Minister of Justice had sought and did in fact receive unanimous consent to table that document. For example, page 433 of the House of Commons Procedure and Practice, second edition, at footnotes 111, 112, and 113, note several documents when documents have, with unanimous consent, been tabled in only one official language. Mr. Speaker, in the case currently before you, the Minister of Justice sought such unanimous consent to table the report for the very reason that it was produced in only one official language. Otherwise, he would not have had to seek such consent in the first place. The Minister did so in the fullness of transparency to provide members with the document as quickly as possible. Of course, once the translation is complete, the document will be tabled in the other official language as well. On the tabling of a Microsoft Word, quote, track changes, unquote, version of the document, it is my understanding that this was deliberately chosen as the means by which the House could most easily, readily, and quickly determine what had changed between the two versions of the report. Rather than the member opposite trying to ascribe the most nefarious possible motivation to the Minister tabling the track changes version, I would suggest that he instead consider the most plausible explanation that the Minister was actually trying simply to be as transparent as possible. What he did was to provide the House with an easy-to-reference version specifically highlighting the differences. For those not satisfied with that, he also provided the website address where a, quote, clean print, unquote, of the updated version of the report could be located. Mr. Speaker, it is important to bear in mind that the original version of the report, which I will note was marked as final by the author in November 2012, and with consent to release, as tabled with the response to order paper question 1169, was upwards of 200 pages in length, I understand, thus making the need for track changes or the benefit of track changes rather obvious. Mr. Speaker, on the matter of the response to order paper question 1169, I would refer you to what was asked in the order paper question itself. In paragraph A, the government was asked for certain information relied upon, quote, in developing this legislation, unquote. And that's a very, very important part of the question. The material that was provided in answer to that was the earlier version of the report. I'm left wondering how data received well after second reading debate started, that is the revised report, could be responsive to a question related to the development of the bill, which was the question on the order paper. Despite that, my colleague should be commended for noting in his response to that order paper question that a revised version of the report had been received. So not only was he responsive to the question, he was also transparent and open at the same time. Finally, Mr. Speaker, the honourable member for Kingston and the Islands offered some comments on a systemic remedy which he proposes. Despite his creativity, I disagree that there is a prima facie case of privilege to be found here. As such, I need not respond further to his suggestion on how to craft an order of reference to the procedure in House Affairs Committee. Thank you very much, Mr. Speaker.
I thank the Honourable Parliamentary Government House Leader and, of course, assure him that the Chair will be as expeditious as possible in responding with a ruling. Resuming debate, the Honourable Member for Vancouver East.
Well, thank you very much, Mr. Speaker. And I'm pleased to rise in the House today to speak to Bill S14, an act to amend the Corruption of Foreign Public Officials Act. And, of course, we're debating this at second reading, so it still has to go to committee. And I've listened with interest to the debate in the House today, and it appears that all parties will be supporting this bill, and of course we are debating it in principle, but nevertheless it is important for us to go through the bill, to examine it as we should all legislation, and of course then it will go to committee. I want to begin by saying, Mr. Speaker, that these last few weeks in the House have been particularly difficult because the government has used time allocation, a form of closure. I think we're up to time number 47 now, if I'm keeping the tab running correctly. So it's really quite incredible that so much legislation is being rushed through. To me, you know, we serve our constituents in this place. We do our work in the constituency, but our role in this House is due diligence in examining legislation and going through it. Even if we're going to support it, one has to go through it, and that's part of holding the government to account in our parliamentary democracy. So it is very disturbing that we see this pattern over and over again. It's become routine, and other colleagues in the House have commented on this earlier, that bills are now sort of just pro forma. We're expected to give a couple hours of debate, sort of a cursory look, and then there's a time allocation that going through committee, going through report stage, third reading, it's all established by timelines. That's not the way, Mr. Speaker, as you well know, it's not the way to do parliamentary business. So I wanted to begin my remarks with that because it's, you know, as someone who's been around here now a few years, I've watched the erosion of parliamentary and democratic practice in this House. And I can almost hear the voice of Bill Blakey in my head from Winnipeg, Transcona, who was sort of one of those folks in this place who had the long-term memory to know what had changed over the years. And when change happens incrementally, just a little snippet at a time, it's difficult to get that overview. And I think it would be useful one day to have that overview and to actually look at how much certain practices have changed in the House, say 10 years ago, 20 years ago. I think we'd all be quite shocked, actually, no matter what party we belong to. So anyway, here we are debating this particular bill. And I want to begin by saying, as others have remarked today, that this bill is so long overdue. I mean, Canada has really an embarrassing record on corruption overseas in terms of lack of legislation, and as many have pointed out today, Transparency International, which is a very credible organization who monitors corruption and bribery in terms of what happens in different places in the world, in their report in 2011, they ranked Canada as the worst of all the G7 countries with regards to international bribery. And they pointed out that we had little or no enforcement based on the very minimal legislation that we had. So no question that this is absolutely long overdue. And of course, it does beg the question, why does it take so long? You know, you look at the legislative agenda and you look at all of the little boutique bills that come through on the criminal code when they don't need to happen. And then something as major as this that does deal with crime and corruption, you know, why has it taken so many years for anything to come forward? Where's the balance here? Where's the priorities? We're sort of pulling apart the criminal code clause by clause and adding in more minimum mandatory sentences. We've had so many conservative backbencher bills, and yet something as major as this, in terms of Canada's role in the international community, where we're hauled on the carpet by an organization that monitors international bribery and corruption, they're saying, you guys have got a pretty bad record. In fact, you're basically the worst of all of the highly industrialized countries. So, Mr. Speaker, this is an embarrassment. And to add further to that, there's only been 3 convictions in the last number of years, in fact, since 1999, and 2 of those were in the last 2 years. So this is a pretty appalling record. So, Mr. Speaker, suffice it to say, I'm glad at least that we are debating this bill today. At least it is taking some steps. And to just focus for a moment on what this bill will do, for those who are watching the debate, there are 4 main changes to the Corruption of Foreign Public Officials Act. One of them will be to increase the maximum sentence of imprisonment applicable to the offence of bribing a foreign public official from 5 to 14 years. So that's a fairly significant change. Secondly, the bill will eliminate an exception that had been in operation for what's called facilitation payments, where a foreign official is paid to expedite the execution of their responsibilities. And I'm going to come back to this, Mr. Speaker, because there are some concerns about this, and while we agree that this exception should be eliminated, we do have to examine the impact of that on, for example, NGOs that are operating in extremely difficult circumstances in political environments that are very, very risky, where they do have to provide payments to get essential emergency humanitarian goods through, like going through police checkpoints, for example. And so one does have to find that balance. Thirdly, the bill does create a new offence for falsifying or concealing books or records in order to bribe or conceal bribery of a foreign official. So this is a very important change in terms of ensuring that transparency goes right the way down the line. And then finally, the bill establishes a nationality jurisdiction that would apply to all of the offences under the Act. And what this means, Mr. Speaker, is that Canadian nationals could be prosecuted for offences that are committed overseas. So again, that's a very important measure. I do want to say very clearly that New Democrats have long supported clear rules that require transparency and accountability by both Canadian individuals and corporations overseas. And in fact, the NDP has had a number of bills in this regard. One of my colleagues, the member for Burnaby New Westminster, has had Bill C-323 that would allow lawsuits in Canadian courts by non-Canadians for violations of international obligations. And the member from Ottawa Centre has had a Bill C-486 that would require public due diligence by companies using minerals for the Great Lakes region of Africa. Now, these are very important issues for Canadians, because we know that the extraction industry in Canada and the way it operates overseas is you know, it's a major business concern, and the way that those companies do business is something that's of great concern to Canadians in terms of ethical practices. And we've seen many movements here in Canada, many NGOs, the labour movement, individual citizens who have made sure that they became active on this issue. And I do want to point out that a bill that we voted on not that long ago, Bill C-300, it was actually a Liberal member's bill. And I raised this earlier when I raised in the debate about transparency, the Liberal member who replied to me from Charlottetown pointed to this bill, C-300, as another attempt to bring about better transparency and corporate accountability in foreign practices. What's really interesting about that bill, though, Mr. Speaker, I'm sure there are many members here who will remember that bill, is that the bill was defeated. And it was defeated in part because 13 Liberal members voted against it. I remember the bill when it came up. There was intense advocacy for the bill from major NGOs across the country. They did an incredible job. The bill itself, I think, was very reasonable. It laid out basic standards for practice. But of course, there was a lobby against the bill, and it was really quite shocking that the 13 Liberal members who voted against the bill resulted in the bill being defeated by a mere 6 votes. So we actually did come close to having that bill go through the House of Commons, and I know many of the organizations and individuals who had supported the bill were quite shocked that it had been defeated and were hugely disappointed that the amount of energy and time and effort that had gone into this. And to me, it was a wonderful example of how Canadians look beyond their own border, who looked globally to see what it is that Canada is doing. And they had paid great attention to the need for Canadian corporations and companies and businesses to be accountable, to engage in ethical practices, and to ensure that there isn't bribery and exploitative practices taking place in terms of labour rights, the environment. I mean, these are things that Canadians actually are very concerned about, and I always feel very inspired when I see organizations and people, whether they're putting out petitions, whether they're sending us emails. People really care about what we do in other parts of the world. We care about whether or not people are being exploited. I mean, my colleague from Ottawa Centre just a little while ago talked about the situation in Bangladesh. I saw the story too last night on CBC, and it's gut-wrenching, and it makes you want to jump up and say, what do we have to do to make sure that these kinds of terrible, appalling conditions no longer exist? I mean, we're talking about thousands of people who lose their lives because they work in terrible conditions, where safety is disregarded, where people aren't paid decent wages, and then you layer on top of that all of the bribery and corruption that goes on. I mean, this is I guess a multi-billion-dollar business in terms of corruption and unethical practices. Now, this bill before us, I don't think the bill is going to address all of that, and so the other bills that we have before the House, particularly from the NDP members that I mentioned, they are critical to ensuring that there is a comprehensive approach to the way that we're dealing with this situation. Mr. Speaker, in looking at this bill, we do have some concerns about it, which I'd like to put on the record. Assuming that the bill does get referred to committee, because the bill does amend the definition of a business to now include not-for-profit organizations, we believe that this should be studied very closely at committee, and obviously witnesses need to be brought in to look at the impact on this particular change on charitable and aid organizations. Because as I mentioned earlier, the reality is that those organizations do sometimes, out of sheer necessity, have to make payments in order to expedite or achieve delivery of very essential items and humanitarian goods. this is something that is out there in the real world. Now, this bill is really tackling corruption and bribery from the point of view that money is being made and money being put in people's pockets, and officials at embassies and so on are being bribed. That's what we're trying to get at. So I think we have to be very careful that we don't, by a consequence, lay down a rule that could actually have a negative impact on organizations that are legitimately and in good faith trying to do very important work in some of these areas globally where there is political and military and civil conflict going on, and to make sure that that kind of aid is delivered in a proper way is very, very important. So we're hoping that this issue will be examined more closely at committee, Mr. Speaker. The second item that we think needs further examination is that the committee should also study the consequences of establishing an indictable offence punishable by up to 14 years in prison, because once you reach 14 years, this is actually the threshold at which conditional or absolute discharges or conditional sentences become impossible. So it's obviously a much more serious penalty, and I think that the committee, when it receives this bill, should examine that very carefully to make sure that there is a balance in terms of our judicial system and conditional sentencing or the question of absolute discharges. You know, it's easy to make kind of a blanket case, and again, we've seen that so often with this Conservative government. They tend to make harsh blanket rules that don't allow for discretion within our court system. And our court system has a history and a tradition of allowing judicial discretion so that judges can actually examine individual cases and the circumstances that warrant a harsher or a more lenient approach. That's what balance in a judicial system is about. So I think one has to be very careful that in bringing forward new legislation, we don't tip over that balance and make or create a system that becomes so rigid that it actually becomes counterproductive, in that because the penalty is so harsh that then people end up pleading not guilty more frequently, or even prosecutors may be more reluctant to bring forward charges. So there can be unintended consequences of having penalties that are so harsh. So this is an issue that we think should be looked at in the bill. We support, in principle, the penalty being increased, the sentencing threshold being increased, but I think we have to look more carefully at whether 14 years is the right cutoff. And finally, Mr. Speaker, in terms of changes that we think do need to be looked at, we want to look at the question whether the rule on the facilitation payments that I spoke about earlier, whether or not it needs, once we figured out how it impacts NGOs and nonprofits, then there's an issue as to why in this bill it wouldn't be part of royal assent. It would rather be under the consideration of Cabinet. That's what's in the current text, Mr. Speaker. So that one aspect of the bill, if this bill were passed as it is, basically, it wouldn't go ahead with the rest of the bill. So I do think that has to be examined. We need to know the reasons for that. Why is that being put aside? And maybe the discussion on the facilitation payments as it impacts NGOs might help inform that debate. But it is something that we need to look at. Mr. Speaker, I do also want to talk briefly about more current situations. We heard today from the member from Ottawa Centre who updated the House on a communique that he had received from the G8 that's currently taking place. And it was quite interesting because he pointed out to us all that in this communique, the issue of corruption and transparency was actually quite prominent in the communique. And his point was that we need to know that our own government is committed to not just the words that are in these communiques, but we're actually going to follow up. And I thought he used a very good example where he spoke about international treaties that we sign, but there's no follow-up. And in fact, the example that he used was Bill S-10 that was rushed through this House just a few days ago. I was one of the people who spoke on that bill to do with cluster munitions. And he pointed out very clearly in the debate in that bill that many of us, well, all of us in the NDP, we believe that the bill, S-10, actually undermined the very international treaty that it was meant to be following up. And so the point here is that when these communiques come out and when these commitments are made in places like the G8, we need to know that they're actually going to be followed up. We need to know that those commitments actually mean something. And again, we get back to this particular bill that has taken so long to come forward, S-14. Why does it take so long? Why isn't there a greater priority and emphasis on these kinds of bills? In the G8 communique, some of the issues that were flagged was the need to have greater transparency, the need to have a public registry. And the member from Ottawa Centre told us that one of the proposals is that there needs to be a regime whereby companies won't be able to set up a shell company. So that even if you have good legislation, if you can't enforce it, well, possibly because there's a lack of political will, because I've just spoken about, but secondly, because then trying to figure out who actually owns, who are the operatives in a particular company, if there is enforcement to be taken on issues of bribery and corruption, then it makes enforcement very difficult. So I think the idea of a public registry, the idea that we need much better transparency, and the notion that we shouldn't allow elaborate legal complexities to set up shell companies that in effect allow people, individuals and operatives to hide behind other entities that make it much more difficult to figure out who's doing what and where enforcement should be applied. So I think that's a very significant issue. Now, of course, Mr. Speaker, it's not covered in this bill, so it does show us that this bill doesn't go far enough, and I think that was the member's point this morning. Nevertheless, we are supporting this bill at second reading. We will pay great attention to it in committee, and we will seek to improve the bill so that it lives up to its spirit and intent, and that is ensuring that we tackle bribery and corruption by public officials in other countries. Thank you, Mr. Speaker.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Foreign Affairs.
Thank you, Mr. Speaker. Of course, I was with quite interest to understand that the NDP is going to be supporting this bill. I mean, to get an NDP to support any bill which deals with trade, the growth of trade, with the growth of businesses, considering their opposition to all trade deals, is quite welcomed by this government. However, we notice also that they always have, as usual, their caveats for everything. What is important here, Mr. Speaker, is that this is a bill that is going to make Canadian companies accountable. And talking about public registry, they're talking about, Mr. Speaker, whenever a Canadian company is held accountable and it becomes a public issue, it is a message to all other Canadian companies that the government is very serious, Canadians are very serious about transparency. Speaker, that by itself, that publicity will ensure that businesses comply with this legislation. So we are thankful that we are okay that the NDP is supporting it, but I can say to her, to the honourable colleague, that as you already three convictions have happened, and this whole publicity will ensure, as I've stated, that Canadian companies will comply with transparency as expected by all Canadians. Thank you.
The Honourable Member for Vancouver East.
Well, thank you, Mr. Speaker, and I listened to my colleague with interest, and I guess I'm a little bit surprised that he thinks that three 3 convictions is a good track record, over 5 years. I mean, surely Canada can do better than that. I would say that that's a bit shameful, actually, to have such a minimal response from the Canadian government. I would like to respond to my colleague, though, by suggesting to him that what we heard today about the G8 communique, which likely he has seen because of the role that he has, that we do need to have a commitment from this, from our federal government, that they're going to live up to these international treaties, and that there is going to be follow-through, whether it's on this bill or whether it's on cluster munitions or whether it's on trade practices or matters affecting human rights. I mean, the follow-through is so important, and I don't get that sense. He talks about accountability. He talks about that this bill will send a message, but if you don't follow it up with the proper enforcement and the transparency, then really it's not worth the paper it's written on. So 3 convictions isn't quite good enough, Mr. Speaker.
Questions and comments? The Honourable Member from Hamilton East, Stony Creek.
Well, thank you, Mr. Speaker. And to the member from Vancouver East, her speech was what we would almost say across the board. She's covered so many topics. But when she started her speech, she spoke of the fact that there's been so many time allocations in this House, and that our debate's been limited to 47 times, I believe she said. What I find very troubling when you come here, the idea of this place and of committee is to take any bill that's put forward by anybody, being private members or the government or the Senate, and we work together to try to make it better. And yet when we get into debates here, we find oftentimes that the government's not even engaging us. They're not even, they ask the odd question, but they're not getting up, giving speeches, putting the point of view, working back and forth on this bill like we could have been. But in her remarks towards the end, she talked about NGOs that bring supplies, to places like refugees from Syria might be an example, where you come into a country and you've got to pay a gratuity, a tip, or a bribe, whatever you call it, to get those goods off of the ship and ashore. That's a reality in the world. That's not something that's high level. Do you think that people will be sideswiped by that unintentionally?
Presume the member wasn't asking me the question, but rather his colleague, the Honourable Member for Vancouver East.
I hope he wasn't asking you the question, Mr. Speaker, and I'd be happy to reply to him. I think that this is a very important point that the member has made, and something that I focused on in my remarks, and that is we have to make sure that there aren't unintended consequences for organizations that are absolutely trying to do the right thing by getting critical aid and humanitarian assistance to people who are literally dying or in severe conflict. And if this bill kind of came down with a heavy hand and sort of zeroed in on what's called facilitation payments on the basis that somehow that's bribery or corruption, I think we would be going down the wrong path. So I think the member makes a very good point, and it's something that we share in terms of, again, understanding what enforcement will mean under this bill and getting it right.
Questions and comments? The Honourable Member for Renfrew, Nipissing, Pembroke.
Speaker, and the member opposite spoke very well, and I'm pleased that her party supports this legislation. But I am concerned about this contradiction wherein companies are forbidden to pay bribes to officials, but NGOs should be allowed to pay bribes to police at checkpoints where they do the shakedowns. Police are supposed to uphold the rules of law, and some of the NGOs are actually tasked with the job of introducing, implementing, helping out with democratic principles in these countries. So having the law on the side of the travelers, wherein they're not allowed to pay bribes, can actually help act as a shield. Letting the employer, the government, get away without paying proper wages, that's not our role. So how can the NDP support letting the employers of these police getting away without paying the proper wages?
The Honourable Member for Vancouver East.
Okay, well, Mr. Speaker, I'm not sure if I completely understand the member's point, or maybe she misunderstood my point. My point was that we want to make sure that NGOs and non-profits who are delivering very important aid don't get nailed and prosecuted when they're actually just doing their job. And I certainly agree that we need to focus on officials who are doing the bribery. And we do need to make sure that people are getting paid properly. I mean, the NDP has a long track record of saying that when we engage in trade deals and various international treaties, what needs to be at the top of the list, ensuring that we have proper labor conditions, safety, human rights. I mean, we're now seeing more and more situations around the world, the most recent in Bangladesh. We see the human misery and tragedy of what happens when there aren't proper standards for corporations to act by, and they can literally get away with murder. So, I mean, we're the ones who have been, I guess, blowing the whistle on that for years and saying this is completely unacceptable and can't continue.
Questions and comments? The Honourable Member for Burnaby Douglas.
Thank you, Mr. Speaker. I had a very interesting conversation last night with our colleague from Windsor, who sits in your chair occasionally, and we were talking about the evolution of the Speaker's position, how it's changed over time, and I can't help but notice that it seems to be almost all the bills that we've been debating over the last week or so are from the Senate, and I would like to ask my colleague, who's been here a long time and has great experience in these matters, if she's noticed a change over her tenure here in the House, that perhaps where the government should be bringing forward bills here in the House, they seem to be bringing forward bills that are partisan bills through the Senate or through private members' business. And I'm just wondering if she'd care to comment on that and perhaps the dangers of going that route. Thank you, Mr. Speaker.
The Honourable Member for Vancouver East.
Well, Mr. Speaker, I thank my colleague for raising this, and there's been a very dramatic shift in this place, and I tried to outline that at the beginning of my remarks to, we need to in some ways account for that and to look at it, but certainly in the last, 3 weeks since we've had these midnight sittings, the number of bills that have come through from the Senate I don't think I've ever seen so many at one time. And really, we've had no explanation from the government as to why this is happening. I'd be fascinated to hear what the speakers think about it, but I'm sure that they're probably not allowed to give their thoughts on this matter. But, this is, one has to ask why the government itself is not introducing its own legislation here in the House of Commons. To me, it diminishes the role of the House of Commons. It diminishes the role of members who are elected to come to this place. By introducing legislation in the Senate, which itself is mired in scandal and corruption, people who are not elected, who are not accountable, to begin the process there and then say, oh, well, we kind of have to go back to the House of Commons, I mean, the proper way to do this is to have legislation in the House of Commons. That's our primary responsibility, is to debate and examine legislation and to represent our constituents. So, maybe we need to talk about these things more and keep bringing them up so Canadians can understand how much has changed under this Conservative government.
Resuming debate, the Honourable Member for Beaches, East York.
Thank you very much, Mr. Speaker, and thank you to my colleague from Vancouver East for the benefit of her years of experience in this House to be able to talk about those issues. I need to let you know, Mr. Speaker, I'll be splitting my time with my friend from Chicoutimi-Le-Fjord. Mr. Speaker, I rise today in the House to support Bill S-14, an act to amend the Corruption of Foreign Public Officials Act. And I do so because, well, for a number of reasons. The bill itself is making four main changes to the Corruption of Foreign Public Officials Act. I'll enumerate these and elaborate on them a bit, Mr. Speaker. It increases the maximum sentence of imprisonment applicable to the offense of bribing a foreign public official from 5 to 14 years. It eliminates an exception for the so-called facilitation payments where a foreign official is paid to expedite the execution of their responsibilities. It creates a new offense for falsifying or concealing books or records in order to bribe or conceal bribery of a foreign official. And it establishes nationality jurisdiction that would apply to all the offenses under the Act, such that Canadian nationals could be prosecuted for offenses committed overseas. Now, Having noted my support for the bill, Mr. Speaker, I do want to take a moment to comment on the process by which this bill comes before us in this House. It is of concern, Mr. Speaker, that we get to this place by way of a 2011 report from Transparency International, and that organization ranked Canada as the worst of all G7 countries with regards to international bribery, with, quote, little or no enforcement, end quote, of the scant legislation that exists in this country on these matters. And this is to say, Mr. Speaker, that we, Canada, needed to be named and shamed publicly, internationally, for our lax legislation and approach to these issues of corrupting public officials in other countries. I also want to comment on the timing of this, and this is a curious pathology of this government, Mr. Speaker. They've been in power through minority and now majority government since 2006. And it seems to elude them that they've been here 7 years, and that, in fact, all that they do now, Mr. Speaker, they've been in power so long, is really an indictment of their own conduct as a government. Implicit in this kind of legislation here, Mr. Speaker, is an indictment of what they have failed to do over the previous 7 years in government. And I note that the parliamentary secretary earlier today justified this particular bill, S-14, on the basis of the fact that we're a trading nation. Well, Mr. Speaker, we were a trading nation in 2006 when they came to power as well. And in fact, we've always been a trading nation. We've always been a very open economy, Mr. Speaker, with goods coming and going to and from this country to other places around the world. And so when did dawn rise over Marblehead, Mr. Speaker, so that this government realizes that we've always been a trading nation? The issues that this bill is meant to address existed in 2006 just as well as they existed in 2013. And it seemed to have taken a series of really national embarrassments, largely in the extractive industry, Mr. Speaker, to get this government to recognize that they needed some legislation such as the act that we have before us. But it's still not clear, Mr. Speaker, after all of this, that they embrace this legislation. We had before in this House C-300, Mr. Speaker, and that was a bill that would have required extractive companies receiving government support to meet certain standards, as well as establishing a system for issuing and assessing complaints against such companies. And this government saw fit, Mr. Speaker, to whip that vote and defeat that legislation. And we had as well, Mr. Speaker, the spectacle of the Foreign Affairs Minister introducing Canadian firms to the transition government in Libya before the United Nations could even assess the needs of a post-conflict Libya. And among the companies that, according to media reports, that our Minister of Foreign Affairs took to Libya was, in fact, SNC-Lavalin, Mr. Speaker. I mean, this is a company who's having contracts investigated in 10 different countries. It's a company that's been banned from bidding on World Bank projects for 10 years. And this is a government that only very recently saw fit to take SNC-Lavalin back into Libya to introduce them to a transition government. And we know, too, Mr. Speaker, that to date there have only been 3 convictions on these matters. And I would cite, since 1999, I'd cite the HydroClean Group was being fined for $25,000 in January 2005. Nico Resources Limited was fined in 2011. Because its subsidiary in Bangladesh had paid for vehicle and travel expenses for a former Bangladeshi state minister. Griffiths Energy International was fined for $10 million in January 2013. after it agreed to pay a $2 million bribe to the wife of Chad's ambassador to Canada, and so on, Mr. Speaker. But that's only 3 convictions since 1999. And all of this seeming reluctance, Mr. Speaker, on behalf of this government to bring forth legislation like this, I think is confirmed by the source of this bill, and that's the Senate. This, Mr. Speaker, the Senate I'm referring to, is an institution with an enormous legitimacy deficit.
Order the honourable member for Burlington is rising on point of order.
Thank you, Mr. Speaker. Mr. Speaker, there's consultations among the parties, and I believe it is possible that you could find unanimous consent for the following motion: that Bill S-15, an act to amend the Canada National Parks Act and the Canada-Nova Scotia Offshore Petroleum Resources Accord Implementation Act, and to make consequential amendments to the Canada Shipping Act 2001, be taken up at the report stage later today.
The members have heard. Does the honourable member have unanimous consent to propose the motion? Yes. The members have heard the terms of the motion. Does the honourable member have unanimous support for the motion? Yes. Agreed. And so ordered. Resuming debate. Order. Resuming debate. The honourable member for Beaches East York.
Thank you, Mr. Speaker. I was just in the process of commenting on the source of this legislation being the Senate and the enormous legitimacy deficit that exists in the Senate. I think that's historical, but it is particularly acute these days. And in particular, the Senate really is in no position to be issuing bills on the issue of corruption, mired as it is, Mr. Speaker, in scandals of exactly that nature. But having said all that, irrespective of the source, and as unfortunate as the source of this legislation is, we remain prepared to support the bill, Mr. Speaker. And one of the central reasons for doing this, Mr. Speaker, is found in the legislative history of members of this party in this House. We have long supported clear rules requiring transparency and accountability by Canadian individuals and corporations overseas. And this bill, in fact, complements legislative efforts by NDP MPs to encourage responsible, sustainable, and transparent management practices. And I speak specifically, Mr. Speaker, of bills put forward by the member for Burnaby New Westminster, C-323, that allows lawsuits in Canadian courts by non-Canadians for violations of international obligations, and also C-486, Mr. Speaker, from the member for Ottawa Centre, that requires public due diligence by companies using minerals from the Great Lakes region of Africa. These bills reflect the history of our party. It reflects a respect for the democratic aspirations of people in other countries, a respect for their aspirations for better labor standards, for a healthier and safer environment. Mr. Speaker, we understand that effective environmental and labor standards in developing countries often depend on advocacy and activism by local populations. And it's very difficult for local people to hold their governments to account when the government has secret sources of revenue that remove the financial incentive to be accountable in the first place. And we support this bill as well, Mr. Speaker, because the lack of anti-bribery enforcement in Canada has been a national embarrassment to us. How much more time do I have, Mr. Speaker? Less than a minute. Okay. Well, I will skip to my conclusion on this point, Mr. Speaker, of the national embarrassment of the lack of legislation. It is worth, I think, pointing out, in spite of our support for this bill, that this bill is in effect totally underwhelming. One is left asking, is that all there is? When the parliamentary secretary points to the openness of our country to international trade, and offers forward this legislation as the solution to dealing with corruption issues in such an open and global environment. When Canadians take such pride and value so highly our reputation in the international scene, the question rises, why does this government always seem to aim so low, Mr. Speaker? Why can't this government, in fact, aspire to a leadership role, one that I think Canadians could justly take pride in? If it is worth putting forward such legislation, and we certainly believe it is, why not set new and higher standards internationally, Mr. Speaker, to ensure that Canadians overseas conduct their affairs to the highest levels of transparency and ethics? Thank you, Mr. Speaker.
Questions and comments. Honourable Parliamentary Secretary to the Minister of Foreign Affairs.
Thank you, Mr. Speaker. Mr. Speaker, I listen with interest to the honourable member's response to this bill, although they are supporting this bill. First, I want to tell him quite clearly that this government has provided a very strong leadership, not also to the around the world, but also in Canada, Mr. Speaker. And at every given time, it's the NDP that opposes it. Matter of fact, in his speech, he talked about that Canada should be named and shamed internationally. Mr. Speaker, their record is their leader and themselves go overseas, and they take no shame in condemning Canada, Mr. Speaker. What a pity! What kind of a official opposition is there that goes overseas to condemn Canada? And most importantly, Mr. Speaker, when I raised the question that 3 companies had been convicted, I got a very strong laughter from the other side of what they're talking about. Let me remind them, Mr. Speaker, they may think Canadian companies are corrupt. They may think Canadian companies are bad. Let me tell them we have full confidence that Canadian companies are doing very well, and the less convictions we have about bribery speaks very well for Canada, not for them to laugh at these things, Mr. Speaker. Thank you.
The honourable member for Beaches East York.
Well, Mr. Speaker, I wish the parliamentary secretary across the way had listened a little more carefully to my speech, because my point was, in fact, quite the opposite, that this is not the NDP arguing that we should be named and shamed. It is with regret, in fact, that we note that this legislation only comes forward, Mr. Speaker, in response to a public report by a credible international organization that notes our lax legislation on these issues and the need for Canada to bring itself up to speed with what the rest of the world is doing. And in fact, this legislation only brings us, in fact, up to kind of par with the rest of the world, in line with the practices of 36 of 39 other OECD countries. Mr. Speaker, with respect to Canadian corporations overseas, by no means is the NDP condemning Canadian corporate conduct overseas. But, Mr. Speaker, what we know that Canadian corporations require and look forward to is a consistent set of standards and consistent enforcement, so that all corporations around the world can be sure that they're playing on a level playing field. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Winnipeg North.
Mr. Speaker, you know, one of the greatest hindrances around the world in many countries is the issue of corruption. And until they're able to deal with that issue, economic prosperity tends to elude them. And this is most unfortunate. And this is when, in fact, you want to see countries around the world, such as Canada, play a strong leadership role. That's why we have the United Nations Convention Against Corruption. It's a unified grouping of countries that have taken an approach that the best way to try to deal with corruption is for countries like Canada to be more aggressive and play a progressive role in combating corporate corruption, to try to prevent the corruption of public services around the world, in particular in countries where there's a real need, Mr. Speaker. And there are a number of countries that have really been taken advantage of or exploited. I've had students in Winnipeg North that I've met with that have even identified this as an important issue in a high school setting, Mr. Speaker. My question to the member is, to what degree do you feel that the government could in fact be doing so much more, that they've had opportunities such as private members' bills to actually act earlier, but they've chosen not to?
Once again, I presume the member is not asking the chair the question, but in fact would like it redirected to his colleague, the honourable member for Beaches East York.
Well, thank you, Mr. Speaker. I would suggest to the member who asked the question that it's not just prosperity that doesn't get shared in response to corruption around the world, but as I said in my speech, it goes beyond the material needs of people that don't get met. It goes to the democratic aspirations of people and their desire to live and choose the environmental standards that they want to live in. It goes to fundamental issues of health and safety in the workplaces in which they work and the prospects, in fact, Mr. Speaker, of coming home at night after a long day's work. And I hope that I made it clear that there are higher standards around the world in terms of transparency on these matters that Canada could adhere to, and in fact Canada could in fact aspire to even greater standards if this government were so willing, but they seem in fact quite reluctant, Mr. Speaker, to even do the minimum. Thank you.
Resuming debate, the honourable member for Chicoutimi-the-Fjord. Thank you very much, Mr. Speaker. Thank you, colleagues. It's a pleasure for me to speak to Bill S-14, an act to amend the Corruption of Foreign Public Officials Act. First of all, I'd like to explain to those listening at home what this bill's all about. S-14. It makes 4 major changes to the Corruption of Foreign Public Officials Act. First of all, it increases the maximum sentence of imprisonment applicable to the offense of bribing a foreign public official. It also eliminates the facilitation payments exception to that offense. In other words, when a foreign official is paid to do their job. Third change, creating a new offense relating to books and records and the bribing of foreign public officials or the hiding of that bribery. And finally, the last change, major change, establish nationality jurisdiction that would apply to all of the offenses under the Act, so that Canadian nationals could be prosecuted for offenses committed abroad. This is a very important anti-corruption bill. Even though the Conservatives who've taken the floor seem to have taken the side of companies that unfortunately engage in corrupt activities. They think they're above the law. They think they can engage in corrupt activities outside Canada, but unfortunately the NDP will be there to watch them and ensure that they pay for their crimes. We will support this bill at third reading. We were a bit disappointed at committee that the committee didn't pay heed to what we were saying. They didn't agree with our suggestions. They think everything they do is perfect. The NDP for a long time has been in favor of clear rules requiring Canadians and Canadian companies abroad to be transparent and accountable. This bill is in addition to legislation put forward by the NDP to promote responsible, sustainable, and transparent management practices. These corruption cases are an embarrassment to Canada. It's not surprising. We're dealing with a government that has its own problems with ethics and corruption. So it's not surprising that on the Conservatives' watch and on the watch of the current Prime Minister, our country has tended towards corruption. The NDP is pleased that the government is finally dealing with this issue, and we're disappointed that it took so long for Canada to be, the government waited for Canada to be criticized and singled out before taking action. And we've been condemned by our international allies on this score. The expectation is that Canada will act responsibly and accountably and will meet clear standards for international business. This will create a level playing field for all businesses while at the same time protecting the environment, labor, and so on. This is something that we can all be proud of. In 2011, Transparency International ranked Canada last among G7 countries when it came to corruption abroad. That's what I was mentioning before, the condemnation coming from our international allies. Transparency International pointed out that Canada was doing little or nothing to implement anti-corruption laws. Since then, our government has begun to try to deal with this source of embarrassment for our country, but there have only been 3 convictions since 1999, 2 of those in recent years. Mr. Speaker, this bill is particularly important for mining. The NDP has always been a fervent champion of accountability. For example, there's C-323 from the member for Burnaby New Westminster that would authorize people who are not Canadian citizens to bring prosecutions based on the violation of international obligations. And Bill C-486 from the member for Ottawa Centre, which would require mining companies in the Great Lakes area of Africa to exercise due diligence. So you can see that the NDP defends those abroad. The NDP is on the side of justice, so any company is expected to live up to high standards. We're disappointed when Canadian companies engage in corruption. Mr. Speaker, those who benefit from corruption in other countries are mainly men, and we can't just assume that even Canadians and Canadian companies are doing the right thing. We need to have things in place to ensure checks and balances to make sure that people are complying with international law. And the flip side is that it's women who often suffer, who go unprotected. And that's why the NDP is proud that that women across the country confide in us. That's why we always reach out to women. It's a principle of equality, unlike other companies who might prefer to see women remain minorities within their parties. I'll continue, Mr. Speaker, by talking about some numbers that might be of interest to people at home. Earlier, I mentioned that there were 3 convictions for corruption. I'm going to say a bit more about that. Since the Canadian legislation came into force on the corruption of foreign public officials in 1999, there have been 3 convictions. There was the Hydroclean Group that got a $25,000 fine in 2005 for corrupting American customs officials at the Calgary airport. Another company got a $9 million fine in July 2011 because in Bangladesh, money was paid to the Bangladeshi Natural Resources Minister, a bribe. And then Energy International got a $10.3 million fine in January 2013 after paying $2 million to the wife of the ambassador of Chad. And this was for discount shares in an oil project in Chad. This is something that we have condemned, but we have to continue to catch companies who are doing this type of thing. It tarnishes our international reputation, and it has to stop. For 2011, Transparency International ranked oil and gas and mining as the 4th and 5th top industries likely to engage in corruption abroad. S14 is thus particularly important. Mr. Speaker, can you tell me how much time I have left? 1 minute? Okay, I'll sum up by saying that unlike the Conservatives, the NDP listens to the public. When the Foreign Affairs Minister tells us that Canadian companies want clear standards, we listen. We want an equal playing field for all companies. In addition, the NDP is listening to environmental and labor groups who want local populations not to be abused when there is any development. Internationally, we want Canadian companies to practice responsible practices. That's my speech. I ran out of time, Mr. Speaker, but I'm certainly open to any questions from my colleagues. Questions and comments? The Honourable Member.
Thank you, Mr. Speaker. And I listened with great interest in my colleague's presentation. A couple of questions for him to consider. I'm kind of wondering if he's aware of all these people that are in the corruption game and doing bad things. Why isn't that reported to the police and then the officials can take the desirable action? I also wonder when he says that all this corruption is taking place in foreign countries. I wonder who made us government of foreign countries that we're going to clear up all this corruption that happens wherever it happens. I think that the NDP showed where they stood with Canada as far as growth of Canada, and there wasn't any corruption. It was a trip to the U.S. to convince them not to be involved in engaging in Canada as a working nation, which I found difficult to understand. But I guess when it comes right down to it, Mr. Chair, I'm really wondering what this three. I'm looking at the word here, convictions, of only 3 convictions since 1999. I'm wondering if the honourable member thinks we'll just gather up some buddies and go get some guys and get some convictions today because it's conviction day in the old corral. I mean, it doesn't work.
Order.
The honourable member for Chicoutimi the Fjord. Mr. Speaker, I find my Conservative colleague's attitude very disappointing. It seems he's not taking Canadian companies' corruption abroad very seriously. He says, what are we supposed to do? Just be sheriffs running around overseas? It seems to me that Canadian companies that are under Canadian jurisdiction but are misbehaving abroad, well, we have to roll up our sleeves. We have to act seriously to protect people in other countries against Canadian companies that misbehave. The idea here is to enforce the law. Those who've done nothing wrong have nothing to be faulted for. But when Canadian companies are corrupt, the Conservative government should not be washing its hands of the situation. Maybe they're doing something, but I'm not so sure.
Was put forward by the Conservative member. He tends to give the impression that Canada has no role to play in terms of combating corruption of public servants beyond Canada's borders. And nothing could be further from the truth, Mr. Speaker. At the end of the day, there's not only a legal, but many would ultimately argue a moral responsibility for Canada to do what it can to combat corruption, Mr. Speaker. And you know, at the end of the day, or once it's all said and done, we would like to think that we should be following the advice of the United Nations Convention Against Corruption. That's one of the reasons why we brought in legislation during the 90s and enacted on it, Mr. Speaker, I believe in 99 when Jean Chrétien was the Prime Minister. And we have seen private members' bills, whether they're New Democrats or Liberal private members' bills that have been brought forward to try to deal with this issue. And the question for the member is, does the member not agree that we could be doing a whole lot more in terms of providing leadership on this particular issue?
L'honorable député de Chicoutimi-Le Fjord.
the honourable member. I would like to thank my Liberal colleague who is looking for my support to see if Canada can do better. Yes, Bill C-300 had been tabled, which would have forced extractive industries to respect certain standards and which would have to have a complaints mechanism. Unfortunately, we know that the government voted against this measure, but what people unfortunately do not know is that the Liberal Party, of which the member is a member, well, 13 of his colleagues voted against the bill, and therefore Bill C-300 was defeated by 6 votes. Canada can do better. The Liberals can do better by supporting NDP bills, which would strengthen this type of legislation. So let's just not talk. Let's walk the talk, Mr. Speaker. Resuming debate. The honourable member. Thank you, Mr. Speaker. I'm pleased to rise in the House today to speak to Bill S-14. S-14 is the Fighting Foreign Corruption Act. So what we're talking about is corruption and transparency. And I would like to point out that as a new Democratic member and proud representative of La Salle et Mar, this is an issue which is very important to my constituents. They want a government which is transparent and which is not corrupt, be it this government or any other government at any other level. All these governments, anyone, any elected representative, regardless of where, should be free of corruption. What is also ironic, and this point has already been made, is that this bill comes from the Senate when we all know that the Senate lacks transparency and ethics when it comes to corruption. When my Conservative colleagues rise in the House, they say that this issue and this bill are a priority. So my question with regard to this bill and any other bill which the government claims is a priority, why did this legislation not begin in the House? I'd also like not only to speak about the importance of the bill, but of the importance of the fact that I will share my time with the member for Saint-Bruno-Saint-Lambert. I should have said this at the very outset, Mr. Speaker, that it is a priority for me in this speech. Now, that being said, I'll continue. I would also like to mention that it's not the first time that this type of bill has been mentioned. In fact, in 1997, Canada signed a convention on the fight against corruption by public officials in international trade transactions. Canada ratified that convention in 1998. So this issue goes back quite a few years. Afterwards, there was the UN Convention Against Corruption. That went back to 2004, and it was ratified in 2007. So, again, we continued to move forward on this issue. Then, in 2008, Canada, the RCMP created a task force to fight international corruption or bribery. 2 7-people teams based respectively in Ottawa and Calgary set to work. So the mandate of that unit was to detect and prevent international corruption, including fraud and bribery. So prosecuting these activities befalls to the RCMP. So Canada for many years has been concerned with this matter, and Canadians as well. In March of 2011, Canada with regard to the Act on the Corruption of Foreign Officials, so Canada was part of a task force of the OECD to study this issue, and we signed an agreement. And within the agreement, the agreement stipulated that it would be reviewed every once in a while, which is always a good idea. So the task force recognized the work Canada made in contribution of the study. However, the OECD did put out some objections on the limits to the scope of our bill and the fact that there are not enough investigators hired to root out foreign fraud, and it was also reproached that the sanctions were not strong enough. Then the report contained a long list of recommendations. I won't go into them now because there are too many of them. However, I would like to go over some of the points which relate to the bill we are studying in the House right now. Now, in September of 2012, and others have mentioned this, Transparency International, which is an NGO, published its eighth annual report on the implementation of the OECD Convention, which I just talked about. What I'd like to point out here is that Transparency International has, as its chair, a Canadian. So this Canadian is the chair of the board. Now, what was said is that Canada was part of the group of moderates. And that's something I'd like to address here. So, this bill reflects the words of the convention, but despite the fact that it signed all of these conventions, Canada is simply moderately applying the convention, and Transparency International has said is that for this bill to really work, for these measures to really fight corruption, we need stronger legislation. So it seems that the members of the OECD task force feel that this bill is not strong enough. The report contains some interesting recommendations. It said that any accusations made should be absent of the territory and based more on the nationality of the accused. And in fact, that's quite... And in fact, this is reflected in the bill we are studying. So, the principle of nationality means that when a Canadian national is abroad, when a Canadian is abroad, and when the Canadian who is abroad engages in bribery of a public official, it triggers a legal process under the criminal code. And this whole system will be made much easier under this bill, so thus reflecting the recommendation contained in the OECD report, or rather the report by Transparency International. And so the bill will help implement legal processes to fight the bribery of foreign public officials. That said, and I talked about this earlier, whether you're working in Canada or abroad, you always have to meet very high ethical standards and very high standards of transparency. Because, as has already been said, it's very important for Canadian companies based in Canada, but which also operate abroad. These Canadian companies operating abroad have to be clean, otherwise they might taint Canada's image, Canada's brand, and this would affect Canada's economy. And it would also be bad for the sectors in which any type of corruption takes place. Further, Canada has to be a leader. We are a democratic country. We are a country with high ethical standards, as I said earlier. In other speeches, we have very high standards in many areas, be it in terms of our labor conditions, our living conditions, and so on and so forth. So it's really important that we keep on leading by example. We have to start at home and then do it abroad. And it's important that we always keep that uppermost in our minds. For a long time, New Democrats were in favor of clear rules governing Canadian businesses doing business abroad. Canadians want Canadian companies operating abroad to be responsible and to operate with respect. We want clear international trade rules. Thank you, Mr. Speaker. Questions and comments?
Thank my honourable colleague for her thoughtful speech, and where she underlines the importance of Canada playing a leading role on the international stage in terms of leading by example. And of course, we're mired in bad examples here in the House of Commons and in the Senate. And I'm wondering if my colleague would like to comment on the ways in which Canada needs to shift focus in order to play that leading role, in order to play a role of an important example to the world community about how good governance on the international stage is achieved.
The Honourable Member for La Salle-et-Mar. Thank you very much, Mr. Speaker, and I'd like to thank my colleague for his question. In fact, what we're realizing now is that often Canada stands in the way of process rather than being an active participant, be it with regard to the implementation of bills to fight corruption or bills to increase environmental standards here or abroad, or be it with regard to our fight against climate change, be it with regard to our participation, or rather be it with regard to our fight to ban bombs or anti-cluster munitions. All of these things call on Canada to play an active international role. All of these things call on Canada to be an active participant in building a better world.
It's the Honourable Parliamentary Secretary to the Minister of Health.
Thank you very much, Mr. Speaker. And I listened to my colleague's speech and some of the questions she was answering. And we talked a little bit about Canada taking a leadership role. And this government has been very forthright in moving forward around the world to negotiate trade agreements. And one of the important things when you're taking a leadership role, you want to make sure that when you're dealing with other countries that you set the bar fairly high so that the company or the countries you're doing business with have an idea of how Canada is going to operate. And we have taken a leadership role in that regard. And each and every time we try to negotiate these trade agreements, Mr. Speaker, except for once, the NDP has always voted against it. And what we have before us here is an excellent bill brought forward, S14, and one of the people that she quoted was Janice Keeping, the chair and president of Transparency International. And what Janice Keeping said, Transparency International Canada is delighted that the federal government is moving to strengthen the Corruption of Foreign Public Officials Act, the CFPOA, in accordance with Canada's international obligations, and encourages the government to ensure that the RCMP have the resources necessary to enforce the CFPOA effectively. So, Mr. Speaker, considering that Canada is taking a leadership role, does this mean now that the NDP is going to be supportive of the government's actions to reach out around the world to increase trade with different countries? Thank you.
The Honourable Member for La Salle-et-Mar. Well, thank you, Mr. Speaker. I'm very pleased that the Conservative member who put that question alluded to the need for having more resources so we can really fight the corruption of foreign public officials. And as I said in my speech, that's the job of the RCMP. I really hope that the government will make sure that the RCMP has the resources it needs, financial or other, to fight this problem, which is the corruption of foreign public officials. Thank you. Resuming debate, the honourable member for Saint-Bruno, Saint-Hubert. Thank you, Mr. Speaker. I'm pleased to speak to Bill S-114, the Fighting Foreign Corruption Act, and an act which would amend legislation to increase the maximum sentence for the corruption of foreign officials, to eliminate the exception with regard to facilitation payments, and to create a new infraction relating to books and records and the bribing of a foreign public official or the hiding of that bribery, and establish nationality jurisdiction that would apply to all of the offenses under the Act. New Democrats, for a long time now, have supported clear and demanding rules to be followed by Canadians and companies doing business abroad. Canadians and businesses doing business abroad must be responsible and transparent, and this bill comes on top of other measures introduced by members of our party in favor of responsible practices which are also sustainable and transparent. In 2011, Transparency International placed Canada last of the G7 countries with regard to how the country addresses corruption abroad. In its report, it said Canada did very little or nothing to implement measures of, corruption measures. And since then, Canada, though, has made an effort to do just that. Since 1999, Canada has only convicted 3 people for corruption abroad. 2 of those came very recently. If we make an exception for facilitation payments, this bill will harmonize Canada's practices with those of the 36 out of 39 other OECD countries. However, the fact remains that this bill will only come into effect when it receives royal assent. Rules on facilitation payments, however, will only come into effect at a later date, which is still unknown and depending on the willingness of Cabinet. Now, rules are already applied in the States by the Security and Exchange Commission, but Canada does not have any similar regulatory body, but its criminal code will step in to play that role. This bill will play a significant role in the extractive sector. The NDP has always believed that mining companies, for instance, must be responsible. The member for Burnaby New Westminster had introduced a measure targeting people aimed at prosecuting people engaged in corruption in Canada. As well, my colleague from Ottawa Centre introduced a bill which would force companies which mine in the Great Lakes area of Africa to exercise due diligence. Mr. Speaker, Canadians want their companies to represent Canada in a way that is responsible and respectable, and Canadian companies want clear and consistent standards when they engage in international trade. The application of rules which don't have any loopholes will even the playing field for all companies while protecting the environment, labor rights, and human rights, which we can be very proud of. We've heard in the news, or rather SNC-Lavalin has been in the news lately, and in light of those reports, a measure like this is necessary. Several people from my family who live farther away have written to me, and some of my childhood friends from Algeria have also written to me asking whether it's normal for Canadians to engage in corruption abroad. As you know, there have been allegations of corruption with regard to SNC-Lavalin's activities, not only in Libya, but also in Algeria as well. SNC-Lavalin was involved in a shady affair with the Algerian public electricity company. Clearly, that episode embarrassed Canadians, and that's why we have to adopt practical measures of responsible management. And this bill will ensure that Canadian companies operating abroad will abide by standards which we can be proud of. In the current version of the bill, however, Canada can only act within a certain jurisdiction, and it can only prosecute people engaging in corruption abroad if a real and significant link can be made between the infraction and Canada. Canada's obligation to prove the existence of a connection or relationship to exercise its jurisdiction is based on nationality, and this provision was received negatively by Transparency International and by the OECD in Phase 3 of its report. These two organizations recommended that Canada amend its legislation to exercise its jurisdiction based on nationality in cases of corruption of a foreign public official, to make it easier to prosecute any act of corruption under this bill. Following the implementation of, this recommendation was included in the bill, and therefore infractions committed abroad will have been deemed to have been committed in Canada. Therefore, prosecutions can be triggered in any jurisdiction in Canada, and the criminal code will apply. New provisions will also provide guarantees with some exceptions to people who have already been prosecuted abroad. Therefore, we will avoid trying a person twice for the same crime, either before a court exercising its territorial jurisdiction, or with regard to the principle of nationality. Similar guarantees are already included in the criminal code. But again, as with many other cases, we will have to make sure that Canada walks the talk, as the MP for Outremont, whom I adore, loves to say. In Canada, loopholes in our fighting corruption legislation so far were a national embarrassment, and we're finally going to fix the problem. However, it's unfortunate that it took so long to fix the problem and that Canada had to be denounced and discredited before the government actually acted. I will quote Janet Keeping from Transparency International. In our opinion, it's very good that the Canadian government is reacting to criticism, which became stronger over the last few years with regard to the Foreign Public Officials Correction Act. I simply wanted to point out that it's important and essential to have good legislation, and Transparency International Canada supports the passage of Bill S14. But as with elsewhere in the world, legislation is only as good as when it is actually applied, especially under criminal law. let's not forget that to apply the law, we have to provide the RCMP and prosecution offices all the resources they need to do their job. So, Mr. Speaker, our outstanding policemen and women need to receive the resources they require to do their job, because without these resources, it will not be possible to appropriately implement the legislation. Thank you, Mr. Speaker.
Comments? The honourable member for Hamilton East Stony Creek.
Well, thank you, Mr. Speaker, and I believe the members from San Bruno, San Hubert, my French is not very good to begin with, but I want to thank her for her remarks. Earlier in the House, the member from Winnipeg North was talking along the same lines that perhaps there's something could have been done earlier on this bill. This member who just spoke was not in the House during the time when Bill C-300 came before the House. And to hear the member from Winnipeg North talk about how we needed to do more, I recall that night distinctly. The galleries were full of people from various NGOs and concerned groups about corporate social responsibility. Bill C-300 was at a time when we had a minority parliament. And when the vote was called, despite the fact it was a Liberal member's bill, it lost because 13 Liberals didn't bother to vote. So we certainly have had an opportunity before to start addressing this. I raised before with one of the members concerns about the fact that oftentimes we have NGOs who are trying to bring goods ashore to help people that are in difficulty, oftentimes people who are displaced persons or even in another country, and they have to pay an offloading fee, a tip, or you can call it a bribe. The reality is those things are facilitations to get that food ashore to help people. Does she see in this bill any concerns about the fact that might sideswipe the NGOs?
The honourable member for Saint-Bruno-Saint-Hubert. I'd like to thank my colleague for his very relevant question. Our objective is to apply the exception for not-for-profit organizations in order to take that into account for these organizations. However, the fact remains that what we do support here is a bill that should have been done before. And as one of my constituents said, it was someone I met at a playground, the person said, politics are all the same, Mrs. Zella. But in the NDP, we work in the interest of human rights, for the respect of labor and the environment, Mr. Speaker. Questions and comments? The honourable member for La Salle-Mar. Thank you, Mr. Speaker. I'd like to thank my colleague for her remarks. She provided a good summary of Bill S-14. She mentioned an expression that we've often used in our remarks. I'd like her to tell us what she sees in terms of real, tangible action the government could take. They've adopted budgets in the House. Oftentimes that has been part of an omnibus bill, and that is problematic. And it shows, in fact, a lack of transparency by this government. What, in her view, are the resources that should be allocated so that this bill can be fully implemented and enforced by the RCMP? The honourable member for Saint-Bruno-Saint-Hubert. Well, I'd like to thank my colleague for her brilliant question. She is a brilliant member of Parliament and does excellent work for her constituents. Now, to go back to what I quoted Janet Keeping, and she said that it's good to have legislation. However, we need to have what we need in the field, i.e. no cuts. We need to see funding for police forces, the RCMP, so that they can do what they need to. As we've seen, since we were elected to this House, unfortunately, the government doesn't see beyond the end of its nose. People are saying that financial and staff-related resources will be required. I hope that with this legislation, they will finally walk the talk. Resuming debate, the Honourable Member from Marcotte-Fortin. Thank you, Mr. Speaker. Mr. Speaker, from the outset, I would like to say that S14 is something that the NDP will be voting in favor of. Of course, we would have liked it to go a bit farther, to advance more quickly, but it is a good start. What it is essential to understand in fighting corruption is vigilance by all involved. This legislation is designed to ensure that corruption doesn't become an adequate way of operating. We don't want Canada to be perceived as committing corruption. We also want to prevent this corruption from hurting local populations. We don't want to be accomplices, making conditions worse for these people who've done nothing to us. An Italian judge, an anti-mafia judge named Antonio Falcone, who said that there are three types of police: the ones who are fighting the mafia, the ones working with the mafia, and the most dangerous of all, the ones who simply allow the mafia to do business as they see fit. And that could be any one of us, Mr. Speaker. People working hard, long hours, who meet with people, lobbyists, as part of our work as a member of Parliament on a daily basis, which can be very difficult, arduous. It's easy to miss something. Letting your guard down for just a few moments can happen to anyone. There's no one in this House who is sheltered from that. And unfortunately, dishonest people take advantage of our weaknesses. The vast majority of honest people are convinced, and this is good, that their counterparts are as honest as they are. And that is what plays right into the hands of the people who are involved in corruption. They take advantage of our confidence and trust. S14 talks about sanctioning Canadians who try to corrupt or bribe foreign officers. And we are now working to eliminate this. Corruption affects too many countries, and it's the source of human rights violations. So imagine a foreign official who's corrupt. He's not someone who respects his own laws of his own country, so if his actions are going to be challenged by a journalist if they say, a journalist says, ex-minister in that country is corrupt, will he be charged and tried, or try to assassinate the journalist in question? Corruption goes hand in hand with the destructions of the rules of a democracy. The more tolerance there is for corruption, the more democracy in those countries suffers. Now, we ask these countries to manage their affairs well, but at the same time, we say, well, if Canadian citizens offer bribes, then those Canadian citizens will just let them do that. But no, that must stop. And this bill is a response by all parties in the House to that situation I've just outlined. It's important for us as well, because if we don't take action, our credibility as legislators will be harshly criticized. Mr. Speaker, Canada missed an opportunity to sit on the UN Security Council. And that is directly linked to the fact that our foreign policy has not always been à la hauteur. We allowed allowed ourselves to dilute it, and now it is high time to change that situation. Now there's also the issue of the dictators who continue to exist. Those dictators, allow me to say, that they're very much in favor of corruption. It's the main motivation that keeps them in power. Corruption, embezzlement, they're spared nothing. And now we're saying openly we will no longer be accomplices. There was a serious issue that arose in Libya, Mr. Speaker. Mr. Gaddafi wasn't a choir boy. He wasn't someone who respected the human rights of his own people. Unfortunately, certain officials at the Canadian Embassy in Libya, in conjunction with some dishonest companies in the extractive industry in Canada working in Libya, were involved, and a great deal of this problem in revenue came from Canada. It's not something we should be proud of, and we need to remedy the situation. Now, how did we respond to this event? By introducing S14. This legislation will punish Canadians who are involved in trying to bribe a foreign official, and it was high time for this action to be taken. And for once, all political parties will be in favor of this and will be supporting this legislation. We'll be supporting the fact that someone who is found guilty may receive up to 14 years in prison for attempting to bribe a foreign official, or bribing a foreign official. The exception for facilitation payments will be eliminated. That was where you could give someone a little gift, not to accept a file, but to facilitate the speed at which the file was treated, for example. For construction permits, it was legal. But if an official said, oh, there's a great deal of work, but if you give me a little something, I'll do it next week instead of in 2 months from now. So that's a facilitation payment, and that kind of payment will no longer be tolerated. Now, with respect to the falsifying of books and records to hide corruption, that will not be allowed either. Canadian shareholders won't be able to, or boards won't be able to show Canadians that the books are all fine and well, when in fact great sums of money have disappeared and ended up in the pockets of foreign officials, and sometimes in the pockets of senior Canadian business leaders who have benefited from a kickback. So of the $50 million that's given, well, maybe 10 will be sent back to me and put in my Swiss bank account. That won't be tolerated either, and it was high time. There are limits to what Canadian shareholders will put up with. In this bill, in fact, this bill applies to all Canadian citizens, regardless of where they commit a crime. They will be held accountable under S14. In a situation where all too often Canadians have dual citizenship, they operate elsewhere, but they will no longer be able to take shelter or to be sheltered from this because of the Canadian nationality jurisdiction. So if a Canadian offers a bribe to a foreigner, there's always the danger that that culture will be such that the person will come back to Canada and provide bribes to Canadian officials. Corruption isn't limited by any border, Mr. Speaker. People who are corrupt in Libya, in Latin America, will be equally as corrupt here in Canada. And unfortunately, we've seen that that is, in fact, true. And that Canadian taxpayers have contributed to funds in tax havens for far too many corrupt people. That is why, Mr. Speaker, the NDP is in favor of this bill. We will be supporting it. We are opposed to corruption, which is a source of embarrassment for the country. It tarnishes our image and, in fact, affects our economic and financial opportunities. There are some mining companies, oil and gas companies, pulp and paper companies, manufacturing companies, etc., that will face the following situation. If other companies do business with them, well, it will be dangerous. They would be associated with someone considered corrupt. That must stop. We need to have a system in place to ensure people that if they do business with a Canadian company, we won't tolerate corruption. We don't tolerate corruption, and there will be accountability. But we don't have that reputation, Mr. Speaker. Corruption is like a cancer. It doesn't stop at the border. It affects us as well, in our political fibers as well. Mr. Speaker, recently we've seen cases of corruption affect political parties, and this morning I looked at the ideological position of someone, and my goodness, he had been involved in all of the parties at the municipal level in Montreal, every single last one of them. At the provincial level, close to the PLQ, the Liberal Party of Quebec, to Mr. Dumont's party as well. Sometimes he approached the PQ at the federal level when he was in fact a member of the Liberal Party of Canada, and even sought to run for the party. Now, we've learned that he was a conservative candidate. He really was involved on all levels. He sought out power, that's what he aimed to do, and played a corrupt role in each and every one of those cases. I guarantee, Mr. Speaker, that if he hadn't been caught and arrested when the NDP takes over in 2015, he probably would have tried to contact us as well. That's what those types of individuals are like.
And Mr. Speaker, there's no single political party that is completely watertight. We're talking about dishonest people who take advantage of the fact that we are overworked. They take advantage of us, and they're especially going to try to take advantage of the budgets and of the money, because if there was no money there, they wouldn't be sniffing around. They're only out for their own personal gain, and generally speaking, they succeed. And that is why we all, collectively, have a duty of vigilance. And in a completely nonpartisan way, Mr. Speaker, no one is completely exempt, completely shielded. Nobody can say, we could never get caught. This person was not always a conservative, this individual, but they were a thief. In the past, our protections were weak, and this wasn't good for Canada's image. But since 1999, we've had this legislation, and we've had 3 convictions, but they weren't the greatest convictions in the world. They're not what you'd call whopping fines. There is one that was $10 million, and that's not peanuts. But when you look at the type of contracts at issue, these are contracts for billions and billions of dollars, multiple billions. And people in other countries, when they see their wealth being dilapidated, being frittered away through corruption, it's very disheartening when you think that Canada's mining and natural resources sector has been ranked 4th and 5th most liable to corruption. That's embarrassing. So S14 is an attempt to correct the mistakes of the past. No one is perfect. But collectively, we've become aware of our mistakes and we're fixing them. That's the difference between a mistake and fault. Anyone can make a mistake, but you're at fault if you repeat those mistakes without correcting them. That's a problem. That's a problem that will no longer affect Canada thanks to this bill. Mr. Speaker, we also have to talk about other problems. There's corruption, but corruption is also possible because there's money laundering. A corrupt official in an African country who's caught with $4 or $5 million. We've seen this in Nigeria. There was a president who died of a heart attack. He had $6 billion in Swiss bank accounts. So you see, those individuals, when they're corrupt in their country, there's things they want to buy in their own country, but they also want to make sure that if ever they lose power, they don't lose all their money. So they squirrel it away in tax havens. And that's a problem we're going to have to address. S14 doesn't deal with tax havens, but with other legislation, we'll get at the tax havens. We'll prevent people in the future from embezzling and hiding money in that way. We're going to cooperate internationally and better regulate these movements of money. And we'll make it possible for the countries who've lost that money to get it back, and that's important. We also have a major banking sector, but we have to remember that our banking institutions play a role internationally, and a major one. That's important. We can't complain about having a sound banking system that plays a major role internationally. That's a good thing. But we have to be careful, Mr. Speaker. We have to avoid having our banking institutions expose themselves to criticism. They mustn't become a means for laundering dirty money or for facilitating corruption. So we're going to enact legislation, criminal legislation, to correct that situation. Another problem, we're talking about Canadian officials at Canadian embassies. They have a role to play. They mustn't encourage or condone or tolerate corruption. Ethically speaking, Canadian officials have to make sure that they're not, how will I put this, corrupted by an association with foreign powers. Too often, all too often, the children of presidents or ministers or senators, foreign public officers, their children get grants to come study in Canada. They get a visa more easily than even a Canadian student might, or a Canadian visa applicant. The daughter of an immigration minister was working on immigration files in a Canadian embassy, and that was hardly a good thing. It didn't look good. The last thing I'd like to discuss is the mafia and organized crime. Organized crime goes beyond borders. Corruption attracts this type of people. There's no one more corrupt than organized crime. They're like an octopus. Organized crime has tentacles that are far-reaching, and in this respect, S14 could help in the future. S14 is only a first step, though. It's not the last step, but it's a good step. Thank you very much, Mr. Speaker.
I believe the honourable member for Beausejour is rising on a point of privilege.
Thank you, Mr. Speaker. And I rise today on a question of privilege. Mr. Speaker, it's indeed the same question of privilege that my colleague from Avalon raised in this House on June 5th, related to the rights of certain members to sit and vote in this House while in violation of certain provisions of the Canada Elections Act. I would first state, Mr. Speaker, that I agree unequivocally with the arguments put forward by both my colleague from Avalon and my colleague, the member for Winnipeg North. Secondly, Mr. Speaker, I understand that you have had a chance to consider all of the arguments with respect to this question of privilege, and you may be prepared to rule on that question of privilege. The reason I'm rising, Mr. Speaker, is to tell you and to tell colleagues, I think it's important for the House to understand that our colleague from Avalon is not in Ottawa today because he had the happy news this morning at 9:55 a.m. of the birth of his second son, Isaac Andrews.
Hear, hear.
And, Mr. Speaker, I'm glad that colleagues join me in congratulating our colleague from Avalon and his wife Susan on the birth of Isaac, but therefore you'll understand that he is in St. John's today and not available to hear your ruling on this matter. For this reason, Mr. Speaker, I rise today in essence to resubmit the question of privilege raised by my colleague on June 5th. I'll spare you, Mr. Speaker, in the House the pleasure of hearing those arguments again, but I would ask, the Government House Leader obviously appreciates that, but I would ask, Mr. Speaker, that you rule on the matter today if you're prepared to do so. And if, Mr. Speaker, you're prepared to rule on the matter and you do find a prima facie breach of privilege, I would be prepared to move the appropriate motion. Thank you, Mr. Speaker.
The Chair appreciates the intervention for the honourable member for Beausejour and will take that under advisement.
Questions and comments? The honourable member for Marc-Aurèle Fortin.
The honourable Minister of Veterans Affairs.
Oui, merci beaucoup, Monsieur le Président.
Yes, thanks very much, Mr. Speaker. I have a question for my honourable colleague. He mentioned that there were three types of politicians: those who collaborate with corruption, those who are unaware, but the worst is those who are aware and do nothing and turn a blind eye. So I'd like to know how my colleague feels about the conduct of his leader, who for 17 years knew there was corruption in Laval and did nothing about it. Not only did he do nothing, he even went so far as to deny that he was ever a victim of an attempted bribe. Does this not meet the third definition that my colleague was referring to?
Member for Marc-Aurèle Fortin would like to remind all honourable members that the matter before the House is S14 and that their questions and comments ought to be related to that somewhat directly and also as for the responses. L'honorable député de Marc-Aurèle.
The honourable member for Marc-Aurèle Fortin. Woof. My colleague's question is unfortunately so partisan that it neglects the basics of what we're talking about here. We're dealing with corruption of foreign public officials, and instead of focusing on that, he's launching a personal attack. Unfortunately, currently in Canada and abroad, there are people combating corruption, and unfortunately, as a group, we are not vigilant enough. Canada's response to that lack of vigilance is S14. We will be hiring specialized police officers to combat corruption. In Montreal, there are squads, specialized teams combating corruption. There's the Marteau squad, or the Hammer squad, if you will. And my colleague may or may not be aware that just yesterday one of his colleagues was caught in that anti-corruption dragnet. And that individual, just 2 months ago, claimed to be the shadow member for the riding of Mount Royal, the Conservative candidate. So there's nothing partisan about this. Corruption is a widespread problem. It's a commonplace problem. And I'm just calling on everyone to do their part in fighting it.
For Davenport.
Mr. Speaker, and I'd like to thank my honourable colleague for his excellent speech this afternoon. He mentions a number of issues which we need to take seriously around the issue of international corruption, and he talks a bit about the context, which is that we are facing scandal upon scandal in this very country, in our political establishment, in the Senate and here in the House, and I'm wondering if my colleague would comment on the importance for Canada, if we're going to show leadership abroad, which we on our side believe this government should show leadership and claim the place that we've always held in the international dialogue, the importance of cleaning up the scandals that beset this government, beset the scandal here at home first, or as well.
L'honorable député de Marc.
The honourable member for Marc-Aurèle-Fortin. What can I say, Mr. Speaker? Corrupt individuals outside Canada are going to be corrupt inside Canada. It's the same individuals. And we see with the charges that were recently laid, people who bribed Mr. Gaddafi are the same people who gave bribes for the McGill University Health Centre in Montreal. The same individuals who claimed to be experts in military intelligence, who were on the CSIS, on the review committee, are also involved. So no one is exempt from corruption. But we can do things to deal with this situation as quickly and as strenuously as possible. And we can fight this together. Thank you, Mr. Speaker.
Question et commentaire, l'honorable député de...
The honourable member for La Salle-et-Mar. Thank you, Mr. Speaker. I'd like to thank my colleague from Marc-Aurèle-Fortin for such an eloquent speech. And I'd like him to elaborate a bit on Canada's international reputation. At the G8 meeting, Canada is once again blocking reform. They're hindering progress in this area. So I'd like my colleague to comment on this, the fact that Canada is putting the brakes to international reform efforts to improve the situation. The honourable member for Marc-Aurèle-Fortin. That is directly related to government policy. This government's choice to never be on the side of the good guys. There was an Israeli minister who, it was once said, would never miss an opportunity to do this kind of thing, and that's exactly the case for this government. On the environment, we're like lemons, we're the dunces, we're the most polluting, we're on the side of the polluters. When it comes to money laundering, again, we're back of the pack. They've cut efforts to fight money laundering. On international corruption, once again, we're in the back of the pack. We're the last country. S14 hasn't yet been passed. We're the last G8 country to enact legislation on this issue. Mr. Speaker, sooner or later, this government is going to have to shoulder its responsibilities in all areas. We lost a seat on the UN Security Council. That should have been a red light, but they downplayed it. They trivialized it. They trivialize everything, anything that would make it stand in the way of a Canadian company making a quick buck. They're against it. And unfortunately, this tarnishes Canada's international reputation. Thank you.
So the honourable member for Davenport.
Thank you, Mr. Speaker. And on that subject, there's a 2011 report from Transparency International that ranked Canada as the worst of all G7 countries with regards to international bribery, with little or no enforcement of the scant legislation that does exist. So we're playing a lot of catch-up on this front, and perhaps my honourable colleague could comment on why it is that this government needs to be dragged kicking and screaming at all levels in order to present transparency and accountability.
The honourable member for Marc-Aurèle-Fortin. We are the last country to enact this type of legislation. We are the dunces. This is essential, and when I quoted Justice Falcone, he mentioned that there are those who fight the mafia, those who work with it, and those who do nothing about it. This government, for the longest time, not through any lack of vigilance or complacency, they knowingly allowed corruption to go on. In Libya, at the Canadian Embassy, our officers were fully involved in corruption with the Gaddafi family, and that's unacceptable. That's why Canada is being singled out. That's why we have such a bad reputation, such a bad record. The effect on, regardless of the hit that our reputation has taken, this government has supported the corruptors and tolerated corruption. But with this bill, we're going to restore Canada's reputation. Thank you, Mr. Speaker. Questions and comments? The honourable member for La Salle-Mar. Thank you, Mr. Speaker. I'd like to reassert, and I'd like my colleague to elaborate on this, the fact that the NDP is in favor of responsible, sustainable, and transparent practices. I think my colleague referred to this in his speech, but I'd like him to reassert that commitment on behalf of the NDP, and I definitely appreciated the fact that he mentioned that this is an individual responsibility as well. Each and every one of us has a role to play in acting ethically and responsibly. The honourable member for Marc-Aurèle-Fortin, a quick answer, please. Yes, Mr. Speaker, that's a good question. Very often, corruption is not just to get a hold of a foreign country's wealth, but it's also in violation of the rules on the environment, on sustainable development, on workers' rights, on local communities' right to live in a healthy environment, not to disrupt transportation means and clean water. All of this is part of the regulation, and corruption denies all those rights to sustainable development. Thank you, Mr. Speaker.
Has expired. Statements by members. Déclaration de député. L'honorable député.
Honourable member for Haute-Gaspésie, Le Métis, Matane, Matapédia. Quebecers can draw a pitiful record of the parliamentary session that is ending, Mr. Speaker. Let's talk first about governance. Navigating from scandal to scandal, the Conservative government no longer has any moral compass. The attempt to cover up fraud committed by senators to the tune of thousands of dollars, and the defense of former Minister Panashwe, who violated elections funding rules, are patent examples of the government's ethical failure. With regard to the consequences for Quebec in all areas, both economic, political, social, and environmental, the government is multiplying decisions that hurt the interests of Quebec. Maintaining the Clarity Act with the support of the NDP and the Liberals, which prevented the Quebec nation from being master of its future, and the support of all Federalist parties for the funding of the Churchill Falls project, which is competing with our money, that is Hydro-Quebec, reveals the extent to which the Federalist parties are prepared to undermine Quebec in favor of Canada. At the same time, unfair reform of employment insurance is hurting and weakening the regions and allows us to say, Mr. Speaker, it is indeed a pitiful record.
The honourable member for Vancouver South.
Mr. Speaker, today I rise to mark a historic moment in this place when our government passed Bill S2, the Family Homes on Reserves and Matrimonial Interests or Rights Act. Shamefully, the Liberals and the NDP voted against this important legislation, which gives women and children living on First Nation reserves the same matrimonial rights and protections as all Canadians. Despite the courts having identified a legal gap in the protection of women and children on reserves some 25 years ago, violence and sometimes even death has resulted for too long. While it is unconscionable that the opposition parties stood against giving these rights to Aboriginal women and children across our country, I applaud those countless women and organizations who came forward to support this bill. Together, Mr. Speaker, we have closed this gap, provided these protections, and made our communities safer. Thank you, Mr. Speaker.
The honourable member for Davenport.
Today, for the first time ever, almost 50% of workers in Toronto cannot find stable full-time jobs. What does this mean for urban workers and, in fact, for all workers across the country who are among this growing sector? Well, it means part-time work, split shifts, serial contract and self-employment, and increasingly it means unpaid internships. Now, there are many excellent internship programs out there, but their reputation is being tarnished by companies who wish to exploit young workers. Indeed, more and more young people who are recent graduates carrying on average $28,000 in debt, student debt, are told that they must work for free first before being able to get a paying job in their field. It's tantamount to being bribed with the possibility of a job in exchange for free labor. Indeed, too often unpaid internships are being misused while this government turns a blind eye. This inaction is one of the many reasons that I'll be tabling an urban worker bill in the House that will, among other things, call on the government to crack down on the misuse of unpaid internships. I urge the government to finally take this issue seriously, to take the issue of youth unemployment seriously, and to support my bill. Thank you, Mr. Speaker.
L'honorable député.
Mr. Speaker, I'm pleased to say that two municipalities in my riding are preparing to celebrate their 150th anniversary. I'm talking about Saint-Edouard and Le Clairville. Rich in history, welcoming and dynamic people live in both communities. The communities continue to grow because they are such great places to live. A program of activities will allow residents and visitors to celebrate together and discover this beautiful part of the country close to the river. I want to recognize the outstanding work done by the organizers and volunteers of the event to promote local cultural development, an event that will allow everyone to establish friendships that will last years and generations. Happy 150th anniversary to all.
The honourable member for York West.
Thank you, Mr. Speaker. Earlier today, South Korea indicated it will do more to help refugees fleeing the repressive northern regime, a measure responding to the recent forced repatriation of 9 North Korean refugees from Laos. The defectors were detained and handed over to North Korea, a move that contravenes the UN Convention on Refugees. Such violations are not unusual, and the incident only underscores the need for action. North Koreans flee because they live in one of the world's most undemocratic countries, where human rights are ignored and dissent is dealt with harshly. They are captured and repatriated because the world closes its eyes. This is intolerable, and Canada must be a voice for victims. When dealing with a country that seeks isolation and seclusion in order to violate human rights, isolation and seclusion are the conditions that we must deny them. The time has come for Canada to show the world that the terrible human rights record of North Korea is not acceptable. Let these 9 defectors be the last ones.
Right.
The honourable member for Ancaster, Dundas, Flamborough, Westdale.
Mr. Speaker, people in the Hamilton area, and most certainly their families, were relieved to hear the news last evening that the charges against 2 Hamilton men in the Dominican Republic were dropped after they reached common ground with the other Canadian involved, and they've been released. Thanks to the efforts of the Canadian consular officials in the Dominican Republic, who were praised by officials from the Dominican justice system, and to the Minister of State for Consular Affairs and her hardworking staff for their engagement on behalf of all Canadians involved. Mr. Speaker, our citizens have been through an ordeal that we certainly hope no others have to suffer. That's why I think it's a good reminder to all Canadians as we head into summer travel season that when you travel abroad, you are subject to local laws and local justice systems which are different from our own. Traveling abroad is a wonderful opportunity. However, please be aware of the precautions and advisories that the Foreign Affairs Department provides. The booklet that's available at all passport offices and MP constituency offices and the Foreign Affairs website are chock full of valuable travel information and tips. Our government wishes that all Canadians have a great and refreshing holiday, so get informed, travel safe, and bon voyage.
The Honourable Member for Laval. The end of the Conservative government is in sight. A glance at its roadmap over the past few weeks reveals the panic that has a firm grip on the Prime Minister's office. With now over 45 gag orders, the government is limiting debate on issues affecting all Canadians for fear of having to defend the indefensible. By taking the floor from the opposition, the Conservatives are denying Canadians their voice. Panic in the government ranks can be heard in their speeches. The Conservatives are clearly scraping the bottom of the barrel and no longer know what to do. Repeated time allocation, senators who spend irresponsibly, and a prime minister unable to control even his own caucus. In 2015, and perhaps before, the NDP will be here to get the country back on track and replace the government with a competent and caring team.
The honourable member for Dauphin, Swan River, Marquette.
Mr. Speaker, last May the Prime Minister announced the creation of the Hunting and Angling Advisory Panel, an acknowledgement of our government's appreciation for the conservation records of Canada's hunting and angling community. Today I am proud to talk about our government's recently announced $10 million Recreational Fisheries Conservation Partnership Program. Through partnership agreements between the Department of Fisheries and Oceans and local angling groups, this program will enhance recreational fisheries by restoring habitats and improving fish production. This partnership program was enabled by changes that our government made to the Fisheries Act. The value of recreational fishing in Canada is an impressive $8 billion, and an estimated 4 million Canadians are active anglers. Our new program is a win-win for anglers, tourism-dependent communities, and of course, Canada's aquatic ecosystems, and will deliver real conservation results, a notion that the opposition simply does not understand. Mr. Speaker, as chair of the Conservative Hunting and Angling Caucus, I am so very proud to be part of a government that stands up for the angling and hunting communities across Canada.
The honourable member for Winnipeg South.
Thank you, Mr. Speaker. This Friday, June 21st, we celebrate National Aboriginal Day. We celebrate the heritage, culture, and achievements of Canada's Aboriginal peoples, both past and present, and look forward to the future. There are many events taking place from coast to coast to coast, but there is one in particular that I would like to mention that will take place right here in the nation's capital. The National Aboriginal Parliamentary Prayer Breakfast is hosted by Honorary Chief Kenny Blacksmith, founder of Gathering Nations International. He will gather leaders from across communities in a spirit of renewal and unity. This year's theme is entitled Beyond Forgiven. Kenny's a strong Aboriginal leader and a friend to many, and I wish him a great success with this year's National Aboriginal Prayer Breakfast, and thank him for his hard work and dedication to the First Nations communities. I'd like to invite all parliamentarians to join in attending this great event at the Chateau Laurier this Friday morning. Thank you.
The honourable member for Hamilton Mountain.
Over the past 4 years, the Conservatives have slashed public services and tried to get buy-in by calling them austerity-related cutbacks. But Canadians aren't buying it because they know that the Conservative Axe is slashing the very programs that we all hold most dear. Let's have a look. Here are some of the biggest cuts as a proportion of the department's size. Statistics Canada is losing a third of its workforce, but then no one has ever accused the Conservatives of wanting to base their decisions on evidence and facts. Next is HRSDC, where a quarter of the workforce will be gone. These are the folks that deal with things like EI, pensions and housing. There's a staggering 62% cut to programs that support homelessness initiatives. Next, there's Veterans Affairs, where the largest proportional cuts are going to programs that support disability, death and financial benefits for veterans. This is how we give thanks to our troops. And the Canadian Food Inspection Agency is losing 1,400 positions, or 20% of the staff. The biggest cuts are in the programs that keep us safe from things such as mad cow disease. These cuts affect us all, so let's push back together. Let's fight to protect our public services. After all, we paid for them.
The honourable member for Jasnefi, Missinippi, Churchill River.
Thank you, Mr. Speaker. It is clear that the Leader of the Opposition possesses dangerous driving skills. Last week, the Leader of the Opposition ran through 5 stop signs, committed criminal code infractions, and refused to pull over when emergency lights on a fully marked police car were activated. As a former RCMP officer, I too have encountered individuals who think they're above the law. When finally stopped, he tried to intimidate the officer, saying, "You're going to be in a lot of trouble." The Leader of the Opposition then had the audacity to hide during question period instead of immediately apologizing to Canadians and the RCMP. To make matters worse, the member from Timmins James Bay insultingly referred to female officers as meter maids. I have worked with many excellent female officers and stand with them and all those who risked and gave up their lives serving in the RCMP. Mr. Speaker, the Leader of the Opposition endangered Canadians, and his driving could have resulted in someone being hurt or worse.
L'honorable. The honourable member for La Pointe de l'Île. Mr. Speaker, June 20th is World Refugee Day. It's a day to remember how important it is to provide our leadership to prevent and end conflicts causing families to leave their homes. Canada must play a role in improving the lives of refugees who are victims of modern conflicts, a role that needs to remain a central pillar of humanitarian aid. We cannot abandon those in need. Fleeing one's home is never a choice. These forced departures put families further in danger. Kidnapping, rape, and torture are just a few examples of the dangers faced by refugees. Commemorating this day means remembering all the challenges refugees face and our duty to act. Thank you, Mr. Speaker.
The honourable member for Etobicoke Lakeshore.
Mr. Speaker, last week the Leader of the NDP tried to imitate Reese Witherspoon by proclaiming, "Don't you know who I am?" An RCMP officer had to chase the NDP leader around Parliament Hill after he decided that the security rules did not apply to him. After having been warned not to do it again, the Leader of the NDP used intimidation and threatened this frontline worker by telling her that she would be in big trouble. The bearded bandit of the Hill is not above the law. He can run, but he cannot hide. The Leader of the NDP believes that he is above the law and lacks respect for those who put their lives on the line to protect Canadians. That attitude shows a lack of judgment, and the Leader of the NDP is demonstrating why he is incapable of governing. Thank you, Mr. Speaker.
The honourable member for Etobicoke North.
Mr. Speaker, June is National Brain Injury Awareness Month and highlights awareness of the causes and effects of brain injury. Automobile and cycling accidents, falls, sports, injuries, strokes, tumors, and other non-degenerative conditions are leading causes of brain injury in Canada, a silent epidemic, with brain injury being the #1 killer of people under the age of 44. Unfortunately, there are no drugs or techniques that can cure a brain injury, and the emotional, social, and economic costs are devastating to families. Sandy and Swapna Mailabathula in my riding have been working with the Brain Injury Association of Canada to promote a pan-Canadian concussion strategy. Together, let's fight for a year of the brain and fight for a national brain strategy to improve the quality of life for all Canadians living with a neurological disease, disorder, or injury, and their families and caregivers. Thank you, Mr. Speaker.
The honourable member for Prince Edward Hastings.
Well, Mr. Speaker, as members of Parliament, part of our job is to work with the pillars of our communities to help make them better places for everyone. In 2010, just 2 years after being elected, the leader of the Liberal Party spoke to a professional development conference for teachers in my riding and educational staff from local prisons, as many of us do. I would say bully for him. But did he do it out of the goodness of his heart or for the betterment of my community or other communities? Sadly not. He did it for $15,000 of taxpayers' money. This on top of the generous salary that he already received as a member of Parliament. Canadians know there's only one taxpayer, Mr. Speaker, and this type of double dipping is reprehensible. The Liberal leader has clearly shown that he puts his own financial interests ahead of education and that he's just over his head. Hey!
The Honourable Member for Portneuf-Jacques-Cartier. Mr. Speaker, instead of the bias training manual for parliamentary guides, I thought of a few suggestions to make tours more interesting and truer to reality. We should create a wing in honour of the Prime Minister with portraits of Mike Duffy, Pamela Wallin, Patrick Brazo, Arthur Porter, Bruce Carson, and Solly Zidell. For children, there would be a ballroom in which they could look for the $3.1 billion the Conservatives lost. But to top things off, there would be a laminated copy of the $90,000 cheque by Nigel Wright to fund the construction of the new wing in this time of budget cuts. I was thinking of organizing a fundraiser with a not-for-profit organization. We could have asked the member for Papineau to speak, but apparently these events don't go over so well. Ultimately, when you have to act like Nigel Wright and get out your checkbook to repay thousands of dollars, it's not ideal. I don't know what the better solution would be, so I'd like to quote a great speaker here. I'm very conflicted about my own position.
The honourable member for Ajax-Pickering.
Thank you, Mr. Speaker. Mr. Speaker, as you know, childhood is a sacred time for Canadians, a time when friendships are forged for life. So imagine our surprise last week when a defiant millionaire Liberal leader sent out his childhood friend from across Sussex Drive, the member for Beausejour, as the sacrificial lamb to defend his exorbitant speaking fees scammed from charities. The member for Beausejour demanded apologies from those who called the Liberal leader out for ripping off charities. And for a few short hours, that childhood friend, the member for Beausejour, was the one person in Canada who didn't feel ripped off by the Liberal leader. But that all changed when the Liberal leader abandoned his position and hung his childhood friend from Rideau Hall out to dry. Make no mistake, Mr. Speaker, this Liberal leader won't think twice about scamming the most vulnerable in our society or abandoning his best friend if he thinks he can make a buck. The Liberal leader's favourite cause is a long way from charities or childhood. It's the Liberal leader.
Oral questions. Questions oral. The honourable member for Halifax.
Mr. Speaker, 5 days ago, the RCMP publicly confirmed that they were investigating the $90,000 check that Nigel Wright wrote to Mike Duffy. As of today, has any employee of the Prime Minister's office been contacted on this subject by the RCMP? The Honourable Minister of Canadian Heritage. Same question as yesterday, Mr. Speaker, same answer. The answer is no. The Prime Minister nor anyone from his office has spoken to the RCMP until now, and that's something quite different from the actions we've seen from the RCMP leader when he was called by the police in Montreal, and he said that he didn't speak to them about the Laval mayor's scandal. So two different approaches, that of the Conservative Party, which is direct, and that of the NDP, which hides details for 17 years. The Honourable Member for Halifax.
Yesterday, the Minister of Canadian Heritage said that Nigel Wright wrote a personal check to Mike Duffy. Does he have proof of this? And if he does, will he table it today?
The Honourable Minister of Canadian Heritage.
As I've said before, Mr. Speaker, no, I don't have access to other Canadians' personal bank accounts. But it was indeed a fact that Mr. Wright resigned, and he took sole responsibility for his behaviour, because that is indeed how these matters unfolded. This was a transaction between Nigel Wright and Mike Duffy individually. But again, the larger question, again for the NDP, they try to avoid this day in and day out, which is why it is that the leader of the NDP failed after 17 years to disclose corruption in the city of Montreal. Why did he hide it? Why didn't he come forward with it? And why did it take so long for him to finally admit that he was offered a bribe by the mayor of Laval?
Member for Halifax.
Speaking of day in and day out, let's turn to yet another issue where the Conservatives are in trouble with the law. Did the Minister of Canadian Heritage even know Sally Zidell when he hired him? And who recommended him for the job?
The Honourable Minister of Canadian Heritage.
Well, Mr. Zidell was a councillor for 23 years. He was a candidate for the Conservative Party, and he's been arrested, Mr. Speaker, on four specific charges. And, Mr. Speaker, I would tell you this, as I said yesterday very clearly. If anybody, Mr. Applebaum or Mr. Zidell, if anybody is convicted of having done anything wrong, they should have the book thrown at them and to be held accountable to the fullest extent of the law. That's what taxpayers expect, Mr. Speaker. They expect people to respect the law, which is something that the leader of the NDP absolutely failed to do for 17 years, and an absolute failure of leadership to the people of Montreal.
The honourable member for Pierrefonds. When he was hired by the Heritage Minister, he was a politician who wasn't particularly known for his cultural knowledge. So, was it Dimitri Soudas, Leo Housakos, or even the Minister of Immigration who would have recommended that the Minister of Heritage hire Sally Zidell? The Honourable Minister of Canadian Heritage. Quite simply, Mr. Speaker, Mr. Zidell or Mr. Applebaum, if they have broken any laws, they should be punished to the full extent of the law. It's very clear. There should be accountability. And here in the House of Commons, with the municipal situation in Quebec, it's clear that the process is unfolding in an effective way to the benefit of Montrealers, Quebecers, and Canadians. The Honourable Member for Pierrefonds. Mr. Speaker, I didn't ask anything about the Minister of Heritage's values. I asked if anybody recommended his hiring. So, with every passing day, we learn of another Conservative being investigated by the RCMP. Hubert Piché, who's a former Conservative candidate and assistant to Senator Pierre-Claude Nolin, is under investigation by the RCMP for his role in the awarding of a contract for the repair of the West Block. Did the Prime Minister's office contact Senator Nolin to ask why his former assistant would have used his parliamentary office to try and influence the awarding of a public contract? Honourable Parliamentary Secretary to the Minister of Public Works. Mr. Speaker, senior officials at Public Works clearly stated that there was no political interference in the awarding of this contract. All of the people involved will have to face any consequences. The process is what it is for the awarding of contracts. Mr. Speaker, Sally Zidell is a former Conservative candidate and employee, was arrested on charges that he allegedly committed corruption before 2011. A security check should have revealed that Mr. Zidell was a security risk, but the Conservatives chose to give him a job that was paid for by taxpayers. So why did the minister hire a former Conservative with such a dubious past at taxpayers' expense? The Honourable Minister of Canadian Heritage. Honestly, Mr. Speaker, that's not at all the case. And my colleague should know that it's the Liberal Party who asked that he run as a candidate for the Liberal Party. So, Mr. Speaker, there is a process on the ground in the front lines, and it will unfold as it should to find the accountability. If any of these people broke the law, they should certainly be fully responsible for it.
Mr. Speaker, the culture of corruption is so deep in the Prime Minister's office that now 2 of his ex-chiefs of staff are facing RCMP investigations with respect to potential criminal behaviour involving legislators and other government officials. The question must be asked, what does the Prime Minister ask his chiefs of staff to do that ends them in a police investigation and facing possible jail time.
The Honourable Minister of Canadian Heritage.
Mr. Speaker, as my colleagues should know very well, that Mr. Wright has resigned and taken sole responsibility for his actions, which is entirely appropriate given this matter, Mr. Speaker. But again, if the leader of today's leader of the Liberal Party wants to speak to others about the importance of acting responsibly in public office, demonstrations of leadership by those who are in positions of authority, perhaps he can explain why the current Liberal leader has, again, taken money from charities that were designed to raise money to provide beds for seniors, literacy programs for kids that were designed to support mental health. He took hundreds of thousands of dollars from charities that were designed to help those who are the most vulnerable in our society. He should show...
Member for Beauséjour.
Mr. Speaker, Nigel Wright, Mike Duffy, Solly Zidell, Bruce Carson, Arthur Porter. The Prime Minister clearly likes to surround himself with men of conviction. In Bruce Carson's case, I think he has 5. So, Mr. Speaker, when did the Prime Minister decide that to work for him, you must either have a criminal record or be willing to obtain one?
The Honourable Minister of Canadian Heritage.
Liberal Senator Penna Merchant, $1.7 million hiding outside of this country, not paying her taxes, who was advocated by the member for Wascana, the Liberal Party.
Order. The Honourable Minister of Canadian Heritage has the floor.
Well, you know, it's the Liberal leader who says that it's okay for Matt Carb to take $231,000 from taxpayers. As long as he pays it back, he's welcome to come back into the Liberal Party. That's the Liberal standard for ethics. Their senators can rip off the taxpayers, take money away, and as long as they pay the money back, if they get caught, they're welcome to come back into the Liberal Party. That's their approach to ethics. Take money from charities, support Liberal senators who don't pay their taxes, and welcome senators back into their caucus who are disgrace to Canadian taxpayers.
Honourable Member for La Pointe-de-L'Île. Mr. Speaker, let's get back to the Conservative minister's former assistant who was handcuffed yesterday. Did the Minister of Heritage give Solly Zidell a job interview personally before hiring him? If not, can he tell us who did? The Honourable Minister of Canadian Heritage.
Mr. Zidell or Mr. Applebaum or anybody are convicted of wrongdoing, they should be held accountable to the full extent of the law, Mr. Speaker. That's what the people of Montreal expect. That's what all Canadian taxpayers expect, Mr. Speaker. But it's no wonder that the Charbonneau Commission is going to take 5 years, cost millions of dollars, when people like the leader of the NDP don't cooperate with these investigations as they're ongoing. That's why the people of Montreal are frustrated. That's why Canadians are frustrated when you have the failed leadership of people like the leader of the NDP not cooperating and getting to the bottom of these scandals.
Order. There's still far too much noise while the ministers answer the question. I'll ask members to come to order.
Honourable Member for La Pointe-de-L'Île. It's very strange, Mr. Speaker. They hired someone who is facing criminal charges, and it doesn't seem to bother them. Mr. Speaker, Solly Zidell is under criminal investigation for fraud, corruption, and breach of trust for a period between 2006 and 2011. The last federal elections took place in 2011. When was Zidell approached to become a Conservative candidate? And precisely when did he become a Conservative Party candidate? Honourable Minister. It was yesterday at 10 in the morning that there was a press conference by the RCMP that spoke about Mr. Zidell. It's the first time that his name has been mentioned in this process, and my colleagues should be aware of the process. The Honourable Member for Alfred-Pellat. The lack of judgment is becoming the Conservatives' trademark. Zidell, Wallen, Brazo, Duffy, Porter, and more were all appointed by this Prime Minister, and all of these people are suspected or accused of fraud. Mr. Speaker, during his job interview with the Minister of Heritage, did Solly Zidell mention that he had special contacts with anyone in Montreal's public administration? The Honourable Minister of Canadian Heritage. It's ridiculous, Mr. Speaker. It's the NDP here in the House of Commons that has shown their lack of judgment, and members who don't pay their taxes, members who don't respect their responsibility for working with the Charbonneau Commission and the leader of NDP, who doesn't follow the rules even here on the Hill in his car. So it's the NDP that aren't respecting the process nor the laws of this country. The Honourable Member for Arfeld-Pélan. I know it's easy to get confused by the number of criminal investigations underway involving the Conservatives, so just to make sure they follow, I'll drop the arrest of the the minister's former assistant to talk about Senator Nolin's former assistant. Mr. Speaker, has the Minister of Public Works ever had any discussions with Hubert Pichet on the subject of the $9 million for the renovation of the West Block Tower? The Parliamentary Secretary for the Minister of Public Works. Mr. Speaker, senior officials of Public Works have clearly stated that there was no political interference in the attribution of this contract. All of the people who are accused of corruption will face the law, and they had nothing to do with the attribution of the contract.
Well, Mr. Speaker, more questions about Conservatives being arrested for corruption and no answers from these Conservatives. Mr. Speaker, I will give the Conservatives one thing. They are very good about finding their friends good jobs. Who recommended to Senator Nolan that he hire Hubert Pichet? And did any ministers recommend Mr. Pichet to the Senator?
The Honourable Parliamentary Secretary to the Minister of Public Works.
No, Monsieur le Président.
No, Mr. Speaker.
Member for Timmins, James Bay.
Well, you see, Mr. Speaker, the problem is it's not just the Prime Minister and key Conservative senators who are investigated by the police right now. Yesterday, a key political advisor to the Minister of Heritage was arrested for corruption. Today, now we have a Conservative staffer who's also been arrested and charged on the issues with the West Block scandal. So my question is simple. Did any minister or any staff from the Prime Minister's office ever discuss the West Block renovation project with Senator Nolan's staffer, Hubert Pichet?
The Honourable Parliamentary Secretary to the Minister of Public Works.
No, Mr. Speaker.
Bravo. The Honourable Member for Timmins, James Bay.
That's ridiculous.
Well, Mr. Speaker, they're pretty happy over there over the fact that more and more of them are being busted. Sooner or later, we're going to have to be doing these question periods in the Don jail. Anyways, if they can't give a straight answer on this Conservative staffer who was just arrested, maybe we can get a bit more understanding of this political advisor who was hired by the Minister of Heritage and is now under arrest. So did Solly Zaidel do any work for ministers other than the Minister of Heritage?
The Honourable Minister of Heritage.
No.
The Honourable Member for Skeena, Bulkley Valley.
Speaker, this Conservative government has moved time allocation to shut down debate for the 49th time this Parliament alone. MPs of all parties come to this place to bring forward their best ideas in the hopes of all Canadians. But the government clearly doesn't like to hear from them, especially those Canadians they happen to disagree with. They call them radicals. They call them enemies of the state. Will the government House Leader acknowledge that his record-breaking choking off of debate is the clearest indictment of Conservative failure to work with Canadians?
The Honourable Government House Leader.
Mr. Speaker, our government took on this mandate with a commitment to Canadians to deliver on the #1 priority for Canadians, jobs and economic growth. And as a result, we put forward an agenda in a series of budgets and other bills to do exactly that. And the results are apparent. Canada is leading the world, over 1 million net new jobs. Our government is delivering on what really matters to Canadians while they stand in the way.
The Honourable Member for Skeena, Bulkley Valley.
300,000 lost manufacturing jobs, highest unemployment rate, highest personal debt rate in Canadian history. That's their record on the economy.
Hear, hear.
The secrecy and abuse of power isn't an attack just on the opposition in Parliament. Backbench revolt spiked by the PMO. Legislative debate shut down by the government House Leader. Simple and clear questions about a massive scandal that goes right into the heart of the PMO. Arrogant denials from Conservative ministers. Canadians deserve better, a government that isn't afraid of the truth and respects Parliament. In 2015, they're going to get a chance to vote for one.
The Honourable Government House Leader.
Mr. Speaker, the record is clear. Over 1 million net new jobs on the track to balance the budget by 2015. The lowest debt, the lowest deficit of any of the major economies. The first of the major economies to recover the jobs lost in the economic downturn. The strongest job creation performance of any of the major economies in the face of a global economic downturn that was stifling every economy in the world. Canada has done well, and Canada has done well because of an economic record and leadership that has delivered on what matters to Canadians.
The honourable member for Westmount Ville-Marie.
Mr. Speaker, the list of Conservatives under investigation by the police is getting longer by the day. Now we've learned that Hubert Piché, who was a former employee of Conservative Senator Nolin, is also under investigation concerning the renovations of the Parliament buildings. And yet, 2 years ago, several ministers on the other side assured us that there was no political interference on this file. Why are they hiding this from Canadians? For 2 years, can we be assured of full cooperation with the RCMP? Yeah.
Minister of Public Works.
Mr. Speaker, senior officials from Public Works have clearly stated that there was no political interference in the awarding of this contract. All of the people involved in corruption will face the consequences, and the officials who are in charge of the process are managing it, including the awarding of the contract.
The honourable member for Humber, St. Barbe, Baie Verte.
Mr. Speaker, HoC and ECBC have become the targets of 3 separate investigations under this minister's watch. When asked yesterday about the Integrity Commissioner's investigation, the minister replied, as if I were asking about the Public Service Commissioner's report, will the minister now confirm to the House that she has made herself aware of the 3rd investigation of her portfolio by the Integrity Commissioner, and that she will cooperate fully with the Commissioner and provide whatever information is asked for concerning the involvement of the Minister of Defence in inappropriate partisan hiring at ECBC? Will she do that?
The Honourable Minister for ACOA.
Thank you, Mr. Speaker. I can't speak to the details of any ongoing investigation, but I can assure the honourable member that although ECBC is an arm's-length Crown corporation, that I expect officials to cooperate with any investigation that's ongoing.
The honourable member for Humber, St. Barbe, Baie Verte.
Well, Mr. Speaker, the Public Service Commission report that was originally presented to the minister was not the same one that was tabled in this House. Even though it was a COA that was being investigated by the PSC, it was the Defence Minister's Chief of Staff who got involved and demanded that a section of that report pointing to the Defence Minister's involvement in the illegal hires be removed from the report. Will the Minister of ACOA promise this House that the report of the Public Sector Integrity Commissioner will not be altered, redacted, or whitewashed in any way?
The Honourable Minister for ACOA.
Thank you, Mr. Speaker. I can assure the honourable member there was no whitewashing of any report. Mr. Speaker, the Public Service Commission found no evidence of any political interference, Mr. Speaker, which not surprisingly is in stark contrast to a 2006 report on the Liberal Phantom Job Scheme. Maybe they could talk about that.
The honourable member for Abitibi-Témiscamingue. Mr. Speaker, Lockheed Martin started signing contracts with Canadian companies to manufacture F-35 parts. The problem is that we still don't even know whether the F-35 will be able to fly, negotiate cloud cover, do air-to-air refueling, or land in the Arctic. So why is Lockheed Martin giving contracts to Canadian companies unless the Conservatives have already decided to buy the F-35? Or is it just because they've never seriously considered any other option?
The Honourable Associate Minister of National Defence.
Mr. Speaker, our government is proud of the 80,000 Canadian aerospace workers across Canada, many of them in Quebec. Our participation in the MOU ensures Canadian industry continues to have access to billions of dollars in contracts. As we have said before, the government will not proceed with the replacement of the CF-18s until the 7-point plan is completed. Until a decision is made, we will continue to support Canadian workers in our world-class aerospace industry.
The honourable member for Beaches, East York.
Well, Mr. Speaker, yesterday while the Associate Minister of Defence was standing in this House claiming no decision had been made on replacing the CF-18, Lockheed Martin was signing a deal for training system support in Canada for the F-35. So, Mr. Speaker, will the Minister now tell Canadians what Lockheed Martin already knows?
The Honourable Associate Minister of National Defence.
Well, my colleague, Mr. Speaker, is quite right, and I stand by what I said yesterday. No money has been spent on the purchase of new fighter aircraft. We will not purchase a replacement aircraft until our 7-point plan is complete. 70 of our world-leading aerospace companies have already won contracts worth $438 million, and remaining in the program means continued benefits for Canadian industry and jobs. When a decision is made, we will let Canadians know.
The honourable member for Ottawa Centre.
Mr. Speaker, the Conservatives are undermining our international reputation yet again when it comes to deadly weapons targeting civilians. The International Committee of the Red Cross is voicing strong warnings about the huge gaps in the Conservatives' bill to ratify the Convention on Cluster Munitions. Gaps that show that if this legislation goes forward, it would mean that Canadian forces would be in joint operations using cluster munitions, if you can imagine, Mr. Speaker. Why is the government proposing flawed legislation with huge loopholes instead of honouring Canada's commitment to ban cluster munitions?
Honourable Parliamentary Secretary, Minister of Foreign Affairs.
Mr. Speaker, our legislation fully implements Canada's commitments to the Convention and is in line with our key allies, including Australia and the United Kingdom. The Canadian forces, Mr. Speaker, will make its policy to prohibit their members from using cluster munitions. Mr. Speaker, this legislation preserves Canada's ability to work alongside our allies.
The honourable member for Laurier St. Marie. Mr. Speaker, cluster munitions kill and maim thousands of innocent people, especially children, for decades after the end of conflicts. But with their flawed bill, which, let me tell you, is full of loopholes, the Conservatives are showing that they really have no intention of abolishing these weapons. Will the government agree to work with us in order to rapidly correct the major flaws in this bill?
The Honourable Parliamentary Secretary.
Mr. Speaker, our government is proud to have participated actively in the negotiation on the Convention on Cluster Munitions, Mr. Speaker, and we are one of the first countries to have signed on the Convention in 2008, Mr. Speaker. The Prohibiting Cluster Munitions Act fully implements Canada's commitment to the Convention and strikes a good balance between humanitarian obligations while preserving our national security and defence interests. Thank you, Mr.
The honourable member for Huron-Bruce.
Thank you, Mr. Speaker. I oppose Bill 377, the Union Transparency Bill. Mr. Speaker, I can also tell you I've never taken any money from unions before or after being elected MP. Had I done so and voted against 377, I would have been in conflict of interest. To contrast, the Liberal leader took over $100,000 in personal payments from unions, including tens of thousands of dollars as his time as MP. After receiving this money, he is now a vocal opponent of the Union Transparency Bill, and his party is opposing it in the Senate. I will be raising this matter with the Conflict of Interest and Ethics Commissioner. Can the government comment? Thank you.
Honourable Minister of International Cooperation.
Well, Mr. Speaker, this matter does in fact deserve to be investigated by the Ethics Commissioner. And allow me to quote from Section 8 of the Conflict of Interest Code for members, and I quote, "From performing parliamentary duties and functions, a member shall not act in any way to further his or her private interests," end quote. Mr. Speaker, furthermore, there needs to be an investigation into whether the Liberal leader's acceptance of this money placed him in a real or perceived conflict of interest with respect to his policy position. Mr. Speaker, I applaud the member for putting ethics first.
The honourable member for Charlebourg Saint Charles. Mr. Speaker, with each year that goes by, we learn a bit more about the Conservatives' incompetence and amateurism with regard to skills training. Yesterday, the Alliance of Western Premiers joined Quebec and Ontario to denounce the problems linked to the Canada Jobs Grant, a program, might I point out, that doesn't even exist. Can the minister tell us why she is not listening to the provinces? Why she is wasting thousands of dollars in promoting a program that does not exist?
The Honourable Parliament Secretary to the Minister of Human Resources.
Mr. Speaker, we want to work with the provinces to ensure that the training flows from the government to employers and to the workers available.
Ne peuvent pas trouver des travailleurs qui ont les compétences recherchées.
Workers who have the skills needed. This helps workers match workers.
Monsieur le Président, l'opposition a voté contre.
Mr. Speaker, the opposition voted against all these programs.
For Hamilton Mountain.
Western premiers have joined Ontario and Quebec in criticizing the government's Canada Jobs Grant. The Conservative plan cuts funding from training programs that are working well, programs now helping the most vulnerable find work. Experts are calling it a, quote, deeply flawed public policy. Premiers are saying no. Will the minister now agree to stop wasting money on prematurely advertising this grant and instead sit down with the provinces and territories to develop a serious pan-Canadian job training program?
Honourable Parliamentary Secretary.
Mr. Speaker, and as I just said, we want to work with the provinces to shift training out of the hands of government and into the hands of employers and employees. We have serious skill shortages across this country. We're focused on making sure every Canadian has an opportunity to be trained and enter into those jobs that are available. We encourage the opposition to support these opportunities for all Canadians.
The Honourable Member for Ekidzy Bathurst. Mr. Speaker, the Public Sector Integrity Commissioner has launched an investigation into the gross mismanagement of the Conservatives with regard to ECBC. The CEO, John Lynn, is under investigation for having hired 4 people who have ties to the Minister of Defence and the Conservative Party. The requirement for bilingualism was deleted and the positions were not even posted. Why is the Minister of Defence using ECBC to find work for his cronies? The Honourable Minister of HoC.
Thank you, Mr. Speaker. We can't speak to the details of any ongoing investigation, but as soon as I became aware of these allegations, I did direct HoC officials to refer the matter to the Ethics Commissioner. Mr. Speaker, we do expect that ECBC to conduct business with integrity, with accountability, and with respect for Canadian taxpayers.
Got it. The Honourable Member for St. John South Mount Pearl.
Hiding behind the Integrity Commissioner's investigation is not a response to blatant Conservative patronage. The Enterprise Cape Breton Corporation is just the tip of the patronage iceberg. ACOA has become a home for Conservative mismanagement, a home for ethical breaches and rigged hiring processes. The Minister of Defence is playing political puppet master while hiding behind a report into Conservative patronage that his Chief of Staff, tried to whitewash. Mr. Speaker, simple question. When are the Conservatives going to stop treating Atlantic Canadians like fools?
Bravo. The Honourable Minister of National Revenue.
Mr. Speaker, ACOA is actually busy doing a lot of good work in that member's riding. What the member is alleging is completely false. Mr. Speaker, and he knows that the Public Service Commission was very clear in its report. The member obviously hasn't read that report, Mr. Speaker, because she should do before making all these ridiculous allegations. We didn't write the report, so we couldn't change something that we didn't write.
The Honourable Member for Lac Saint-Louis.
Mr. Speaker, yesterday evening during the hockey playoffs, Canadian taxpayers had no choice but to watch 3 ads that were paid for out of their own taxpayers' money and sponsored by the Conservative government. We're talking about $420,000. Mr. Speaker, instead of forcing taxpayers to pay for advertising campaigns promoting programs that are not even going to exist until long negotiations have taken place with the provinces, and the provinces have said that they're not even interested. Why don't they spend for real training for workers who want to reclassify today?
Resources.
Mr. Speaker, the government has the responsibility to inform Canadians about programs that are available to them. For example, this year, the government is implementing new measures to help Canadians, including the Canada Jobs Grant, to help Canadians receive training for better jobs.
Ensure Canadians have jobs, and that's exactly what we're doing, what our program is doing.
Member for Vancouver Quadra.
Mr. Speaker, so the government is advertising during the Stanley Cup playoffs for a Canada Job Grant program that doesn't exist and likely never will. That's like sending out birth announcements for a baby that not only hasn't been conceived, but the hoped-for partners that you wanted to have the baby with have already turned you down. At $140,000 a pop, some of the most expensive TV time available, these are very pricey birth announcements. My question, what is the total ad budget for this phantom job grant program, and why this abuse of the public purse?
Honourable Parliamentary Secretary to the Minister of Human Resources.
Thank you very much, Mr. Speaker. As I've said before, we want to work with the provinces to make sure that training dollars are put in the hands of employers and employees. We're focused on making sure that we're creating jobs for Canadians, unlike the Liberal leader who's focused on himself. In fact, in April of 2012, he took $20,000 from Literacy for Life. We're focused on making sure that charities receive. I encourage the Liberal leader to follow the example of our Prime Minister, who donated generously when he was a backbencher. He should be ashamed of himself.
The Honourable Member for Hochelaga. Mr. Speaker, Prince Edward Island has just put forward a proposal to enhance pension plans, but the Minister of Finance does not seem interested. He can't even free up a few hours in his schedule to hold this meeting that he has been promising for 6 months in order to make progress on CPP and QPP reform. Instead of taking advantage of photo ops at the Guinness Museum in Dublin, why doesn't the minister take the time to meet with his provincial counterpart?
The Honourable Minister of State for Finance.
Well, thank you, Mr. Speaker, and we do continue to meet with our provincial counterparts because we share the jurisdiction on Canada Pension Plan with them, Mr. Speaker. And that honourable member should understand that the last time that we met, in fact, the last 3 times that we met with the provincial finance ministers, there was not consensus amongst those ministers to move forward with any expansion of Canada Pension Plan. In fact, the Canadian Federation of Independent Business actually encouraged us not to move forward with expansion of the Canada Pension Plan, but to actually move forward with the pooled registered pension plans, and that's what we've done.
The Honourable Member for London Fanshawe.
Well, it may have escaped their notice, but the CFIB are not the premiers of this country. Mr. Speaker, the required support among the provinces exists, and the Minister of Finance has previously stated support for enhancing CPP-QPP. Is the lack of leadership because the Minister is flip-flopping, or will he work with the provinces and set a date for this important and promised meeting?
Good question. The Honourable Minister of State for Finance.
Well, Mr. Speaker, I will repeat that it takes consensus amongst the provinces and the federal government, the finance ministers from those jurisdictions, to actually move forward with any changes to the Canada Pension Plan. There was not consensus, Mr. Speaker, in the last 3 meetings that we've had. There was not consensus to move forward. We continue to look at the Canada Pension Plan, to look at the economic indicators that might provide us the opportunity to do that. But the provinces have agreed that we should move forward with the pooled registered pension plans to provide a pension for those 60% of Canadians that are in the workforce that actually don't have a pension plan now.
Order. The Honourable Member for Edmonton Centre.
Thank you, Mr. Speaker. Over the past decade, thousands of Canada's brave men and women have deployed to Afghanistan to promote freedom, democracy, human rights, and the rule of law. That includes the honourable member from Pickering Scarborough East who served a tour of duty there, and several of us have had the honour of spending time there with our troops. Our nation is well served by these courageous individuals who have helped strengthen Afghanistan's capacity to rebuild their country and provide basic security. We helped establish security, and now, for the past 2 years, Canada has been helping train the Afghan security forces. Now the Afghan security forces are taking over responsibility for all security. Can the Minister please update this House on Canada's contribution to this significant milestone?
The Honourable Associate Minister of National Defence.
Speaker, Canadian soldiers are deploying to Afghanistan for the final rotation of Operation Attention, Canada's most recent contribution to the people of Afghanistan. The Canadian Armed Forces have done exemplary work helping Afghans rebuild their country into a nation that is more stable and secure. More than 350,000 Afghan security forces have been trained. Our efforts have not been without Canadian sacrifice, including 158 soldiers and a diplomat. Many have been injured, both physically and mentally. But these efforts have helped Afghanistan reach the significant milestones today where they are taking over the lead for their security nationwide.
Well said. The Honourable Member for York West.
Mr. Speaker, one of Canada's greatest and most celebrated strengths is its diversity. Despite this, recent cutbacks at ethnocultural television stations have caused the cancellation of more than 21 programs representing at least 12 minority language groups. Encouraging and promoting diversity in our media is a principle supported by all Canadians and a central objective of Canada's broadcasting. So I ask the Minister of Heritage, what is he going to do to ensure that the millions of Canadians who rely on that language programming that they very much enjoy, what is he going to do about it, and what is the government going to do to protect their interests and their rights?
The Honourable Minister of Canadian Heritage.
An important principle and an important question. Our government has created the Canada Media Fund. That's what we're doing. $100 million every single year to support the diversity of Canada's broadcast system. $100 million. And by the way, under the previous Liberal government, there was the Canada Television Fund and the Canada New Media Fund. We merged them together. We created the Canada Media Fund together. And it's $100 million every year, not sunsetting like the Liberals used to have with their television programs. $100 million, A-based, every single year to support Canadian broadcasting in minority languages across the country, in both of Canada's official languages, in every region of the country. Canada Media Fund, A-based, as part of our cultural infrastructure now forever. It was the first announcement that I made as Canadian Heritage, and we're proud to support.
The Honourable Member for Windsor West.
Mr. Speaker, at Blue Water Bridge Canada, former managers were paid over $650,000 in severance, and the CEO who approved this move, he was reappointed by the Minister of Foreign Affairs. The Integrity Commissioner found this affair to be, quote, gross mismanagement of public funds and breach of the Code of Conduct. And now we learn the people who blew the whistle have been fired. Why is the minister allowing this abuse of public funds, and will he give these brave whistleblowers their jobs back?
Honourable Parliamentary Secretary to the President of the Treasury.
We want employees to feel safe bringing forward concerns about wrongdoing in the public service. We put in place tough rules following 13 years of Liberal scandals and mismanagement. That's precisely why we put in place this legislation, which gives employees option to report their concerns and imposes consequences for individuals that fail to play by the rules.
Good. The Honourable Member for Nipissing Timiskaming.
Mr. Speaker, while the leader of the NDP drives recklessly around the hill and tries to intimidate RCMP members, and the member for Timmins, James Bay, refers to female RCMP members as meter maids, our government is standing up for frontline law enforcement. By contrast, our Conservative government has consistently taken steps to ensure that our frontline police officers have the tools they need to do the job. Could the Minister of Public Safety please update this House on our government's policies with respect to law enforcement?
Great question.
The Honourable Minister of Public Safety.
Mr. Speaker, the NDP leader's true colours were on display last week. In a stunning display of elitism, he demanded special treatment from law enforcement based on his position. And when he didn't receive it, he made threats at the female RCMP member who had confronted him. And not to be outdone, the member from Timmins, James Bay, dismissively said that this female RCMP member was nothing more than a meter maid. Our government has listened to law enforcement and has passed numerous laws to keep our streets and communities safe. The NDP seem to have opposed these measures simply due to their own lack of respect for those who daily put their lives on the line to keep us safe.
The Honourable Member for Nickel Belt.
Mr. President, the previous member who asked a question maybe should concentrate on issues in his writing.
Mr. Speaker, Francophones in minority language communities receive aid from the federal government. The Official Languages Roadmap is intended to support official language minority communities, but the problem is that the funding intended for training Francophone immigrants outside Quebec is used to offer English courses. Can the minister assure us that this money will be used to help Francophones outside Quebec? The Honourable Minister of Canadian Heritage. Mr. Speaker, one of the purposes of the Official Languages Roadmap is to protect Francophones in minority communities and English as well. We want to ensure that training is there, the investments are there for Francophones outside Quebec and in my region of BC as well.
That the Roadmap for Canada's official languages is about supporting and encouraging Canadians to understand and better speak both of Canada's official languages. And it's true for a lot of new Canadians, for example, in the city of Vancouver, they're struggling to learn either of Canada's official languages, so we do have funding available if they wish to learn to speak French or English. We want to support both of Canada's official languages being taught and understood better by Canada's new immigrants.
The honourable member for Edmonton, St. Albert.
Thank you, Mr. Speaker. Mr. Speaker, the Alberta economy is the engine of economic growth for Canada. With an unemployment rate of less than 4.4%, temporary foreign workers are simply a reality for many Alberta employers. The Minister of Citizenship and Immigration knows, and in fact he said publicly, that when the Royal Bank attempted to use the TFW program to outsource 45 information technology positions, they were doing so illegally and offside the existing rules of the program. So my question is, why did the government overreact by changing the rules, making the program more expensive and difficult to access, simply than enforcing the rules against outsourcing?
The Honourable Parliamentary Secretary to the Minister of Human Resources. Order. The Honourable Order. The Honourable Parliamentary Secretary. Order. The Honourable Parliamentary Secretary to the Minister of Human Resources, I think, would like to answer the question. Order, please.
Thank you very much, Mr. Speaker. Our government has introduced reforms to the temporary foreign worker program so that Canadians always come first in line for every advantage. That is what we're focused on and will continue to be focused on. Our reforms strengthen compliance and oversight to ensure that the program is being used as it is intended, to make sure Canadians are first in line and that when there are absolute shortages, the temporary foreign workers are available. Inspections will be conducted when necessary for businesses taking into account, but it's no surprise the opposition doesn't think that greater oversight is actually required and supports this because the opposition continue to ask for temporary foreign workers in their own ridings.
That concludes question period for today. The Honourable Member for Saanich Gulf Islands has a point of order.
Thank you, Mr. Speaker. I raised this point of order some time ago, but what appears to be, certainly in terms of the tradition and the principles behind the Standing Order 31 rule, that it allows members of Parliament to raise issues of concern to their constituents. I think it was many months ago now, Mr. Speaker, they were increasingly used for crass partisan purposes, and now they're increasingly used for personal attacks. I'm wondering, Mr. Speaker, you said you might consider it at some point rule on it. Perhaps over the summer you could give it some thought and we could start in the fall with some guidance on this position.
I thank the Honourable Member for Saanich Gulf Islands. I will take a look at today's SO31s and, if necessary, come back to the House. Pursuant to an order made on Wednesday, May 22nd, 2000... Oh, sorry. The Honourable Member for Prince Edward Hastings is rising on a point of order.
Well, thank you, Mr. Speaker, and certainly I heard the comment from the member from Saanich Gulf Islands, and I do take offence to that. And the reason I take offence to that, but I stand in this place and I'm critical of any person, my own party or another member of Parliament, to suggest that I'm not doing it because it doesn't matter to my riding. $15,000 came from my riding to a person that shouldn't have went. That is wrong.
we're certainly not going to get into a debate through points of orders on SO31 that I have yet to review. So we'll move on, I think, to the vote now. Pursuant to an order made on Wednesday, May 22nd, 2013, the House will now proceed to the taking of the deferred recorded divisions on the motions at report stage of Bill C-49. Call in the members. The question is on motion number 1. A vote on this motion also applies to motions number 2 to 15. Order. Monsieur Nantel.
Mr. Nantel, seconded by Mr. Dubé, moved that Bill C-49 be amended by deleting Clause 1.
In favor of the motion will please rise.
Mr. Cullen.
Mr. Cullen.
Madame Day.
Madame
Mr.
Day.
Alan Wellen.
Mr. Alan Wellen.
Mr. Godin.
Mr. Godin.
Ms. Chow.
Ms. Chow.
Mr. Dewar.
Mr. Dewar.
Mr. Harris St. John's East.
Mr. Harris St. John's East.
Ms. Leslie.
Ms. Leslie.
Ms. Davies, Vancouver East.
Ms. Davies, Vancouver
Mr. Christopherson.
Mr. Christopherson.
Mr. Julian.
Mr. Julian.
Ms. Crowder.
Ms. Crowder.
Mr. Davies, Vancouver Kingsway.
Mr. Davies, Vancouver
Kingsway. Ms. Matheson.
Ms. Matheson.
Ms. Duncan, Edmonton, Strathcona.
Ms. Duncan, Edmonton, Strathcona.
Madame Perrault.
Madame Perrault.
Mr. Martin.
Mr. Martin.
Madame Ayala.
Madame Ayala.
Mr. Bevington.
Mr. Bevington.
Madame Moore-Abitibi-Témiscamingue.
Madame Moore-Abitibi-Témiscamingue.
Mr. Massey.
Mr. Massey.
Mr. Donnelly.
Mr. Donnelly.
Ms. Sims, Newton North Delta.
Ms. Sims, Newton North Delta.
Madame Leblanc-Lassalle-Mar.
Madame Leblanc-Lassalle-Mar.
Mr. Kelway.
Mr. Kelway.
Madame Brosseau.
Madame Brosseau.
Madame Grosguet.
Madame Grosguet.
Madame Turmel.
Madame Turmel.
Ms. Charlton.
Ms. Charlton.
Mr. Chisholm.
Mr. Chisholm.
Mr. Angus.
Mr. Angus.
Mr. Marston.
Mr. Marston.
Madame Hughes.
Madame Hughes.
Monsieur Dubé.
Monsieur Dubé.
Madame Laverdière.
Madame Laverdière.
Mr. Scott.
Mr. Scott.
Mr. Cash.
Mr. Cash.
Mr. Stewart.
Mr. Stewart.
Mr. Garrison.
Mr. Garrison.
Monsieur Ravignac.
Monsieur Ravignac.
Madame Blanchette-Lamotte.
Madame Blanchette-Lamotte.
Monsieur Aubin.
Monsieur Aubin.
Mr. Harris Scarborough Southwest.
Mr. Harris Scarborough Southwest.
Madame Boutin-Sweet.
Madame Boutin-Sweet.
Monsieur Saganache.
Monsieur Saganache.
Monsieur Caron.
Monsieur Caron.
Madame Péclet.
Madame Péclet.
Monsieur Gravel.
Monsieur Gravel.
Mr. Rafferty.
Mr. Rafferty.
Monsieur Maille.
Monsieur Maille.
Mr. Thibault.
Mr. Thibault.
Monsieur Larose.
Monsieur Larose.
Monsieur Giguère.
Monsieur Giguère.
Monsieur Côté.
Monsieur Côté.
Monsieur Genet-Jourdain.
Monsieur Genet-Jourdain.
Monsieur Lapointe.
Monsieur Lapointe.
Monsieur Choquette.
Monsieur Choquette.
Monsieur Rousseau.
Monsieur Rousseau.
Madame Lou.
Madame Lou.
Mr. Sandou.
Mr. Sandou.
Madame Sella.
Madame Sella.
Madame Quash.
Madame Quash.
Mr. Rankin.
Mr. Rankin.
Mr. Tsabaïsen.
Mr. Tsabaïsen.
Monsieur Nantel.
Monsieur Nantel.
Madame Freeman.
Madame Freeman.
Monsieur Nichols.
Monsieur Nichols.
Madame Michaud.
Madame Michaud.
Mr. Comartin.
Mr. Comartin.
Mr. Atamanenko.
Mr. Atamanenko.
Monsieur Jacob.
Monsieur Jacob.
Monsieur Nunez-Melo.
Monsieur Nunez-Melo.
Monsieur Tremblay.
Monsieur Tremblay.
Monsieur Chiquan.
Monsieur
Monsieur
Chiquan.
Dion Labelle.
Monsieur Dion Labelle.
Mr. Cleary.
Mr. Cleary.
Monsieur Morin-Chicoutimi-Lefiard.
Monsieur Morin-Chicoutimi-Lefiard.
Madame Doré-Lefebvre.
Madame Doré-Lefebvre.
Madame Morin-Notre-Dame-de-Grâce-Lachine.
Madame Morin-Notre-Dame-de-Grâce-Lachine.
Monsieur Pilon.
Monsieur Pilon.
Madame Reynaud.
Madame Reynaud.
Monsieur Genet.
Monsieur Genet.
Mr. Benskin.
Mr. Benskin.
Monsieur Morin-Laurentide-Labelle.
Monsieur Morin-Laurentide-Labelle.
Mr. Goodale.
Mr. Goodale.
Monsieur Leblanc-Beauséjour.
Monsieur Leblanc-Beauséjour.
Mr. Macaulay.
Mr. Macaulay.
Mr. Easter.
Mr. Easter.
Ms. Fry.
Ms. Fry.
Mr. Regan.
Mr. Regan.
Monsieur Bélanger.
Mr. Bélanger.
Mr. Pichetti.
Mr. Pichetti.
Ms. Foote.
Ms. Foote.
Mr. Lamoureux.
Mr. Lamoureux.
Mr. Byrne.
Mr. Byrne.
Mr. Bryson.
Mr. Bryson.
Mr. McKay-Scarborough-Gilwood.
Mr. McKay-Scarborough-Gilwood.
Mr. Cosner.
Mr. Cosner.
Mr. Iking.
Mr. Iking.
Monsieur Garneau.
Monsieur Garneau.
Ms. Gros.
Ms. Gros.
Mr. Scarpalagia.
Mr. Scarpalagia.
Mr. Sims Bonavista Gander Grand Falls Windsor.
Mr. Sims Bonavista Gander Grand Falls Windsor.
Ms. Murray.
Ms. Murray.
Ms. Duncan Etobicoke North.
Ms. Duncan Etobicoke
Mr.
North.
Valeriot.
Mr. Valeriot.
Mr. Chou.
Mr. Chou.
Mr. Casey.
Mr. Casey.
Ms. Jones.
Ms. Jones.
Madame Saint-Denis.
Madame Saint-Denis.
Monsieur Plamondon.
Monsieur Plamondon.
Madame Mourani.
Madame Mourani.
Monsieur Fortin.
Monsieur Fortin.
Ms. May.
Ms. May.
All those opposed to the motion will please rise.
Mr. Fletcher.
Mr. Fletcher.
Mr. Fantino.
Mr. Fantino.
Monsieur Valcourt.
Mr. Valcourt.
Mr. Taves.
Mr.
Mr.
Taves.
Nicholson.
Mr. Nicholson.
Mr. Van Loan.
Mr. Van Loan.
Monsieur Paradis.
Monsieur Paradis.
Mr. Moore, Port Moody, Westwood, Pocahontas.
Mr. Moore, Port Moody, Westwood, Pocahontas.
Mrs. Aglukac.
Mrs. Aglukac.
Mrs. Shea.
Mrs. Shea.
Mr. Kent.
Mr. Kent.
Monsieur Blaney.
Monsieur Blaney.
Miss Finley, Delta Richmond East.
Miss Finley, Delta Richmond East.
Mr. Duncan, Vancouver Island North.
Mr. Duncan, Vancouver Island
Mr.
North.
Hillier.
Mr. Hillier.
Mr. Benoit.
Mr. Benoit.
Mr. Brightchrist.
Mr. Brightchrist.
Mr. Merrifield.
Mr. Merrifield.
Mr. Moore Fundy Royal.
Mr. Moore Fundy Royal.
Mr. Camp Pitt Meadows, Upper Ridge, Michigan. Mission.
Camp Meadows Maple Ridge Mission.
Mr. Poiliev.
Mr. Poiliev.
Mr. Lake.
Mr. Lake.
Mr. O'Brien. Mr. Dykstra. Monsieur Bernier. Mr. Gosal. Mr. Goodyear. Mr. O'Connor. Mrs. Yelich. Mrs. Wong. Mrs. Oblonsky. Mr. Menzies. Mr. Upal. Mr. Calandra. Mr. Anderson. Monsieur Gould. Mr. Carey. Mr. Katie South Shore St. Margaret. Mr. Anders. Mr. Valacott. Mr. Reed. Mrs. Gallant. Mr. Lunny. Mr. Rajat. Mr. Schellenberger. Mr. Allison. Mr. Bazan. Mr. Brownlees Granville. Mr. Hahn. Mr. Chong. Mrs. Greywall. Mr. Alexander. Ms. Rampel. Monsieur Gauguin. Mr. Del Mastro. Monsieur Lemieux. Mr. Lukiski. Ms. Bergen. Ms. Adams. Mrs. Glover. Ms. Leach. Mr. Leong. Mr. Saxton. Mr. Deckert. Ms. Brown Marketarora. Mrs. McLeod. Mr. Hebert. Mr. Jean. Mr. Komarnicki. Mr. Crown Prince Edward Hastings. Monsieur Lauzon. Mr. Mackenzie. Mr. Miller. Mr. Preston. Mrs. Smith. Mr. Tilson. Mr. Trost. Mr. Tweed. Mr. Warwa. Mr. Watson. Mr. Allen to Biknaktakwak. Mr. Brownberry. Mr. Bernouge. Mr. Calkins. Mr. Cannon. Mr. Albrecht. Mrs. Davidson. Mr. Galipo. Mr. Norlock. Mr. Shipley. Mr. Sweet. Mr. Van Kesteren. Mr. Wallace. Mr. Walkington. Mr. Clark. Mrs. Block. Mr. Bowen. Mr. Braid. Mr. Dreeshen. Mr. Holder. Mr. Lobb. Mrs. O'Neill Gordon. Mr. Payne. Mr. Richards. Mr. Shorey. Mr. Weston St. John. Mr. Woodworth. Mr. Young Oakville. Mr. Armstrong. Mr. Sopak. Mr. Harris Caribou Prince George. Mr. Adler. Mr. Albus. Mrs. Ambler. Mr. Aspen. Madame Bateman. Mr. Butt. Mr. Carmichael. Mr. Chisu. Mr. Daniel. Mr. Gill. Mr. Hayes. Ms. James. Mr. Menegakis. Mr. Tote. Mr. Wilkes. Mr. McColman. Ms. Young, Vancouver South. Mr. Lizon. Mr. Opitz. Mr. Seaback. Mr. Strahl. Mr. Trottier. Mr. Williamson. Mr. O'Toole. Ms. Crockett. Mr. Zimmer. Mr. Stanton. Mr. DeVolen. Mr. Goldring. Mr. Rathgeber.
Yeas pour 114, 114. Nays contre 141, 141.
I declare motion number 1 defeated. I therefore declare motions number 2 to 15 defeated. Mr. Moore, Port Moody, Westwood, Port Coquitlam, seconded by Mr. O'Connor, moves that C-49, an act to amend the Museums Act in order to establish the Canadian Museum of History and to make consequential amendments to other acts, be concurred in at report stage. Is it the pleasure of the House to adopt the motion? Yes. All those in favor will please say yay. Yay! All those opposed will please say nay. I declare the yeas have it. In my opinion, the yeas have it. I don't declare it. In my opinion, the yeas have it. Okay. All those in favor of the motion will please rise.
Mr. Fletcher, Mr. Fantino, Mr. Valcourt, Mr. Taves, Mr. Nicholson, Mr. Van Loan, Mr. Paradis, Mr. Moore, Port Moody, Westwood, Port Coquitlam, Mrs. Aglukak, Mrs. Shea, Mr. Kent, Mr. Blaney, Ms. Finley, Delta Richmond East, Mr. Duncan, Vancouver Island North, Mr. Hillier, Mr. Benoit, Mr. Brightcross, Mr. Merrifield, Mr. Moore-Fundy Royal, Mr. Camp Pitt Meadows Maple Ridge Mission, Mr. Poiliev, Mr. Lake, Mr. O'Brien, Mr. Dykstra, Mr. Bernier, Mr. Gosal, Mr. Goodyear, Mr. O'Connor, Mrs. Yelich, Mrs. Wong, Mrs. Oblonsky, Mr. Menzies, Mr. Upal, Mr. Calandra, Mr. Anderson, Mr. Gould, Mr. Carey, Mr. Kitty, South Shore St. Margaret, Mr. Anders, Mr. Valacott, Mr. Reed, Mrs. Gallant, Mr. Lunny, Mr. Rajat, Mr. Schellenberger.
Mr. Schellenberger.
Mr. Allison.
Mr. Allison.
Mr. Bazan. Mr. Brownlees-Granville.
Brownlees-Granville.
Mr. Hahn.
Mr. Hahn.
Mr. Chong.
Mr. Chong.
Mrs. Graywall.
Mrs. Graywall.
Mr. Alexander.
Mr. Alexander.
Ms. Rampel.
Ms. Rampel.
Monsieur Gauguin.
Monsieur Gauguin.
Mr. Delmastro.
Mr. Delmastro.
Monsieur Lemieux.
Monsieur Lemieux.
Mr. Lukiski.
Mr. Lukiski.
Ms. Bergen.
Ms. Bergen.
Ms. Adams.
Ms. Adams.
Mrs. Glover.
Mrs. Glover.
Ms. Leach.
Ms. Leach.
Mr. Leong.
Mr. Leong.
Mr. Saxton.
Mr. Saxton.
Mr. Deckert.
Mr. Deckert.
Ms. Brown Market Aurora.
Ms. Brown Newmarket Aurora.
Mrs. McLeod.
Mrs. McLeod.
Mr. Hebert.
Mr. Hebert.
Mr. Jean.
Mr. Jean.
Mr. Komarnicki.
Mr. Komarnicki.
Mr. Crown Prince Edward Hastings.
Crown Prince Edward Hastings.
Monsieur Lauzon.
Monsieur Lauzon.
Mr. Mackenzie.
Mackenzie.
Mr. Miller.
Mr. Miller.
Mr. Preston.
Mr. Preston.
Mrs. Smith.
Mrs.
Mr.
Smith.
Tilson.
Mr. Tilson.
Mr. Trost.
Mr. Trost.
Mr. Tweed.
Mr. Tweed.
Mr. Warwa.
Mr. Warwa.
Mr. Watson.
Mr. Watson.
Mr. Allen Tubik McTaquac.
Mr. Allen Tubik McTaquac.
Mr. Brownberry.
Mr. Brownberry.
Mr. Bernouge.
Mr. Bernouge.
Mr. Calkins.
Mr. Calkins.
Mr. Cannon.
Mr. Cannon.
Mr. Albrecht.
Mr. Albrecht.
Mrs. Davidson.
Mrs. Davidson.
Mr. Galipo.
Mr. Galipo.
Mr. Norlock.
Mr. Norlock.
Mr. Shipley.
Mr. Shipley.
Mr. Sweet.
Mr.
Mr.
Sweet.
Van Kesteren.
Mr. Van Kesteren.
Mr. Wallace.
Mr. Wallace.
Mr. Warkington.
Mr. Warkington.
Mr. Clark.
Mr. Clark.
Mrs. Block.
Mrs. Block.
Mr. Bowen.
Mr. Bowen.
Mr. Braid.
Mr. Braid.
Mr. Dreeshen.
Mr. Dreeshen.
Mr. Holder.
Mr.
Mr. Lobb.
Mr. Lobb.
Mrs. O'Neill Gordon.
Mrs. O'Neill Gordon.
Mr. Payne.
Mr. Payne.
Mr. Richards.
Mr. Richards.
Mr. Shorey.
Mr.
Mr.
Shorey.
Weston West Vancouver Sunshine Coast Sea to Sky Country.
Western West Vancouver, Sunshine Coast, Sea to Sky Country.
Mr. Weston St. John.
Mr. Weston St.
Mr.
John.
Woodworth.
Mr. Woodworth.
Mr. Young Oakville.
Mr. Young
Mr.
Oakville.
Armstrong.
Mr.
Mr. Sopak.
Mr. Sopak.
Mr. Harris Caribou Prince George.
Harris Caribou, Prince
Mr.
George.
Adler.
Mr. Adler.
Mr. Albus.
Mr. Albus.
Mrs. Ambler.
Mrs. Ambler.
Mr. Aspen.
Mr. Aspen.
Madame Bateman.
Madame Bateman.
Mr. Butt.
Mr. Butt.
Mr. Carmichael.
Mr. Carmichael.
Mr. Chisu.
Mr.
Mr.
Chisu.
Daniel.
Mr. Daniel.
Mr. Gill.
Mr. Gill.
Mr. Hayes.
Mr. Hayes.
Ms. James.
Ms. James.
Mr. Menegakis.
Mr. Menegakis.
Mr. Tote.
Mr. Tote.
Mr. Wilkes.
Mr. Wilkes.
Mr. McColeman.
Mr. McColeman.
Ms. Young, Vancouver South.
Ms. Young, Vancouver South.
Mr. Lizon.
Mr. Lizon.
Mr. Opitz.
Mr. Opitz.
Mr. Seaback.
Mr. Seaback.
Mr. Straw.
Mr. Straw.
Mr. Trottier.
Trottier.
Mr. Williamson.
Williamson.
Mr. O'Toole.
Mr. O'Toole.
Ms. Crockett.
Ms. Crockett.
Mr. Zimmer.
Mr. Zimmer.
Mr. Stanton.
Mr. Stanton.
Mr. DeVolen.
DeVolen.
Mr. Goldring.
Mr. Goldring.
Mr. Rathgaber.
Mr. Rathgate.
Ms. May.
Ms. May.
All those opposed to the motion will please rise.
Mr. Cullen.
Mr. Cullen.
Madame Day.
Madame Day.
Mr. Allen Wellen.
Mr. Allen
Mr.
Wellen.
Godin.
Mr. Godin.
Ms. Chow.
Ms. Chow.
Mr. Dewar.
Mr. Dewar.
Mr. Harris St. John's East.
Harris St. John's East.
Ms. Leslie.
Ms. Leslie.
Ms. Davies, Vancouver
Ms.
East.
Davies, Vancouver.
Mr. Christopherson.
Mr. Christopherson.
Mr. Julian.
Mr.
Ms.
Julian.
Crowder.
Ms. Crowder.
Mr. Davies, Vancouver Kingsway.
Mr. Davies, Vancouver Kingsway.
Ms. Matheson.
Ms. Matheson.
Ms. Duncan, Edmonton, Strathcona.
Ms. Duncan, Edmonton, Stratford.
Madame Perrault.
Madame Perrault.
Mr. Martin.
Mr. Martin.
Madame Ayala.
Madame Ayala.
Mr. Bevington.
Mr. Bevington.
Madame Moore, Abitibi-Témiscamingue.
Moore, Abitibi-Témiscamingue.
Mr. Massey.
Mr. Massey.
Mr. Donnelly.
Mr. Donnelly.
Ms. Sims, Newton North Delta.
Ms. Sims, Newton North Delta.
Madame Leblanc, La Salemar.
Madame Leblanc, La
Mr.
Salemar.
Kelway.
Mr. Kelway.
Madame Brosseau.
Madame Brosseau.
Madame Grosguet.
Madame Grosguet.
Madame Turmel.
Madame Turmel.
Miss Charlton.
Miss Charlton.
Mr. Chisholm.
Mr. Chisholm.
Mr. Angus.
Mr. Angus.
Mr. Marston.
Mr. Marston.
Madame Hughes.
Madame
Monsieur
Hughes.
Dubé.
Monsieur Dubé.
Madame Laverdière.
Madame Laverdière.
Mr. Scott.
Mr. Scott.
Mr. Cash.
Mr. Cash.
Mr. Stewart.
Mr. Stewart.
Mr. Garrison.
Mr. Garrison.
Monsieur Ravigna.
Monsieur Ravigna.
Madame Blanchette Lamotte.
Madame Blanchette Lamotte.
Monsieur Aubin.
Monsieur Aubin.
Mr. Harris Scarborough Southwest.
Mr. Harris Scarborough Southwest.
Madame Boutin-Sweet.
Madame Boutin-Sweet.
Monsieur Saganache.
Monsieur Saganache.
Monsieur Caron.
Monsieur Caron.
Madame Péclet.
Madame Péclet.
Monsieur Gravel.
Monsieur Gravel.
Mr. Rafferty.
Mr. Rafferty.
Monsieur Maille.
Monsieur Maille.
Mr. Thibault.
Mr. Thibault.
Monsieur Larose.
Monsieur Larose.
Monsieur Giguère.
Monsieur Giguère.
Monsieur Côté.
Monsieur Côté.
Monsieur Genet-Jourdain.
Monsieur Genet-Jourdain.
Monsieur Lapointe.
Monsieur Lapointe.
Monsieur Choquette.
Monsieur Choquette.
Monsieur Rousseau.
Monsieur Rousseau.
Madame Lou.
Madame Lou.
Mr. Sandou.
Mr. Sandou.
Madame Sella.
Madame Sella.
Madame Quash.
Madame Quash.
Mr. Rankin.
Mr. Rankin.
Mrs. Sabaïson.
Mrs. Sabaïson.
Monsieur Nantel.
Monsieur Nantel.
Madame Freeman.
Madame Freeman.
Monsieur Nichols.
Monsieur Nichols.
Madame Michaud.
Madame Michaud.
Mr. Comartin.
Mr. Comartin.
Mr. Atamanenko.
Mr. Atamanenko.
Monsieur Jacob.
Monsieur
Monsieur
Jacob.
Nunez Melo.
Monsieur Nunez
Monsieur
Melo.
Tremblay.
Monsieur Tremblay.
Monsieur Chiquan.
Monsieur
Monsieur
Chiquan.
Dion Labelle.
Monsieur Dion
Mr.
Labelle.
Cleary.
Mr. Cleary.
Monsieur Morin-Chicoutimi-Lefiard.
Monsieur Morin-Chicoutimi-Lefiard.
Madame Doré-Lefebvre.
Madame Doré-Lefebvre.
Madame Morin, Notre-Dame de Grâce-Lachine.
Madame Morin, Notre-Dame de Grâce-Lachine.
Monsieur Pilon.
Monsieur Pilon.
Madame Reynaud.
Madame Reynaud.
Monsieur Genet.
Monsieur Genet.
Mr. Benskin.
Mr. Benskin.
Monsieur Morin, Laurentier de Labelle.
Monsieur Morin, Laurentier de Labelle.
Mr. Goodale.
Mr. Goodale.
Monsieur Leblanc Beauséjour.
Monsieur Leblanc Beauséjour.
Mr. McCauley.
Mr.
Mr. Easter, Ms. Fry, Mr. Regan, Monsieur Bélanger, Mr. Pichetti, Ms. Foote, Mr. Lamoureux, Mr. Byrne, Mr. Bryson, Mr. McKay-Scarborough-Guildwood, Mr. Cosner, Mr. Eiking, Monsieur Garneau, Ms. Gros, Mr. Scarpaleggia, Mr. Sims Bonavista, Gander Grand Falls, Windsor, Ms. Murray, Ms. Duncan Etobicoke North, Mr. Valeria, Mr. Chou, Mr. Casey, Ms. Jones, Madame Saint-Denis, Monsieur Plamondon, Madame Mourani, Monsieur Fortin.
pour 143, 143. Nays contre 113, 113, 113.
I declare the motion carried. When shall the bill be read a third time? At the next sitting of the House. I am now prepared to rule on the question of privilege raised on June 5, 2013 by the Honourable Member for Avalon, and again today by the Honourable Member for Beausejour, regarding the right of the members for St. Boniface and Selkirk-Interlake to continue to sit and vote in the House. I
would like to thank the Honourable Member for Avalon for having raised this matter, as well as the Honourable Leader of the Government in the House of Commons and the members for Toronto-Danforth, Winnipeg North, Selkirk-Interlake, and St. Boniface for their comments.
In his question of privilege, the member for Avalon focused on the situation of the members for St. Boniface and Selkirk-Interlake who had failed to correct their electoral campaign returns by a specified date as required by the Chief Electoral Officer, pursuant to subsection 457(2) of the Canada Elections Act. Accordingly, he argued, pursuant to subsection 463(2) of the same Act, the members no longer had the right to continue to sit or vote in the House. While acknowledging that both members had made applications to the courts on this matter, he claimed that a review by the courts does not provide relief from section 463 of the Act, arguing that the members, quote, should not sit or vote in the House until the matter is rectified, either by Elections Canada or by the federal court, unquote.
Furthermore, the member for Avalon argued that only the House, and neither the courts nor the Speaker, possessed the authority to determine the right of any member to sit and vote in the House. In response, the Government House Leader described the situation in each case as a dispute about the interpretation of accounting practices, one which did not justify the suspension of duly elected members from participating in the proceedings of the House. It was also added that one that he found to have been raised prematurely, and he saw no merit in asking the chair to intervene prior to the conclusion of relevant court proceedings.
The Government House Leader held that the members currently have two options, either to submit returns that comply or to file an application with the courts, with suspension from the House being the consequence only if a member failed to choose one of the available options. Thus, he claimed that to accept the interpretation that these members could not continue to sit or vote would effectively remove a member's right to seek redress through the courts and grant Elections Canada an inordinate, albeit unintended, power. On June 7, 2013, the members for Selkirk-Interlake and St. Boniface intervened. Each agreed that the matter was a disagreement with Elections Canada as to accounting interpretations applicable to certain expenditures, and each stated that pursuant to Section 459 of the Canada Elections Act, they had filed applications with the Manitoba Court of Queen's Bench. Each member argued that this put into abeyance the provisions of subsection 463(2) of the Act regarding what would amount to suspensions from the House.
Given that the matter is currently before the courts and that they are both party to court proceedings, both members invoked the sub judice convention, arguing that any debate or decision on the matter outside the court would prejudice their interests in the court proceedings. Before I begin to outline the complex issues with which we are all grappling, allow me to review for the House the sequence of events that have led us to where we are today.
Its review processes undergone by the members for St. Boniface and Selkirk-Interlake began some time ago. For our purposes, the issue arose on May 23rd and May 24th, when I received letters from the Chief Electoral Officer informing me of the status of the respected cases involving the two members. The letters both contain a reference to the relevant section of the Canada Elections Act and close with the following sentence, quote, "In the event that the corrected returns or an application to a court is subsequently filed, I will advise accordingly," unquote. On May 24th, the Chair learned that both members had filed applications to the Manitoba Court of Queen's Bench in relation to these matters. Perhaps I should explain that immediately on receipt of the first letter from the Chief Electoral Officer, I sought the advice of the clerk and the law clerk. Neither were aware of any precedent, and both undertook further research, after which they confirmed that the situation is indeed unprecedented. However, it was only on June 4th, having by then been informed as well that the two applications in question had been filed, that the Chief Electoral Officer could himself notify me officially by letter of the two applications. Ainsi,
Thus, it was only after these events and following media reports regarding the existence of these letters that on June 5th, the Honourable Member for Avalon rose in the House on a question of privilege to argue the case. Other members have intervened in the matter, and that has led us to this ruling today. After the intervention by the member for Avalon, the member for Saint-Léonard-Saint-Michel raised a related issue on June 6th, arguing that the Speaker ought to table the letters from the Chief Electoral Officer in the House.
On Friday, June 7th, to address the matter of the House being notified on the situation. I stated that I was not prepared to table the letters at that time. Since there was no provision to deal with letters of that nature, and since I was currently considering the entire matter, I believed it would be appropriate to wait and address all aspects of the situation in a comprehensive ruling. It seems evident to the Chair that the lack of a clear process, either for me or for the House, in matters of this nature leaves us all in a complicated situation. As Speaker, I must be mindful of my duty to protect the rights of individual members, while at the same time balancing that responsibility with the responsibility to ensure, as the servant of the House, that I protect its exclusive right to deal with matters affecting the collective privileges of the House. In the present circumstances, this is no small challenge. Le droit
The right, in fact, the absolute need for members to be able to sit and vote in the House is so integral to their ability to fulfill their parliamentary duties that it would be difficult for the Chair to overstate the importance of this issue to members individually and to the House as a whole. Page 245 of House of Commons Procedure and Practice, 2nd edition, states, and I quote, "The determination of whether a member is eligible to sit and vote is a matter affecting the collective privileges of the House," unquote.
For Selkirk Interlake reminded the House of Commons Procedure and Practice at page 307 states, "It is the responsibility of the Speaker to act as the guardian of the rights and privileges of members and of the House as an institution," unquote. In my view, this is especially important in the case before us today because of the potential infringement on the rights of certain members individually and on the rights of the House collectively. Lorsqu'elle s'acquitte de cette
In fulfilling this responsibility, it is incumbent upon the Chair to remind the House of the limited role assigned to the Speaker in matters with legal implications. Simply put, the Speaker's role is to determine procedural issues, not matters of law, for which the courts are to decide.
Specific course of action, for example, to table a document or to hold off on taking action while an appeal to the courts is ongoing, the Chair governs itself accordingly. But where, to a lay reader, related provisions of a statute are categoric in stating, as Section 463(2) does in this case, that a particular consequence applies, and is silent as to any mitigating effect of an application to the court for relief from that consequence, then the Chair must heed this reality. Cela dit, O'Brien et Bosque.
That being said, O'Brien and Bosque states at page 259 that, quote, "In the case of statutory provisions, the House of Commons endeavours to ensure that its standing orders and practices are consistent with statutes while retaining the exclusive jurisdiction to determine whether the provisions of a statute apply to its proceedings," unquote.
It also states that, quote, "Since the House has the exclusive jurisdiction to determine whether and how a statute applies to its proceedings, there may be extraordinary situations when the House determines that a statutory provision ought not to apply," unquote. To answer this question of how a statute might apply to House proceedings, the member for Avalon looked to a ruling given by Speaker Lamoureux on March 1st, 1966 for guidance. In it, he found evidence that it is indeed the House, and the House alone, that retains the sole authority to determine when members of Parliament may sit and vote in the House. At page 1940 of the debates, Speaker Lamoureux stated, quote, "The House is still the sole judge of its own proceedings, and for the purpose of determining on a right to be exercised within the House itself, which in this particular case is the right of one honourable member to sit and to vote, the House alone can interpret the relevant statute," unquote. However, does this mean that the House should therefore be seized with this matter immediately in order to pronounce itself on the substantive issue, as several members seemed to suggest? Let us consider that question. House of Commons Procedure and Practice, 2nd edition, at pages 244 and 245, states, quote, "Once a person is elected to the House of Commons, there are no constitutional provisions and few statutory provisions for removal of that member from office. The statutory provisions rendering a member ineligible to sit or vote do not automatically cause the seat of that member to become vacant. By virtue of parliamentary privilege, only the House has the inherent right to decide matters affecting its own membership. Indeed, the House decides for itself if a member should be permitted to sit on committees, receive a salary, or even be allowed to keep his or her seat, unquote. Borno's Parliamentary Procedure and Practice, 4th edition, at page 64, reads as follows, quote, "The right of a legislative body to suspend or expel a member for what is sufficient cause in its own judgment is undoubted. Such a power is absolutely necessary to the conservation of the dignity and usefulness of a body," unquote. Thus, I believe there is no dispute that it is up to the House as a whole and not for the Speaker ultimately to decide if one of its members should continue to sit and vote. Bien que nous puissions tirer...
Well, there may admittedly be some lessons to be drawn from the 1966 case. I must point out that the circumstances facing Speaker Lamoureux in 1966 were markedly different.
...inform the House of a judgment on the case at issue. This reference may be found in the debates for February 28, 1966, at page 1843. As members who visit that reference will find, it appears that in the 1966 case, the legal process was at an end, and the member whose right to sit and vote had been questioned had been cleared to sit and vote. By contrast, in the case before us today, applications have been filed, as all honourable members know, although court hearings have yet to begin. With these considerations in mind, the Chair must determine a way forward for the House that respects and safeguards its rights and privileges. To be sure, the arguments presented have revealed just how rare it is that the Chair is asked to pronounce itself on an issue of such deep significance and with such potential consequences, yet with so few precedents to guide it. The question of the processes that ought to be followed in cases of this kind is of critical importance and is one which the Chair believes the House ought to clarify. The current situation and the various interventions on the matter points to a serious gap in our procedures here in the House in cases where an impasse is reached in a dispute between a member and Elections Canada. The Canada Elections Act provides that the Chief Electoral Officer inform the Speaker when key milestones have been reached in the course of a dispute. Thus, as I explained earlier, I received a letter from the Chief Electoral Officer informing me that a member had not complied with his request for corrections and informing me of the suspension provision of the Act applicable in the circumstances. And while elsewhere in the Act there are provisions for a member in those circumstances to apply to the courts for relief, the Act is silent on the effect of such an appeal on the suspension provision. I am not the only one left with questions about how to respond to this situation. Some argue that the provisions in subsection 463(2) demand immediate action, namely the suspension of a member who has not complied with the Chief Electoral Officer in his application of subsection 457(2) of the Canada Elections Act, even as they acknowledge that there is no procedure for operationalizing such a suspension. Others hold that since the Canada Elections Act provides for an application for relief from the provision in subsection 457(2), any suspension is held in abeyance until the court makes its decision. We can all agree, however, that this silence is in sharp contrast to the statutory processes contained in Part 20 of the Canada Elections Act with regard to contested elections, described in O'Brien and Bosca pages 193 to 195. In those cases, subsection 531(3) of the statute provides that the clerk of the court shall inform the Speaker of the decision of the court and whether or not an appeal has been filed. The statute is very clear about the Speaker's duties. Quote, "Except when an appeal is filed under subsection 532(1), the Speaker of the House of Commons shall communicate the decision to the House of Commons without delay." Unquote. If there is an appeal to the Supreme Court, then the Speaker awaits the decision of that court, which its registrar must communicate to him. Here again, the Canada Elections Act is very clear. Once in possession of that decision, quote, "The Speaker of the House of Commons shall communicate the decision to the House of Commons without delay," unquote. But in the case before us, the Speaker is given no such direction, and there are no precedents to be guided by. I will therefore respond to the situation as fairly as I can, trying to maintain an equilibrium between the rights of the House as a whole and the rights of the individual members. For make no mistake, any member, any one of us, could potentially be in such a predicament. This highlights all the more vividly the importance of my duty to safeguard the rights of each and every member and of my potential inability to do so without the proper mechanisms in place. So in the absence of statutory guidance, should a standing order mechanism be developed to guide the Chair in such cases? To answer that question, I believe it would be helpful to the whole House and to me as Speaker if the Standing Committee on Procedure and House Affairs were to examine the issue with a view to incorporating in our standing orders provisions on how the Chair and the House ought to deal with such matters in the future. The committee might begin by looking at the lack of a clearly defined process for communications on these matters between the Chief Electoral Officer and the Speaker, and between the Speaker and the House. This would fall squarely within the mandate of this committee, which is charged, pursuant to Standing Order 1083, with, quote, the review of and report on all matters relating to the election of members to the House of Commons, unquote. If the committee were to proceed in this manner, the Chair believes that the sub judice convention would not be breached, as the deliberations would not reach into the substance of the disputes themselves. Rather, they would focus on the processes which the Speaker could follow in these cases while remaining true to his fundamental duty as Speaker to act as the guardian of the individual rights and privileges of each member while safeguarding the rights and privileges of the House as an institution. Cela serait conforme à
This would be in keeping with the ruling made by Speaker Sauvé on March 22, 1983, in which he stated that, and I quote, the sub judice convention has never stood in the way of the House, considering a prima facie matter of privilege vital to the public interest or to the effective operation of the House and its members, unquote.
Remarking that he had a certain appreciation of the Speaker's position in the absence of any guidance at all, either from the statute or from the standing orders, as to how to execute the provisions of Section 463(2) of the Act, the member for Toronto Danforth came to a conclusion with which I can entirely agree, namely, this Honourable House cannot function without the Speaker and the House as a whole working in concert. Il me paraît évident.
It seems evident to me that the lack of a clear process is not satisfying the needs of the House, nor indeed of the individual members concerned. As always, in deciding on questions of privilege, the Speaker's role is well defined. Some might even say constrained, as it is limited to determining if, at a first glance, the matter appears to be of such significance as to warrant priority consideration over all other House business.
Circumstances are significantly different from those of the 1966 case relied upon by the Honourable Member for Avalon. However, the Chair is faced with the fact that some have argued that it is just and prudent to continue to await the conclusion of legal proceedings, while others have maintained the two members ought even now not be sitting in the House. I believe that the House must have an opportunity to consider these complex issues. This approach is founded on an ancient practice summarized in a section of Bourneau's 4th edition, found at pages 161 and 162 of that work, where it states, quote, in the Canadian as in the English House of Commons, whenever any question is raised affecting the seat of a member and involving matters of doubt, either in law or fact, it is customary to refer to the consideration of a committee. Accordingly, the Chair has concluded that there is a prima facie case of privilege here. I would now like to return to the issue of the letters that I have received from Elections Canada on these cases. As I said before, the Speaker generally tables documents in accordance with statutory requirements or the standing orders. Outside of the sorts of documents enumerated in O'Brien and Bosk at pages 435 and 436, the Chair is not aware of any precedent or practice that would suggest that letters to the Speaker, even letters from an officer of Parliament, are de facto letters to the House, as has been suggested. Cependant, je ne peux pas.
However, I cannot logically come to the conclusion that this situation warrants immediate consideration by the House without also ensuring that the House has access to the letters of the Chief Electoral Officer to me on the situation. The Chair would welcome recommendations from the Standing Committee on Procedure and House Affairs and the House's clear directions on how these issues might be handled in the future.
Meanwhile, I will make available the letters I received from the Chief Electoral Officer informing me of the applications of the provisions of subsection 436(2) of the Canada Elections Act, and the letters I received informing me that applications to the courts had been made for relief of these provisions. I am also prepared to make available correspondence that I might receive from the Chief Electoral Officer in future cases that may arise in like circumstances. I also wish to advise the House that just today I have received a letter from the Chief Electoral Officer informing me that the member for St. Boniface has since provided a corrected return as required by the Canada Elections Act. In summary, then, to bring clarity to the situation at hand and to give the House a voice on the matter and to seek its guidance, the Chair has concluded that immediate consideration of the matter by the House is warranted. In view of the circumstances brought to the attention of the House regarding the situation of the member for Avalon, I now invite the member for Beausejour, who has raised an identical question of privilege, to move the appropriate motion.
Thank you, Mr. Speaker. Based on your ruling of a prima facie case of privilege, I move, seconded by the member for Wascana, that the matter of the question of privilege raised by the member from Avalon be referred to the Standing Committee on Procedure and House Affairs.
Mr. LeBlanc, seconded by Mr. Goodale, moves that the matter of the question of privilege raised by the member from Avalon be referred to the Standing Committee on Procedure and House Affairs. Debate. The honourable member for Beausejour.
Merci.
Thank you very much, Mr. Speaker. Obviously, I would like to begin by thanking you for the study that you have done on this very important matter. Clearly, you have closely examined precedent and
à cette question.
And we would like to thank you for the attention that you have given to this.
Your ruling makes it clear. This is not an easy situation and one for which not many precedents exist. I think you have given a great deal of merit to the question of privilege raised by my colleague from Avalon. You have obviously given a great deal of attention to the interventions from other colleagues on this question of privilege, and for that, Mr. Speaker, I thank you profoundly. The issue has been, Mr. Speaker, and continues to be from our perspective, the issue of members of Parliament having earned the right to take their seats in this House. Those of us that are privileged enough to represent our constituents in this great democratic assembly, I think also have the obligation to arrive in this place having followed every single section and every principle and every precedent of the Canada Elections Act and the various court cases over the years that have interpreted the application of Canada's electoral legislation. C'est un concept, Monsieur le Président, qui est en...
That is a concept, Mr. Speaker, that is quite simple. All voters have the right to vote in a fair election, and the person with the largest number of votes wins the privilege of representing his or her constituents in the House of Commons. However, Mr. Speaker, the election itself must be a fair one, and it must be fair for all parties and all candidates who run. When a candidate chooses to flout the rules of the election law, the vote is by definition unfair, and it is our democracy then that pays the price.
I think, and I agree with you, that the Procedure and House Affairs Committee of the House of Commons is the place for members to properly understand the application of the Elections Act and also the rights and privileges of members of this House to sit and debate and vote with colleagues who arrived here having followed all of the prescriptions of the Canada Elections Act. But I think it would be instructive, Mr. Speaker, because as we begin a debate on this very important matter, I would like you and all colleagues to be reminded, as my colleague from Avalon had raised, of Section 463, subsection 2 of the Canada Elections Act, which says an elected candidate who fails to provide a document as required by Section 451 or Section 455, or fails to make a correction as requested under Section 457, subsection 2, or authorized by Section 458, subsection 1, shall not continue to sit or vote as a member until they are provided or made as the case may be. Now, Mr. Speaker, I would draw your attention to the words shall not. The legislation from our perspective, Mr. Speaker, is unambiguous. It is prescriptive. It doesn't say may not. It doesn't say might not. It says shall not. And that's why, Mr. Speaker, you were in the difficult position of having to reconcile that section of our election legislation with other sections that provide for other offences or other non-compliance measures an opportunity to seek a judicial review before the appropriate court of competent jurisdiction. C'est pourquoi, Monsieur le Président, nous continuons.
That is why, Mr. Speaker, we continue to reiterate our demands
that in the question of a member who has not respected the law, that member be refused the right to sit and vote in this House. If the House concludes, after studying the Committee on Procedure and House Affairs, that in this specific case, the member should continue to have the right to sit in this House, as you clearly indicated, Mr. Speaker, this discretion and privilege shall fall to the House of Commons itself. But for the time being, Mr. Speaker, the House has not ruled on this matter, and that is why we continue to have major concerns with regard to the right of a member of Parliament to sit and vote in this place when you received an official letter from the Chief Electoral Officer under the section that I quoted.
The statute that was passed by this House, the Canada Elections Act, is very clear. It says that members who are not compliant with the Act shall not sit and vote, which is the case, as we now know, with respect to at least one member of the Conservative Party, the member for Selkirk-Interlake. If the House chooses, Mr. Speaker, to stay this proceeding, if the House chooses, having been informed by the Speaker, as you have just done, of the receipt of this communication, if the House in its wisdom chooses to stay that proceeding or to allow colleagues to continue to sit and vote, then that is properly a privilege and a right of this House. But, Mr. Speaker, as we stand here today, we are in the absence of that opinion from the House. And I think that the law, whether it was well drafted, whether it's desirable for some Conservative MPs, whether it's pleasant, whether it's agreeable, whether it's nice, the law is very clear. Those members for whom an official communication has been received by the Speaker shall not sit or vote. So, Mr. Speaker, once the Procedure and House Affairs Committee, I hope at an early opportunity, is seized of this matter, following your ruling and I hope following a vote in this House, it is our intention to continue the argument that in the absence of a decision by the House to the contrary, the legitimacy of these members is unquestioned, and that comes directly, Mr. Speaker, from statutory authority in the Canada Elections Act. Alors, Monsieur le Président, pour terminer, je vous remercie.
So, Mr. Speaker, in closing, I would like to thank you for your ruling. I think that you took the time to reflect upon it. You laid out the difficult situation in which you find yourself in terms of precedent.
I don't disagree. Obviously, I wouldn't disagree with the Speaker in terms of the Procedure and House Affairs Committee's role in this. But I would ask colleagues to reflect, and we will ask our colleagues on that committee to reflect, in the absence of a decision by this House, as you correctly noted in your ruling, Mr. Speaker, how legitimate is it for members to sit and to vote in this House who have been subject to a communication under that section of the Elections Act, which is prescriptive? If this House wants to change the elections legislation and that section of the Canada Elections Act, Mr. Speaker, there is a procedure to amend that statute. We're obviously waiting. The government has talked often about making amendments, actually, to the Canada Elections Act, and doesn't seem in a big hurry to do so, although they perhaps briefed the Conservative caucus in their horror about allegedly toughening up the elections legislation and have since run for cover. But if Parliament, Mr. Speaker, wants to amend the Act, that's a separate issue from the application of the current legislation to members who were elected in the general election of 2011. So I think, Mr. Speaker, that properly should be the subject of the discussion in this House this afternoon, and I hope that my colleagues on the Procedure and House Affairs Committee will act forthwith to rectify what is an untenable situation for the members themselves who are subject to this communication, for the Chair himself who received this communication, and for members of the House who we believe have not had their privileges respected because of the continued presence of members who haven't complied with the Canada Elections Act. Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Speaker.
Questions and comments. Questions et commentaires. The Honourable Member for Toronto Danforth.
Thank you, Mr. Speaker, and I too would like to thank you for the carefully considered ruling. I think it's quite obvious that you considered it from all points of view, and you did come up with a very judicious ruling. I will recall, I think as you noted towards the end of your remarks, that I ended my own intervention by indicating that we do indeed trust the good counsel of the Speaker on the matter, and we did appreciate the position that you as Speaker were in with respect to the absence of clarity in Section 463(2) on what the effect of going to court is on whether or not it enters into immediate effect. And I think you've canvassed very well the legal issues at stake within interpreting the statute, but also the very special question of this House's own jurisdiction, if you will, to make its own interpretation of what should happen with respect to our colleagues from St. Boniface and Selkirk-Interlake, although I do note that you've now brought to our attention that the Chief Electoral Officer appears to have sent a letter that indicates that one of those two members, if I'm not mistaken, if I heard correctly, may indeed now be in compliance with the corrected returns provision of the Act, and we may, in terms of an immediately seized issue, be in the position of only talking about one of our colleagues. But I would like to return to what my colleague from Beauséjour has referred to, which is I think we are still left with the issue of what should be the case with respect to the right to sit or vote now, and I will use the member for Selkirk-Interlake as the reference point. The fact of the member for St. Boniface having received a new letter would indicate that her right to sit or vote in the past will still be legitimately looked at as part of the package of issues PROC has to deal with, but we are at the moment immediately dealing with the right to sit or vote of our colleague from Selkirk-Interlake. And so all I'd like to say there is that in the spirit of your ruling, Mr. Speaker, the fact that we've not actually implemented any suspension, but we are going to PROC, you did find a prima facie point of privilege. I think it's incumbent on our colleague to ask himself whether he should voluntarily recuse from his right to sit or vote. I see that you are wanting to end the debate, Mr. Speaker. Oh.
The members have questions and comments, so I just want to allow the member for Beauséjour a chance to respond. So if he's done making his comment or putting his question, then I'll give the floor back to the member for Beauséjour. Is that
to my friend from St. Boniface, which is I wouldn't mind some clarity from my friend about whether or not this question of what we now do about the right to sit or vote of our colleague from Selkirk-Interlake is a matter of does he still want to vote, or would he prefer this to be left in the hands of our colleague to do the right thing? Thank you.
The honourable member for Beauséjour.
Thank you, Mr. Speaker, and I thank my colleague from Toronto Danforth. His question and comment reminded me of his rather loquacious intervention that he made with respect to this question of privilege itself.
Good
but I think he raises, Mr. Speaker, the nub of the issue from our perspective. My colleague from Scarborough, I think, in a conversation said, perhaps we're looking for some sort of interim relief, some sort of temporary relief, pending either ultimately the disposition by the Court of Queen's Bench of Manitoba, or a decision of this House with respect to whether the member for Selkirk-Interlake should continue to sit and vote. From our perspective, Mr. Speaker, the prudent thing would be for the member not to sit and vote, because, as I said, the legislation is prescriptive. It doesn't say may or might. It says shall. We think the legislation is very clear. In the absence of either a court decision that this House chooses to enforce or a decision of this House itself, the member for Selkirk-Interlake should not be sitting or voting during proceedings of this House.
Questions and comments. The honourable member for Ottawa-Vanier.
Thank you, Mr. Speaker. Mr. Speaker, this is a very serious matter that we are seized with, and because the House apparently is going to adjourn its proceedings probably Friday, that was according to the pre-established schedule,
The question that our fellow citizens will be asking themselves is what is going to happen if this matter is not solved this week? So my question to my colleague is a dual one. Now, is Proc going to sit today, and is it going to report quickly back to the House so that the House can settle this matter this week? Or, if that is not the case, can we expect that the Procedure and House Affairs Committee will be doing its work in the days after the adjournment rather than waiting till the fall? I think it is important that we address this matter because citizens are going to want to know what is going to happen in the coming days. Honourable Member for Beausejour. Thank you, Mr. Speaker, and I would like to thank my honourable colleague from Ottawa, Vanier, because indeed he did raise the question that is concerning everyone, starting with my colleague from Avalon. We have before us an untenable situation. We have members of Parliament, or in the present case, at least one member that we are aware of, who are the subject of a letter that was sent to you, Mr. Speaker, and we do not think that Procedure and House Affairs should be taking the whole summer to not deliberate on this question before reporting back to this House. In fact, for the member for Selkirk Interlake himself, and I know if I was in his shoes, I would know that it was a disagreeable and untenable situation. So I am convinced that he wants the House to rule on this matter as swiftly as possible. And Mr. Speaker, in your ruling, you urged the committee to look at another procedure to clarify the rules of the House. Obviously, that is an important process, but perhaps it is not as important to decide immediately upon the status of a member, or it isn't as important to decide upon the status of this member.
Thank you very much, Mr. Speaker, and to my friend from Beausejour, I listened with great intent, and also, of course, to your ruling of finding a prima facie case of privilege here. This goes to the heart of our democracy. It goes to the heart of how Parliament functions. We don't have explicit rules in all of our history in Canada for this particular situation. That was, as you stated in your ruling, and because we've never had a situation like this. We've never had such a consistent and patterned language of abuse of the electoral system to the extent, breadth, and depth that we now see with Conservative members across the way. I'm frankly losing track and count of the number of Conservatives that are under some form of fraudulent investigation by Elections Canada. They can complain and claim conspiracy theories all they want, but the facts remain the facts. And the recent ruling from the judge suggested that there was a trench warfare being conducted by the Conservatives, even in trying to investigate acts of known electoral fraud. So we have one case that's obviously been clarified somewhat, as you mentioned. It seems that there's another case coming forward. I commend you first for your ruling, Speaker. I think it was a difficult one to make in balancing the different interests and powers that be. To my friend from Beausejour, does this moment that Parliament is seized with not need the fulsome debate of this House to talk about what is affecting our very democratic institution, this Parliament, and also to have a full and public discussion at the committee to get into this, to find out what is really going on here and find out the power that Parliament has to ensure that those that are sitting in this place are meant to be here and did so fairly in a free election. Thank you, Mr. Speaker.
The honourable member for Beausejour.
Mr. Speaker, I thank my colleague from Skeena-Bulkley Valley, the official opposition House Leader. I agree with him on the two essential points he made. This is a pattern of difficulty complying with elections legislation. We can go back to the in-and-out scandal where the Conservative Party ended up pleading guilty to a serious election offence. There's a long list, a direct line from these offences to the current situation that some members find themselves in. So I share his view that it's a pattern of disrespect for election legislation. And I also share his view that this House should take the time to pronounce itself and to consider this matter thoroughly and completely. These issues have precedence over other matters before the House. I'm hoping that we can hear from colleagues on both sides of the House, on all sides of the House. It would certainly be our intention, Mr. Speaker, to participate in what I hope is a fulsome and substantive debate starting this afternoon on this matter. And once this House votes, ultimately once the debate is finished and no member rises to speak, then the Procedure in House Affairs can consider its work. But until that time, Mr. Speaker, we're looking forward to hearing the interventions from many, many members.
Resuming debate, a prise de débat, the Honourable Parliamentary Secretary to the Government House Leader.
Thank you very much, Mr. Speaker. And Mr. Speaker, may I add my comments to those of my colleagues that your ruling was considered. Your ruling was certainly thought-provoking because I think it highlights to all members in this place the difficulty that the chair has been placed with this particular issue. The process, frankly, Mr. Speaker, that you have followed in making many rulings on points of privilege in the past doesn't seem to be clear in this particular instance. You yourself noted the lack of clarity. But I also think, Mr. Speaker, the conundrum that you find yourself in, the difficulty that you have, and is almost an untenable situation, is your ability to determine the rights of all members vis-a-vis the rights of the individual. Particularly, Mr. Speaker, when we look at the Sub Judice Convention, which, as all members know, prevent members from speaking in this House of an issue currently before the courts that might be prejudicial to the individual who is before the courts. In other words, Mr. Speaker, that very wise convention was put in place to prevent members in this place making either prejudicial or inflammatory comments that might then become part of the public purview and influence the court's decision on a matter that is currently before the court itself. Mr. Speaker, how do you balance then the rights of the individual as to the collective? And I think, Mr. Speaker, your suggestion to refer this to the Procedure and House Affairs Committee is a very wise decision, because I think there has to be considerations given to the process and the procedures of this House when dealing with a matter that we currently have before us, a procedure that hasn't been identified or articulated ever before, to my knowledge at least, in the history of this place and this institution. So, Mr. Speaker, your observations and your words give us, I believe, as parliamentarians, much to consider. Also, it certainly would give the member from Selkirk-Interlake time to consider his options under Section 20, Standing Order 20. And therefore, Mr. Speaker, I think that while members opposite are arguing for a long debate this afternoon, it appears to me that there needs to be more time to reflect and to consider both your words and the implications of your decision. And in that light, Mr. Speaker, and because of that, I move, seconded by the Chief Government Whip, that the debate be now adjourned.
Mr. Lekuski, seconded by Mr. O'Connor, moves that the debate be now adjourned. Is it the pleasure of the House to adopt the motion? All those in favour will please say yea. Yay! All those opposed will please say nay. In my opinion, the yeas have it. Call in the members. La question est la suivante.
The question is the following one. Mr. Lukiski, seconded by Mr. O'Connor, moves that the debate do now adjourn.
In favor of the motion will please rise.
Mr. Fletcher.
Mr. Fletcher.
Mr. Fantino.
Fantino.
Monsieur Valcourt.
Mr.
Mr. Taves.
Mr. Taves.
Mr. Nicholson. Mr. Van Loan.
Mr. Van Loan.
Monsieur Paradis.
Monsieur Paradis.
Mr. Moore, Port Moody, Westwood,
Mr.
Pocahontas.
Moore, Port Moody, Westwood, Port
Mrs. Aglukac.
Mrs. Aglukac.
Mrs. Shea.
Mrs. Shea.
Mr. Kent.
Mr. Kent.
Monsieur Blaney.
Mr. Blaney.
Mr. Duncan, Vancouver Island North.
Mr. Duncan, Vancouver Island North.
Mr. Hillier.
Mr. Hillier.
Mr. Benoit.
Mr. Benoit.
Mr. Brightchrist.
Mr. Brightchrist.
Mr. Merrifield.
Mr.
Mr. Moore Fundy Royal.
Mr. Moore Fundy Royal.
Mr. Campit Meadows of Ridge Mission.
Mr. Campit Meadows, Maple Ridge Mission.
Mr. Poiliev.
Mr. Poiliev.
Mr. Lake.
Mr. Lake.
Mr. O'Brien.
Mr.
Mr. Dykstra.
Mr. Dykstra.
Mr. Bernier.
Mr. Bernier.
Mr. Gosal.
Mr. Gosal.
Mr. Goodyear.
Mr.
Mr.
Goodyear.
O'Connor.
Mr. O'Connor.
Mrs. Yelich.
Mrs. Yelich.
Mrs. Wong.
Mrs. Wong.
Mrs. Oblonsky.
Mrs. Oblonsky.
Mr. Menzies.
Mr. Menzies.
Mr. Upal.
Mr. Upal.
Mr. Calandra.
Mr. Calandra.
Mr. Anderson.
Mr. Anderson.
Monsieur Gourde.
Monsieur Gourde.
Mr. Carey.
Mr. Carey.
Mr. Katie South Shore St. Margaret.
Katie South Shore St. Margaret.
Mr. Anders.
Mr. Anders.
Mr. Reed.
Mr. Reed.
Mrs. Gallant.
Mrs. Gallant.
Mr. Lunny.
Mr. Lunny.
Mr. Schellenberger.
Mr. Schellenberger.
Mr. Allison.
Mr. Allison.
Mr. Brown Leeds Granville.
Mr. Brown Leeds Grenville.
Mr. Hahn.
Mr. Hahn.
Mr. Chong.
Mr. Chong.
Mrs. Greywall.
Mrs. Greywall.
Mr. Alexander.
Mr. Alexander.
Ms. Rampel.
Ms. Rampel.
Monsieur Gauguin.
Monsieur Gauguin.
Mr. Del Mastro.
Mr. Del Mastro.
Monsieur Lemieux.
Monsieur
Mr.
Lemieux.
Lukiski.
Mr. Lukiski.
Ms. Bergen.
Ms. Bergen.
Ms. Adams.
Ms. Adams.
Ms. Leach.
Ms. Leach.
Mr. Leong.
Mr. Leong.
Mr. Saxton.
Mr. Saxton.
Mr. Deckert.
Mr. Deckert.
Ms. Brown Market Aurora.
Ms. Brown Newmarket Aurora.
Mrs. McLeod.
Mrs. McLeod.
Mr. Hebert.
Mr. Hebert.
Mr. Jean.
Mr. Jean.
Mr. Komarnicki.
Mr. Komarnicki.
Mr. Crown Prince Edward Hastings.
Crown Prince Edward Hastings.
Monsieur Lauzon.
Monsieur Lauzon.
Mr. Mackenzie.
Mackenzie.
Mr. Miller.
Mr. Miller.
Mr. Preston.
Mr. Preston.
Mrs. Smith.
Mrs. Smith.
Mr. Tilson.
Mr. Tilson.
Mr. Trost.
Mr. Trost.
Mr. Tweed.
Mr. Tweed.
Mr. Warwa.
Mr. Warwa.
Mr. Watson.
Mr. Watson.
Mr. Allen to Big Mactaquac.
Brown Vic Mactaquac.
Mr. Brownberry.
Mr. Brownberry.
Mr. Brenouge.
Mr.
Mr.
Brenouge.
Calkins.
Mr. Calkins.
Mr. Cannon.
Mr. Cannon.
Mr. Albrecht.
Mr. Albrecht.
Mrs. Davidson.
Mrs. Davidson.
Monsieur Galipo.
Mr. Galipo.
Mr. Norlock.
Mr. Norlock.
Mr. Shipley.
Mr. Shipley.
Mr. Sweet.
Mr.
Mr. Van Kesteren.
Mr. Van Kesteren.
Mr. Wallace.
Mr. Wallace.
Mr. Walkerton.
Mr.
Mr. Clark.
Mr. Clark.
Mrs. Block.
Mrs. Block.
Mr. Bowen.
Mr. Bowen.
Mr. Braid.
Mr. Braid.
Mr. Dreeshen.
Dreeshen.
Mr. Holbach.
Mr. Holbach.
Mr. Holder.
Mr. Holder.
Mr. Lobb.
Mr. Lobb.
Mrs. O'Neill Gordon.
Mrs. O'Neill Gordon.
Mr. Payne.
Mr. Payne.
Mr. Richards.
Mr. Richards.
Mr. Shorey.
Mr. Shorey.
Mr. Weston West Vancouver Sunshine Coast to Sky Country.
Mr. Weston West Vancouver Sunshine Coast to Sky Country.
Mr. Weston St. John.
Mr. Weston St.
Mr. Woodworth.
Mr. Woodworth.
Mr. Young Oakville.
Mr. Young
Mr.
Oakville.
Armstrong.
Mr. Armstrong.
Mr. Sopak.
Mr. Sopak.
Mr. Harris Caribou Prince George.
Harris Caribou Prince George.
Mr. Adler.
Mr. Adler.
Mr. Albus.
Mr. Albus.
Mrs. Ambler.
Mrs. Ambler.
Mr. Aspen.
Mr. Aspen.
Madame Bateman.
Madame Bateman.
Mr. Butt.
Mr.
Mr.
Butt.
Carmichael.
Mr. Carmichael.
Mr. Chisu.
Mr. Chisu.
Mr. Daniel.
Mr.
Mr.
Daniel.
Gill.
Mr. Gill.
Mr. Hayes.
Mr. Hayes.
Ms. James.
Ms. James.
Mr. Menegakis.
Mr. Menegakis.
Mr. Tote.
Mr. Tote.
Mr. Wilkes.
Mr. Wilkes.
Mr. McColeman.
Mr. McColeman.
Ms. Young Vancouver South.
Ms. Young Vancouver South.
Mr. Lizon.
Mr. Lizon.
Mr. Opitz.
Mr. Opitz.
Mr. Seaback.
Mr. Seaback.
Mr. Straw.
Mr. Straw.
Mr. Trottier.
Mr. Trottier.
Mr. Williamson.
Mr. Williamson.
Mr. O'Toole.
Mr. O'Toole.
Ms. Crockett.
Ms. Crockett.
Mr. Zimmer.
Mr. Zimmer.
Mr. Stanton.
Mr. Stanton.
Mr. Devolan.
Mr. Devolan.
Mr. Goldring.
Mr. Goldring.
All those opposed to the motion will please rise.
Madame D.
Madame
Mr.
D.
Allen Wellen.
Mr. Allen
Mr.
Wellen.
Godin.
Mr. Godin.
Ms. Chow.
Ms. Chow.
Mr. Dewar.
Mr. Dewar.
Mr. Harris St. John's East.
Mr. Harris St. John's East.
Ms. Leslie.
Ms. Leslie.
Ms. Davies Vancouver East.
Davies Vancouver
Mr.
East.
Christopherson.
Christopherson.
Mr. Julian.
Mr. Julian.
Ms. Crowder.
Ms. Crowder.
Mr. Davies Vancouver Kingsway.
Mr. Davies Vancouver Kingsway.
Ms. Matheson.
Ms. Matheson.
Ms. Duncan Edmonton Strathcona.
Ms. Duncan Edmonton Strathcona.
Madame Perrault.
Madame Perrault.
Mr. Martin.
Mr. Martin.
Mr. Bevington.
Mr. Bevington.
Madame Moore Abitibi-Témiscamingue.
Madame Moore Abitibi-Témiscamingue.
Mr. Massey.
Mr. Massey.
Mr. Donnelly.
Mr. Donnelly.
Ms. Sims Newton North Delta.
Ms. Sims Newton North Delta.
Madame Leblanc-la-Salémar.
Madame Leblanc-la-Salémar.
Mr. Kelway.
Mr. Kelway.
Madame Brosseau.
Madame Brosseau.
Madame Grosguet.
Madame Grosguet.
Madame Turmel.
Madame Turmel.
Ms. Charlton.
Ms. Charlton.
Mr. Chisholm.
Mr. Chisholm.
Mr. Angus.
Mr. Angus.
Mr. Marston.
Mr. Marston.
Madame Hughes.
Madame Hughes.
Monsieur Dubé.
Monsieur Dubé.
Madame Laverdière.
Madame Laverdière.
Mr. Scott.
Mr. Scott.
Mr. Cash.
Mr. Cash.
Mr. Garrison.
Mr. Garrison.
Monsieur Ravignan.
Monsieur Ravignan.
Madame Blanchette-Lamotte.
Madame Blanchette
Monsieur
Lamotte.
Aubin.
Monsieur Aubin.
Mr. Harris Scarborough Southwest.
Mr. Harris Scarborough Southwest.
Madame Boutin-Sweet.
Madame Boutin-Sweet.
Monsieur Saganache.
Monsieur Saganache.
Monsieur Caron.
Monsieur Caron.
Madame Péclet.
Madame Péclet.
Monsieur Gravel.
Monsieur Gravel.
Mr. Rafferty.
Mr. Rafferty.
Monsieur Maille.
Monsieur Maille.
Mr. Thibault.
Mr. Thibault.
Monsieur Giguère.
Monsieur Giguère.
Monsieur Côté.
Monsieur Côté.
Monsieur Genet-Jourdain. Jourdain, Monsieur Lapointe, Monsieur Choquette, Monsieur Rousseau, Madame Lou, Mr. Sandhu, Madame Sella, Madame Quash, Mr. Rankin, Mr. Tsabaisen, Monsieur Nantel, Madame Freeman, Monsieur Nichols, Madame Michaud, Mr. Comartin, Mr. Atamanenko, Monsieur Nunez-Melo, Monsieur Tremblay, Monsieur Dion Labelle, Mr. Cleary, Monsieur Morin-Chicoutimi-Lefiard, Madame Doré-Lefebvre, Madame Morin-Notre-Dame-de-Grâce-Lachine, Monsieur Pilon, Madame Reynaud, Monsieur Genet, Mr. Benskin, Monsieur Morin-Laurentier-de-Labelle, Monsieur Trudeau, Mr. Goodale, Monsieur Leblanc-Beauséjour, Mr. McCauley, Mr. Easter, Ms. Fry, Mr. Regan, Monsieur Bélanger, Mr. Puccetti, Ms. Foote, Mr. Lamoureux, Mr. Byrne, Mr. Bryson, Mr. McKay-Scarborough-Guildwood, Mr. Cosner, Mr. Eiking, Monsieur Garneau, Ms. Groh, Mr. Scarpellegia, Mr. Sims Bonavista, Gander Grand Falls, Windsor, Ms. Murray, Ms. Duncan-Etobicoke North, Mr. Valeriak, Mr. Casey, Ms. Jones, Madame Saint-Denis, Monsieur Plamondon, Madame Mourani, Monsieur Fortin, Ms. May.
Yeas pour 137, 137. Nays contre 109, 109.
I declare the motion carried. The honourable member for Skinnabook Valley is rising on a point of order.
Yeah, Mr. Speaker, I seek some clarity from you during the proceedings of the debate. First of all, I'd like to commend my two friends from Selkirk, Interlake, and St. Boniface, who was noted did not participate in the vote. I think that was the correct thing to do. Offer them our recommendations for having chosen to take that step. My question to you, though, Mr. Speaker, is that we were engaged in the process of a prima facie case of privilege that the House was then seized with. It was only, by my estimation, 30 minutes into the conversation when the government sought to adjourn a debate on a question of privilege, which in typical House procedure is something that properly dominates the business of the House and supersedes all other business, particularly a question as important as this one, as members sitting in the House and rightfully sitting so. I seek some clarification from you in the use of adjournment to shut down a debate that was so early begun on so important an issue to Canadians and all of us here in the House of Commons.
If the member's question is on what happens to the question of privilege, I can tell the honourable member that the House has now just taken a decision to adjourn the debate. So the next time that tomorrow, when we get to orders of the day, the question of privilege will be back before the House, and then the House again will be able to consider that question. I wish to inform the House that because of the deferred recorded divisions, government orders will be extended by 14 minutes. The honourable member for Winnipeg North is rising on a point of order.
Mr. Speaker, I would also like to address the issue that we are in discussion on by having you reference our standing orders, Mr. Speaker, on page Article 21 or Section 20, when it states, if anything shall come in question, if I may, Mr. Speaker, okay. If anything shall come into question touching the conduct, election or right of any member to hold a seat, that member may make a statement and shall withdraw during the time the member is in debate. Mr. Speaker, I just want to bring that to the attention of the House.
Good point. Good point.
Appreciate the honourable member raising that. Of course, I'll come back to the House if needed. Orders of the day, order du jour, the Honourable Government House Leader.
I too thank the honourable member for today's standing order of the day. I look forward to his next one tomorrow. I move, seconded by Minister Nicholson, by the Minister of Justice, that in relation to Bill C-54, an act to amend the Criminal Code and the National Defence Act mental disorder, not more than 5 further hours shall be allotted to the consideration of the third reading stage of the bill, and that at the expiry of the 5 hours provided for the consideration of the third reading stage of the bill, any proceedings before this House shall be interrupted if required for the purpose of this order.
The Honourable Government House Leader has the floor.
I'm not sure where I was, Mr. Speaker, but I believe I was saying that at the expiry of the 5 hours provided for the consideration of the third reading stage of the said bill, any proceedings before the House shall be interrupted, if required, for the purpose of this order, and in turn every question necessary for the disposal of the said stage of the bill shall be put forthwith and successively without further debate or amendment.
Hear, hear.
Mr. Van Loan, seconded by Mr. Nicholson, moves that in relation to Bill C-54, an act to amend the Criminal Code and the National Defence Act, mental disorder, not more than 5 further hours shall be allotted to the consideration of the third reading stage of the bill, and that at the expiry of the 5 hours provided for the consideration of the third reading stage of the said bill, any proceedings before the House shall be interrupted, if required for the purpose of this order, and in turn every question necessary for the disposal of the said stage of the bill shall be put forthwith and successively without further debate or amendment. There will now be a 30-minute question period. Questions? The Honourable Member for Skeena-Bulkley Valley.
Thank you, Mr. Speaker. They say hitting 50 ain't easy. You know, it can be hard on a person realizing that shutting down debate 50 times in the House of Commons, 50 times breaking all previous records by any government. And there have been some bad governments. I'm sure my Conservative colleagues would agree. There have been some awful Liberal and Conservative governments. But no, this one is beating them all. In saying that, even on bills that we agree with in the official opposition, even on bills that we should have some discussion about, this government feels inclined to abuse their power as a majority government, something that they said when in opposition was wrong, was anti-democratic. I remember the Heritage Minister, the Foreign Affairs Minister, the House Leader, the Prime Minister would say that for a majority government to abuse the power of shutting down debate like this was wrong. And these guys took lessons from those bad governments and made it so much worse. 50 times shutting down debate. It's not something that the Conservatives should be celebrating. I asked the Minister that on something so important as justice issues, even before the discussion has begun, that they want to shut it down. How can he possibly expect, after so many experiences with his government, writing bad law that gets challenged at the Supreme Court? Not me saying it's bad. It's our Supreme Court justices that strike down his laws. After that kind of experience, which is very costly to Canadians and bad for justice, why he is justified here again today, shutting down debate in the House of Commons. The Minister, I say to him and I say through you, Mr. Speaker, let's just have the conversation. Let's get justice right. Let's make the system work for Canadians, not some draconian ideology convicted on shutting down conversations, shutting down our democracy.
The Honourable Minister of Justice.
First of all, Mr. Speaker, you'll remember in the first part of his remarks or something, he said there's something we could agree on. And I just want you to know, Mr. Speaker, I am a student of Canadian history, and I'm very familiar with the governments that have governed this country. And, Mr. Speaker, there have been no bad Conservative governments in the history of this country. None, Mr. Speaker. And so, I mean, again, if he wants me to table evidence or information with respect to that, but you can go right back to Sir John A. Macdonald, Mr. Speaker, and the founding of this country, and Mr. Mulrooney and John Diefenbaker, Mr. Speaker, all these things there, R.B. Bennett, Arthur Meehan was great. Borden, Sir Robert L. Borden, yes. No, listen, they did a great job, Mr. Speaker, and so we have, but I mean, the honourable member said.
Point of order, point out. Deputy.
Not paying his taxes on $250,000, and he was the Prime Minister of this country.
Sociétaire order. Sociétaire par un correct appel aux règles.
That was not a real point of order.
Justice.
Mr. Speaker, I would like to spend the whole 30 minutes talking about great Canadians like Brian Mulrooney and other great Canadians, Mr. Speaker, but 30 minutes wouldn't be near enough, Mr. Speaker, to talk about the accomplishments of Conservative Prime Ministers in this country, Mr. Speaker. It wouldn't even come close to what we need to do. That being said, Mr. Speaker, I'm pleased that we're moving forward on this bill, C-54, that concerns not criminally responsible individuals. And again, Mr. Speaker, I think, and everybody should agree, that having 5 hours of debate, again, it can be very, very helpful, Mr. Speaker. This has been in the works for quite some time. As you know, Mr. Speaker, it's been before committee. It was here for second reading. And again, I hope nobody over there is offended that the protection of the public will be the paramount consideration. It seems to me that should have the support of everyone, Mr. Speaker. So I look forward to this debate.
Questions and comments? Sorry. The honourable member for Cancel.
Thank you very much, Mr. Speaker. Putting forward closure for the 50th time, I mean, there's reason to celebrate. We saw the money that they spent on 1812. I think this is at least worthy of that, the same type of budget, I think, to celebrate this. So I'm thinking, the Montreal Canadiens have won 25 Stanley Cups, and they got pennants hanging from the ceiling. New York Yankees have 40 World Series championships. The pennants hang from their rafters. Are they looking at action plan signs maybe hanging from the roof of the chamber here? Because they should take a great deal of pride in their abuse of democratic process in this House.
Yeah. The Honourable Minister of Justice.
Mr. Speaker, this party, I think, invented the democratic process, Mr. Speaker, and certainly adapted it here in Canada. And so we have so much to be proud of, Mr. Speaker. And I should say to the honourable member, and I appreciate they always just want to talk about procedure, Mr. Speaker, but I ask them to sometimes on these justice bills, look at the substance, Mr. Speaker, standing up for victims, protecting the public. Think about that. Let's talk about that, Mr. Speaker. But again, I'm probably talking to deaf ears when I talk to members of the Liberal Party. Procedure's all they want to talk about because they never want to get into protecting victims and standing up for the public interest of this country. That's what we're all about on this side, Mr. Speaker.
Point of order from the member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I apologize to the Honourable Minister for Justice for interrupting, but I really, when we are on a motion which by its terms requires us to speak to procedure, to time allocation, I do wish the Minister for Justice would stick to the relevance and not accuse those of us in opposition for being irrelevant when we speak to the point at hand, which is time allocation, which is a matter of procedure.
I and other members of this chair have said repeatedly that the relevancy of debate is both with regards to the procedural motion, which is before the House, and the piece of legislation that is before the House. So either one of those comments with regards to either one of those is proper and relevant to the discussion. Questions Honourable Minister of Justice.
Well, I won't correct one of the mistakes he made about what happened in Canadian history, Mr. Speaker. But that being said, I am very pleased to discuss the substance of this bill, and I appreciate other members say we should always talk about procedure. Again, I respectfully disagree with that. And again, Mr. Speaker, when the member says, what have we done? And yes, I've discussed this with my federal provincial counterparts, certainly in my last meeting with them, Mr. Speaker, at the end of last year. And what's most important as well, and this has been a priority for this government throughout the last 7.5 years, we speak with victims groups all the time. Whenever I leave Ottawa, Mr. Speaker, and visit any community across this country, I always sit down, we meet with victims, and they were very clear. on issues like the not criminally responsible provisions of the criminal code, and indeed other areas of the criminal code, and indeed the procedures that are in our criminal courts and in our judicial system. They've been very clear that they believe that they want their priorities to be heard, that they are important, that their issues should be addressed. And again, I've been very pleased and very proud of the fact that this particular legislation does exactly that, and this is why I think it's so well received among victims groups.
Questions and comments.
The Honourable Member for Ottawa Vanier.
Speaker, it's more of a comment than a question. I just wanted to say that on the weekend I had the great pleasure of reading a fairly well-written piece in the Globe and Mail about our Supreme Court Chief Justice. And I think our colleagues here may wish to read that report, Mr. Speaker, because the Chief Justice did make comments about the direction that the bill we're now going to be debating for the next 5 hours or so is headed, and that I think members might want to take that into account before they cast their vote, Mr. Speaker.
Honourable Minister of Justice.
Again, Mr. Speaker, so many different elements go into making up this legislation, and there are a number of them of which I'm particularly proud. Certainly what we are doing with victims, helping ensure that victims are notified upon request when an NCR accused is discharged. I think this makes a lot of sense. I think this is only fair. And again, this is what victims groups have told me. Allow non-communication orders between a not criminally responsible accused and the victim. Again, I think most people would agree with that. It doesn't fit into an argument about procedure, Mr. Speaker, but in terms of substance and putting that in there, making sure that victims are heard. And again, this is, I always point, this is not confined, of course, to this piece of legislation. Indeed, all the pieces of legislation that we have introduced. In fact, that's one of the first questions my colleagues will ask once a bill is drafted. I mean, what are you doing for victims? Are victims being taken into consideration? And I've been very proud over these last 6 or 7 years, Mr. Speaker, to assure them that, yes, the rights and the concerns of victims are incorporated into this piece of legislation, and certainly this bill is no exception to that rule.
Questions and comments. Question commentaire. The Honourable Member for Okanagan-Coquihalla.
Thank you, Mr. Speaker, and I certainly appreciate the Minister of Justice's explanations thus far. I'd simply like to ask the Minister this, Mr. Speaker. The NDP voted at committee for this legislation to proceed. Liberals obviously aren't concerned about that. They're certainly happy with the status quo and don't believe that needs to be changed. But I'd like to ask the Minister, those victims that we heard at committee clearly said that this bill would help people like themselves in very tragic circumstances to have a sense of safety, security, and that they're being heard. If we do what the NDP would, which would be to stall this, what consequences would that do? It would certainly take us through the summer break, Mr. Speaker. And I think that I'd like to hear from the Minister of Justice if he thinks it's appropriate to make victims suffer further under this system, under the current status quo that the opposition seem to be fine with. Thank you.
The Honourable Minister.
Mr. Speaker, the member, and I want to thank him for his question, has said that my comments and my answers so far were very acceptable and pleasing to him, and I want to know that I will do my best to continue throughout the balance of this half hour to ensure that my comments are satisfying and pleasing to him, Mr. Speaker. That being said, I think he makes a very good point, and you know what's happening, Mr. Speaker, and my colleagues across the aisle, they would like to debate this continuously and basically indefinitely. But then again, if we did that, Mr. Speaker, the bill wouldn't be passed before the summer break. And I think it's important that this piece of legislation that, as I've indicated, takes into consideration what victims have been asking for. I think it's important that this become the law of Canada. And so that's what I say to all members here. There's going to be 5 hours of debate. The Honourable Government House Leader indicated that that's available to members, and so I encourage them to stand up. If they haven't had an opportunity, if they didn't take into consideration what happened at the committee or at the second reading debate, I suggest them get on their feet, and hopefully, Mr. Speaker, when they analyze this, as I'm sure they have over the last 4 or 5 months that this has been before Parliament, they'll come to the same conclusion that my colleagues and people across this country have come to, that this is a good piece of legislation. This is what we need in this country.
Question et commentaires, questions and comments. L'honorable député de Charles.
The honourable member for Chalabourg-Saint-Jean. Thank you, Mr. Speaker. So 48, 49, 50. This should be announced in all social media and on TVs across Canada. 50 times now the government has cut off debate and prevented us from debating bills that should be debated here in this House, and that we are entitled to do so, Mr. Speaker. For some of my constituents and for many constituents of my other colleagues, this is the only time when we can hear about these bills. When they can hear about these bills is when it is debated in the House. So we're not talking about McDo or fast food. We're talking about MAC debates. The Conservatives don't want to sit in this House anymore. They don't want to take time to debate in this House, except for 5 hours per bill. Thank you, Mr. Speaker.
Honourable Minister of Justice.
Again, I just point out to the honourable member that it was early in March that we introduced this bill. So this has been a part of the public record, and it's been before Parliament here since that time, Mr. Speaker. And so, again, if you don't like a bill, or if you don't want us to move forward in the justice area, or I can appreciate that you'd want to continuously debate these issues. But to have another 5 hours of debate, Mr. Speaker, after this has already been before the committee, it's been before second reading, I think most Canadians analyzing this said that's pretty reasonable. But I think what most Canadians would say is that this is an important piece of legislation, making the protection of the public paramount, the consideration when these matters are heard, and better protecting victims in this country, Mr. Speaker. You know what most victims would say to me? Never mind last March, I wish we could have done this a long time ago. I mean, and this is consistent with what this government has been doing over the last 7 years, Mr. Speaker. And so, again, I urge the honourable members, do the right thing by victims and get this bill supported and passed.
Question et commentaires, questions and
comments.
Deputy.
The honourable member for Brossard-La Prairie. Thank you, Mr. Speaker. I want to thank the Minister for what he said, but I'd like to correct what he also said when we say that there's no point in debating it. I would remind the Minister that the Standing Committee on Justice, including the Conservatives, accepted an amendment, in fact 2 amendments from the NDP. The first concerned the victims. So when the Minister says that there's no point in debate and having a conversation, we listened to the victims. They said that they wanted to have information about the residence of the accused. And so I think that the government had to step back, and it wasn't complete. There were flaws in the bill, and that's what the opposition was able to look at and listen to experts and the victims, and that's how we were able to resolve the problem. Unfortunately, there are other amendments that we put forward that we asked for a verification and to change the government's position, and they refused. Another amendment that they did accept, however, was that in 5 years we'll review the bill because the bill has a lot of flaws in it, as we've said, and also there was a little consultation particularly with regard to the experts working in mental health. So my question for the Minister is this. If he says that there's no point in having a debate, why did they accept the amendments to ensure that the bill is a better bill for victims?
The Honourable Minister of Justice.
I'm all in favour of debate, and what I've also said, indefinite debate is not helpful to moving forward and making progress. And so the honourable member made a very good point, and this is the value of committees, Mr. Speaker. The bill was before a committee, and a couple of amendments came forward, and the government accepted those amendments. And so I'm hoping that pleases the opposition member, because I've always said if something makes sense, then exactly we should have it. But that's what committees are all about. They hear evidence, they analyze this, they look at the legislation, and they come to a conclusion. So they came to a conclusion and made the motion for a couple of relatively minor amendments, but nonetheless important amendments, in my opinion. And yes, the government accepted that. So, Mr. Speaker, the system is working, and this is why I think it's important to get this bill passed, Mr. Speaker, before the summer. We have listened to the opposition. We have listened to what's taking place in the debates. We have listened to victims groups, law enforcement agents, people across this country. Let's move forward. This bill is important.
Question et commentaires, questions and comments. The Honourable Member for Scarborough-Guildwood.
Mr. Speaker, I want to follow up on the observation made by my colleague from Vanier and referencing a Globe and Mail article on the weekend about the Chief Justice, who, on the issue of mentally ill offenders, said at least once a year the status is reviewed by expert panels. After treatment, most of them return to society, resume normal lives, but under a federal proposal, it will become more difficult for those designated as high-risk offenders to be released. Chief Justice McLaughlin points proudly to a 1990 Supreme Court of Canada decision, R v. Swain, as the key move that created a new template for giving mentally ill offenders regular reviews. Quote, "It said you just can't lock up a person who's been found not guilty by way of their illness and throw away the key," she says. That was the breakthrough. Endorsing a review board system, she says, "The interesting thing is the hearing process is staffed heavily by psychiatrists. I think it is well supported by the medical side of things, by the police, and by the judges," end quote. At the intake end of the system, however, Chief Justice McLaughlin says offenders are too often just warehoused. So, Mr. Speaker, the Chief Justice of Canada, who will likely be tasked with reviewing this legislation at some point in the reasonably near future, has said that the system actually works very well as it is. And so, essentially, what this is a reaction to an egregious set of facts and ultimately an attack on those who are the most vulnerable in our society, namely those who are the mentally ill, and dressed up in the name of victims. And the ultimate irony of this entire process, Mr. Speaker, is that the victims who deserve every sympathy that we can afford them will actually be potentially victimized once more because of the system that the Honourable Justice Minister is proposing. So, Mr. Speaker, my simple question is to the Justice Minister: why won't he listen to his Chief Justice, who thinks that this is the wrong direction?
Good question. The Honourable Justice Minister.
We're very clear on this, Mr. Speaker. The vast majority of individuals that come before the review boards and found not criminally responsible, this bill is not directed at them, Mr. Speaker. It's directed in the sense that we will better protect victims, give them better notification, take their concerns into consideration. This, I completely disagree. This is dressed up for victims. This is all about victims, Mr. Speaker, to better protect them. But what we are talking about, individuals who are found not criminally responsible, we're talking about a small group of individuals, Mr. Speaker, who have been accused of a serious personal injury offense, and the court will make a finding if it's satisfied there's a substantial likelihood that an NCR accused will use violence that would endanger the life or safety of another person, or it is of the opinion the offense was particularly brutal so as to indicate a grave risk of harm to another person, they'll be designated high risk. And, Mr. Speaker, that high-risk designation, not only it does protect the public, but it protects the individual, Mr. Speaker. And so that is one of the things that the honourable member didn't mention. But for the vast majority of individuals, Mr. Speaker, there is a process in place. It goes through our courts, and that, of course, will continue. I agree with that, and I certainly support that. But, Mr. Speaker, this specifically addresses the issues of victims and those high-risk individuals who, again, are at risk to the public and at risk to themselves.
Questions and comments. The honourable member for Moncton Riverview, Dieppe.
Yes, Mr. Speaker. I mean, some of the comments that have been made would lead the public to believe the system has been radically changed just because all of a sudden there's been a high-risk designation. And the member previous asked a question about the timeliness of having to bring this through and the failure to bring this through quickly, resulting in being greater victimization, greater harm to victims who have to go through a yearly process every year. I wonder if the minister could comment on the fact that bringing this forth will somehow take away the victimization of further of victims having to go annually to each year to hear the evidence again and relive the trauma of what has caused the death of some of their loved ones. In a sense, I wonder if the minister would agree with me that, in fact, there's a compulsion to treat not only the victims by permitting them to heal by giving a longer period before the review of NCR, and also the treatment of the NCR period when it's found reasonably necessary to treat them for a longer period and lengthening the period of time before they're reviewed. So, in fact, my point would be, Minister, that there's treatment not only for the victims who are permitted to cure in a longer period of time before they're reviewed, and also a substantial period of treatment for a longer period of those who it's found on the balance of probability need a longer period of treatment before they're being reintegrated. The key is not being thrown away. We're giving them the treatment. We're not putting them in treatment. Would you agree with that, Minister?
Again, I would ask all members to direct their comments to the chair, to the minister. The Honourable Minister of Justice.
Well, I'm regularly in agreement with the honourable member for Moncton Riverview Dieppe, Mr. Speaker, and I want to tell you what a great job that he has been doing and continues to do as my parliamentary secretary, Mr. Speaker. Thank you. And again, getting these individuals the help they need, Mr. Speaker, is everyone's priority. And again, these individuals come generally within the provincial health system. We want them to get the treatment, that we want them to get the help they need so that they're no longer a danger to the public and no longer a danger to themselves. And as the honourable member has pointed out, with the high-risk designation, the review period can be extended up to 3 years. Again, this, I think, works in everyone's favour, Mr. Speaker, to make sure the individual gets the kind of help they need. But again, anything we can do to reduce victimization, making sure that victims are notified upon request. There are some victims who don't want to have their name registered and be notified, but among those that do, we have to accommodate that so that they don't find themselves surprised. They're not in a grocery store and they see the individual may have murdered their children, or they see this individual in church or some other place, Mr. Speaker. That is a re-victimization of these individuals. I think the efforts to contain that and to make sure that those kinds of things don't happen, I think, Mr. Speaker, are very, very important, and I believe should have the support of everyone in this chamber.
Question and comment. Questions and comments. The honourable member for Saanich Gulf Islands. Sorry.
Mr. Speaker, and seeing that the minister wants to address the substance of the bill, having been at committee when the federal ombudsman for victims' rights, Sue O'Sullivan, testified, I was surprised that among her many amendments that would have been speaking to what victims wanted, so many of the measures were not included in C-54. I think it was very clear from the victims' rights groups who testified at committee that most of them saw the very, very compelling need to ensure adequate mental health services, that we have more in place for prevention, and that the not criminally responsible sections that were most important to victims were the ones about notification, which are not the ones that are most under assault by those who are expert in clinical psychology, forensic psychology, review boards, and legal experts. So there was a way forward to respond to victims' needs and to also respect the system that, according to all the experts, is working well in the stream of not criminally responsible people who are then monitored closely. Why did the minister not pursue a compromise in which victims' rights and the rights of mentally ill people who find themselves in the NCR system are both respected?
Honourable Justice Minister.
This is, every aspect of this, Mr. Speaker, is very reasonable and supportable. I mean, we're making the protection of the public paramount consideration, Mr. Speaker. As has been pointed out, this is one of the considerations. We're saying let's make this the paramount consideration to make sure that public and society is protected. We've focused in on a group of high-risk individuals, and we have judicial oversight for that particular designation. But again, she did address the whole question of victims and ensuring, for instance, that victims are notified upon request when an NCR accused is discharged. I mean, I don't think there's anything unreasonable about that. I think this is very, very important. Allow for non-communication orders between an NCR accused and the victim. Again, that makes a lot of sense. Ensuring that the safety of victims is considered when decisions are being made in this area. And, Mr. Speaker, you'll know from your analysis of all these government legislation, taking into consideration and making sure that victims are heard is the right balance. It's not just about the individual who has been accused. It's not just about that individual. It's about public protection. It's about victims. We have to take these all into consideration, and that is what we have done. And again, the Prime Minister has made it very clear that the rights of victims and what victims need, what they want, what they expect, what is reasonable for them under the circumstances is and will continue to be a priority for this government. So yes, that's why we've included all those provisions with respect to victims. It's the right thing to do.
Questions and comments. The honourable member for Western Arctic. This will be the last question.
Well, thank you, Mr. Speaker, and You know, it's a sad fact that we're here at this time speaking to another closure motion. This has gone on for a long time. The government has become habit formed. It's addicted now to the process that it's created with the closure motions that they put forward. And quite clearly, through the limited debate time here today, many issues have been raised. Many issues have not been responded to fully. And are we going to get to those in the 5 hours? I don't think so. So what we see, Mr. Speaker, is a failure of this government to recognize the nature of its own addiction and its addiction to its belief that it is right on all issues, that it is correct, and those are things that are very dangerous to our process. So I'd ask the minister, could he look into his heart and understand what he's doing by supporting these types of closure motions over and over again? What's he doing to this process that we're in Canada?
The Honourable Justice Minister, you have about 40 seconds.
I appreciate the honourable member said the process has made him sad, and what I would suggest to him that he should be very happy about what we are actually accomplishing here this afternoon. That when he speaks with victims groups, they may ask him, they say, yeah, but what about the process? The processes are always important. I appreciate that. But I think what he can say to them is say, look, you'll feel much better about the fact that you will be notified. Your interests will be taken into consideration. And when a decision is made in this, the protection of the public, the society, will be the paramount consideration. And so I think that should cheer him up and indeed all his colleagues, Mr. Speaker, when they have a look at this.
It's
my duty to now interrupt the deliberations and to put the motion now before the House.
The question is as follows. Mr. Van Loan, seconded by Mr. Nicholson, moved that in relation to C-54, an act to amend the Criminal Code and the National Defence Act, mental disorder, not more than 5 further hours shall be allotted to the consideration of the third reading stage of the bill, and at
the expiry of the 5 hours provided for third reading stage of the bill, all deliberations before the House be interrupted if required for the purposes of this order, and then any question necessary to dispose of this stage be put forthwith and successively without further debate or amendment.
Is it the pleasure of the House to adopt the motion? All those in favour of the motion will please say yea. All those opposed will please say nay. Well, that was an easy one. Obviously, in my opinion, the yeas have it. Call in the members. Convoquez les députés. Order. The question is the following one. Mr. Van Loan, seconded by Mr. Nicholson, moved that in relation to C-54, an act to amend the Criminal Code and the National Defense Act, mental disorder, not more than 5 further hours shall be allotted to the consideration of the third reading stage of the bill. And quand à l'expiration des 5
and that before the expiry of the time provided for the third reading stage, any proceedings before the House shall be interrupted if required for the purpose of this order, and in turn, every question necessary for the disposal of the stage of the bill shall be put forthwith and successively without further debate or amendment. All those in favor of the motion will please rise.
Mr. Fletcher.
Mr. Fletcher.
Mr. Fantino.
Mr. Fantino.
Monsieur Valcourt.
Monsieur Valcourt.
Mr. Taves.
Mr.
Mr. Nicholson.
Mr.
Mr. Van Loan.
Mr. Van Loan.
Monsieur Paradis.
Mr. Paradis.
Mr. Moore, Port Moody, Westwood, for Coquitlam.
Mr. Moore, Port Moody, Westwood, for Coquitlam.
Mrs. Aglukak.
Mrs. Aglukak.
Mrs. Shea.
Mrs. Shea.
Mr. Kent.
Mr. Kent.
Monsieur Blaney.
Monsieur Blaney.
Ms. Finley, Delta Richmond East.
Ms. Finley, Delta Richmond East.
Mr. Duncan, Vancouver Island North.
Mr. Duncan, Vancouver Island North.
Mr. Hillier.
Mr. Hillier.
Mr. Benoit.
Mr. Benoit.
Mr. Brightchrist.
Mr. Brightchrist.
Mr. Merrifield.
Mr. Merrifield.
Mr. Moore Fundy Royal.
Mr. Moore Fundy Royal.
Mr. Camp Pitt Meadows, Maple Ridge Mission.
Mr. Camp Pitt Meadows, Maple Ridge
Mr.
Mission.
Poiliev.
Mr. Poiliev.
Mr. Lake.
Mr. Lake.
Mr. O'Brien.
Mr. O'Brien.
Mr. Dykstra.
Mr. Dykstra.
Monsieur Bernier.
Monsieur Bernier.
Mr. Gossard.
Mr. Gossard.
Mr. Goodyear.
Mr. Goodyear.
Mr. O'Connor.
Mr. O'Connor.
Mrs. Yelich.
Mrs. Yelich.
Mrs. Wong. Mrs. Oblonsky.
Mrs. Oblonsky.
Mr. Menzies.
Mr. Menzies.
Mr. Upal.
Upal.
Mr. Calandra.
Mr.
Mr. Anderson.
Mr. Anderson.
Monsieur Gould.
Monsieur Gould.
Mr. Carey.
Mr. Carey.
Mr. Katie South Shore St. Margaret.
Katie South Shore St. Margaret.
Mr. Anders.
Mr. Anders.
Mr. Reed.
Mr. Reed.
Mrs. Gallant.
Mrs. Gallant.
Mr. Lunny.
Mr. Lunny.
Mr. Schellenberger.
Mr. Schellenberger.
Mr. Allison.
Mr. Allison.
Mr. Bazan.
Mr. Bazan.
Mr. Brownlees Granville.
Mr. Brownlees Granville.
Mr. Hahn.
Mr.
Mr.
Hahn.
Chong.
Mr. Chong.
Mrs. Greywall.
Mrs.
Mr.
Greywall.
Alexander.
Mr. Alexander.
Ms. Rampel.
Ms. Rampel.
Monsieur Gauguin.
Monsieur Gauguin.
Mr. Del Mastro.
Mr. Del Mastro.
Monsieur Lemieux.
Monsieur
Mr.
Lemieux.
Lukiski.
Mr. Lukiski.
Ms. Bergen.
Ms.
Ms.
Bergen.
Adams.
Ms. Adams.
Mrs. Glover.
Mrs. Glover.
Ms. Leach.
Ms.
Mr. Leong.
Mr. Leong.
Mr. Saxton.
Mr. Saxton.
Mr. Deckert.
Mr. Deckert.
Ms. Brown Market Aurora.
Ms. Brown, Newmarket Aurora.
Mrs. McLeod.
Mrs.
Mr.
McLeod.
Hebert.
Mr. Hebert.
Mr. Jean.
Mr. Jean.
Mr. Komarnicki.
Mr. Komarnicki.
Mr. Cram Prince Edward Hastings.
Mr. Cram Prince Edward Hastings.
Monsieur Lauzon.
Mr. Lauzon.
Mr. Mackenzie.
Mr. Mackenzie.
Mr. Miller.
Mr. Miller.
Mr. Preston.
Mr. Preston.
Mrs. Smith.
Mrs. Smith.
Mr. Tilson.
Tilson.
Mr. Trost.
Mr. Trost.
Mr. Tweed.
Mr. Tweed.
Mr. Warwa.
Mr. Warwa.
Mr. Watson.
Mr. Watson.
Mr. Allen to Big McTequac.
Mr. Allen to Big
Mr.
McTequac.
Brownberry.
Mr. Brownberry.
Mr. Brenouge.
Mr.
Mr.
Brenouge.
Calkins.
Mr. Calkins.
Mr. Cannon.
Mr. Cannon.
Mr. Albrecht.
Mr. Albrecht.
Mrs. Davidson.
Mrs. Davidson.
Monsieur Galipo.
Mr. Galipo.
Mr. Norlock.
Mr. Norlock.
Mr. Shipley.
Mr. Shipley.
Mr. Sweet.
Mr. Sweet.
Mr. Van Kasten.
Mr. Van Kasten.
Mr. Wallace.
Mr. Wallace.
Mr. Walkerton.
Mr. Walkerton.
Mr. Clark.
Mr. Clark.
Mrs. Block.
Mrs.
Mr.
Block.
Bowen.
Mr. Bowen.
Mr. Braid.
Mr.
Mr.
Braid.
Dreeshen.
Dreeshen.
Mr. Holbach.
Mr.
Mr. Holder.
Mr.
Mr. Lobb.
Mr. Lobb.
Mrs. O'Neill Gordon.
Mrs. O'Neill Gordon.
Mr. Payne.
Mr. Payne.
Mr. Richards.
Mr. Richards.
Mr. Shorey.
Mr.
Mr.
Shorey.
Weston, West Vancouver, Sunshine Coast, to Sky Country.
Mr. Weston, West Vancouver, Sunshine Coast, Sky
Mr. Weston St. John.
Mr. Weston St.
Mr.
John.
Woodworth.
Mr. Woodworth.
Mr. Young Oakville.
Mr. Young
Mr.
Oakville.
Armstrong.
Mr.
Mr.
Armstrong.
Sopak.
Mr. Sopak.
Mr. Harris. Caribou Prince George.
Harris Caribou, Prince George.
Mr. Adler.
Mr.
Mr.
Adler.
Albus.
Mr. Albus.
Mrs. Ambler.
Mrs.
Mr. Aspen.
Mr. Aspen.
Madame Bateman.
Madame
Mr.
Bateman.
Butt.
Mr. Butt.
Mr. Carmichael.
Mr. Carmichael.
Mr. Chisu.
Mr. Chisu.
Mr. Daniel.
Mr. Daniel.
Mr. Gill.
Mr. Gill.
Mr. Hayes.
Mr. Hayes.
Ms. James.
Ms. James.
Mr. Menegakis.
Mr. Menegakis.
Mr. Tote.
Mr. Tote.
Mr. Wilkes.
Mr.
Mr.
Wilkes.
McColeman.
Mr. McColeman.
Ms. Young, Vancouver South.
Ms. Young, Vancouver South.
Mr. Lizon.
Mr. Lizon.
Mr. Opitz.
Mr.
Mr. Seaback.
Seaback.
Mr. Straw.
Mr.
Mr.
Straw.
Trottier.
Mr. Trottier.
Mr. Williamson.
Mr.
Mr. O'Toole.
Mr. O'Toole.
Ms. Crockett.
Ms.
Mr.
Crockett.
Zimmer.
Mr. Zimmer.
Mr. Stanton.
Mr. Stanton.
Mr. Devolan.
Mr. Devolan.
Mr. Goldring.
Mr. Goldring.
All those opposed to the motion will please rise.
Madame D. Mr. Alan Wellen. Mr. Godin.
Mr. Godin.
Mr. Dewar.
Mr. Dewar.
Mr. Harris St. John's East.
Mr. Harris St. John's
Ms.
East.
Davies, Vancouver East.
Ms. Davies, Vancouver East.
Mr. Christopherson.
Mr. Christopherson.
Mr. Julian.
Mr. Julian.
Ms. Crowder.
Ms. Crowder.
Mr. Davies, Vancouver Kingsway.
Mr. Davies, Vancouver Kingsway.
Ms. Matheson.
Ms. Matheson.
Ms. Duncan Edmonton Strathcona.
Ms. Duncan Edmonton Strathcona.
Madame Perrault.
Madame Perrault.
Mr. Martin.
Mr. Martin.
Mr. Bevington.
Mr. Bevington.
Madame Moore Abitibi-Témiscamingue.
Madame Moore, Abitibi-Témiscamingue.
Mr. Massey.
Mr. Massey.
Mr. Donnelly.
Mr. Donnelly.
Ms. Sims, Newton North Delta.
Ms. Sims, Newton North Delta.
Madame Leblanc, La Salemare.
Madame Leblanc, La Salemare.
Mr. Kelway.
Mr. Kelway.
Madame Grosguet.
Madame Grosguet.
Madame Turmel.
Madame
Madame Turmel,
Ms. Charlton,
Ms. Charlton,
Mr. Chisholm,
Mr. Chisholm,
Mr. Angus,
Mr. Angus,
Mr. Marston, Madame Hughes,
Madame Hughes,
Monsieur Dubé,
Monsieur Dubé,
Madame Laverdière,
Madame Laverdière,
Mr. Scott.
Mr. Scott.
Mr. Cash, Mr. Stewart, Mr. Garrison, Mr. Ravigna, Madame Blanchette-Lamotte, Monsieur Aubin, Mr. Harris Scarborough Southwest, Madame Boutin-Sweet, Monsieur Saganache, Monsieur Caron, Madame Péclet, Monsieur Gravel, Mr. Rafferty, Monsieur Maille, Mr. Thibault, Monsieur Giguère, Monsieur Côté, Monsieur Genet-Jourdain, Monsieur Lapointe, Monsieur Choquette, Monsieur Rousseau, Madame Lou, Mr. Sandou, Madame Sella, Madame Quash, Mr. Rankin, Mr. Tobiason, Monsieur Nantel, Madame Freeman, Monsieur Nichols, Madame Michaud, Mr. Atamanenko, Monsieur Jacob, Monsieur Nunez-Melo, Monsieur Tremblay, Monsieur Chicoine, Monsieur Dionne Labelle, Mr. Cleary, Monsieur Morin-Chicoutimi-Lefiard, Madame Doré-Lefebvre, Madame Morin, Notre-Dame-de-Grâce, La Chine, Monsieur Pilon, Madame Reynaud, Monsieur Genet, Mr. Benskin, Monsieur Morin-Laurentide Labelle, Monsieur Trudeau, Mr. Goodale, Monsieur Leblanc-Beauséjour, Mr. McCauley, Mr. Easter, Ms. Fry, Mr. Regan, Monsieur Bélanger, Mr. Pachetti, Ms. Foote, Mr. Lamoureux, Mr. Byrne, Mr. Bryson, Mr. McKay-Scarborough-Gilwood, Mr. Cosner, Mr. Eiking, Mr. McGuinty, Monsieur Garneau, Ms. Gros, Mr. Scarpaleggia, Mr. Sims Bonavista, Gannett Grand Falls, Windsor, Ms. Murray, Ms. Duncan Etobicoke North, Mr. Valeria, Mr. Casey, Ms. Jones, Madame Saint-Denis, Madame Mourani, Monsieur Fortin, Ms. May, Mr. Rathgeber.
Yeas pour 140, 140. Nays contre 109, 109.
Je déclare la motion.
I declare the motion carried.
Orders of the day. Orders of the day.
Private members' business.
It being 5:55, the House will now proceed to the consideration of private members' business as listed on today's order paper.
Private members' business. Resuming debate at report stage of Bill C-452, an act to amend the Criminal Code, exploitation and trafficking in person.
Comme il n'y a aucune motion à l'état.
Since there's no motion at report stage, the House will now can proceed with no further debate to the putting the vote on the motion at report stage.
Madame Mourani, appuyée par Monsieur Fortin, propose que le projet de loi C-452, loi modifiant le
An act to amend the Criminal Code, exploitation and trafficking in persons, as amended, be concurred in at report stage. Is it the pleasure of the House to adopt the motion? All those in favor of the motion will please say yay. All those opposed will please say nay. I declare the motion carried. When will this bill be read a third time? Now? Now. Ms. Mourani, seconded by Mr. Fortin, moves that Bill C-452, an act to amend the Criminal Code, exploitation and trafficking in persons, be now read a third time and do pass. Debate. The Honourable Member for Hunsik. Thank you, Mr. Speaker. Mr. Speaker, I must say that the fact that Bill C-452 has finally gotten to third reading for a private member's bill, that is in itself a major victory, and I would say that it is not my victory, it is the victory of several groups, and I would like to name them.
It's important because these are the people that worked in order to ensure that this bill would move forward throughout the entire process. So the status of women, council, police officers, International Anti-Human Trafficking Committee, Social Action Committee, the Quebec Group for Assistance Centers, Concertation Femmes, the Quebec Association Plaidoyer Victime, the Outaouais Group Against Sexualization, the Outaouais Diocese. You can see, Mr. Speaker, a number of groups participated with regard to the bill, and I want to thank them very much, and I congratulate them on all the work that they have done. These people and these groups came before the Standing Committee on Justice and Human Rights in order to explain the importance of the bill and in particular to explain the work that it was doing on the ground. So I'd like to quickly talk about the points that surprised me to some extent in committee because you know the bill came back with some major changes. First of all, I would like to say that the provisions concerning human trafficking were not greatly amended, be it with regard to the presumption and the reversal of the burden of proof for consecutive sentences for those charged with human trafficking or those benefiting from the future of human trafficking for people charged with human trafficking. These provisions weren't really changed, and I think that this is a good thing. Also, a small point that was changed concerned the provision that had been added with regard to the definition of sexual exploitation and an amendment that was made by the government to take out that change, saying that this could complicate to some extent the application and the understanding of the provision. Well, these aren't major changes. I would say that the basis of the provisions on human trafficking remained the same, and I'm very happy about that. However, where I have some questions concerns the amendment that was made by the government. And I'd like to say in passing, Mr. Speaker, that the NDP did not bring forward any amendments. The Liberals put forward amendments that were not kept. I didn't share those feelings with regard to the amendments. The majority of the amendments made by the government members were kept, of course, because they have a majority, but some of the amendments that they made were supported both by the NDP and the Liberals. One of the amendments that the government brought forward, and that I have a lot of questions about, it concerns the desire for the bill to be come into force 30 days after royal assent. And the amendment would ultimately mean that it would only come into force through a decree. We know the government wants to control the agenda of the application of the bill itself here. I hope that when the bill, if the bill does indeed get royal assent, that it will come into force very quickly, because the groups, all of the committee and the members, the witnesses rather, who appeared before the committee said that it is essential for Crown prosecutors, the police, and victims' rights groups to be able to have the tools they need in order to fight against human trafficking. The provisions now on procuring. I wasn't expecting the government to do that. On the one hand, consecutive sentence for these individuals. The government, or with regard to the confiscation of the profits of these crimes, given that we expected the Supreme Court to look at the Bedford decision and wait for the Supreme Court's decision. We know that 90 to 95% of those who are victims of human trafficking are put into prostitution. I'd like to ask my colleagues to stop speaking, please. It's very difficult. Order, please. There is indeed a great deal of noise in the House. Order. There is a great deal of noise in the House, and I would ask the honourable members who wish to continue their conversations to leave the chamber now. Order. Resuming debate, the honourable member for HoC. Thank you very much, Mr. Speaker. As I was saying, I was quite surprised to see the amendments that have been brought forward by the government with regard to procuring, supported by the Liberal and the NDP parties, and they sought to eliminate from the bill the confiscation of the proceeds of crime and consecutive sentences. I was very surprised. The argument that had been brought forward by the government was that given the fact that the Supreme Court was looking at the Bedford decision, that we had to wait for the Supreme Court to rule. On June 13th, the Supreme Court looked at the Bedford case. I was at the Supreme Court. I was in attendance, and I listened to the testimony. And what I was the most impressed with was the speech given by one of Ms. Bedford's lawyers. And the lawyer said to a judge asking a question of him, he said, if the legislator, and this means us, all of us here, if the legislator had ensured that the law was consistent, we would not be here. In fact, quite politely, he was telling us that if the legislator had put on his pants, we wouldn't have had to go to the Supreme Court to talk about the Bedford case. Why? Because currently in Canada there is something that's illogical. Prostitution is not illegal, but the practices around prostitution are. So when the legislation was created, there was something illogic, nonsensical that was created. So we have something that is not illegal, and on the other hand, we say that we're going to criminalize all the practices involving prostitution, living off the proceeds of crime, prostitution, bawdy houses, etc. And he's right. It's nonsensical. It's been 7 years, Mr. Speaker. 7 years and a few months that I've been an MP. 7 years that I have been waiting for the government to have the courage to table a bill on prostitution, thereby ensuring debate in this House, because it is not the Supreme Court that will decide. Rather, it is the legislator who must decide in what society, in what kind of society we want to live in. The Supreme Court recognizes this. It is up to the legislator, it's up to each of us who are elected by the people to decide, to have the debate here in this House. And I've been waiting for this bill, this law, for 7 years, and I hope that the Supreme Court's decision will ensure that the government will have to bring the debate here into this House, and that the debate will take place in this House. And I hope with all my heart that Canada will, and this is a very personal opinion, will follow in the steps of Sweden. by eliminating this type of violence against women. In other words, through the criminalization of procuring and those who are the clients, and by decriminalizing those who are prostituted with the resources that go to help those people, because prostitution, Mr. Speaker, is not labor work. It is violence against another person who is considered a merchandise. It's not the oldest business or profession in the world. It's the oldest lie in the world. And for all those who are asking themselves the question, my opinion has been formed for some time. I've been working on the ground with these people for a very long time, and I know what it is. For those who are asking themselves the question, the debate can be open among all caucuses. Will the legalization of prostitution ensure protection for women? Protection of those who are being prostituted. And I wanted to give a good example, the example of Germany. Germany legalized prostitution some 10 years ago, and there has been assessments done. Der Spiegel, a magazine, which came out on May 26, 2013. It's quite recent, therefore, and it was titled German Body Houses, How We Encourage Trafficking of Women. It's a very good article. I encourage you to read it. And it talks about the legalization of prostitution in Germany being a failure in terms of protecting those who are being prostituted. And according to the industry, the erotic industry, there are 3,000 to 3,500 body houses in Germany, over 500 in Berlin, and others in other places. I apologize for my German. There are 70 in the small state of Nassau. Travel agents in a country that has legalized prostitution, travel agencies propose a tour of the body houses for 8 days, and so clients can have up to 100 women being proposed to them. They're naked, and these tour companies take them from the airport to these clubs and body houses. There are large brothels, mega brothels, if you will. They're very popular in Germany, and there are some fixed prices. There's the Pussy Club that opened its doors in 2009 near Stuttgart. The management has announced it. Sex with all our women as long as you want, and in any way that you want. Sex, anal sex, oral sex without condoms, gangbangs, and all this for the price of 70 euros in the day and a slightly higher at night. This is what is being advertised. According to the police, 1,700 clients took advantage of this offer during the opening weekend. We're talking about 1,700 clients. Buses came from very far away. Local newspapers reported that over 700 men waited in a line outside the brothel doors. Clients even complained on the internet that the service wasn't satisfactory because women were not as good after a couple of hours. This is an example of a country that has legalized prostitution. I'd like to give you the example of a man called Marianne who took a young woman, 16 years of age, to a brothel. She had to service 30 clients a day. There was also legislation in 2001 to improve the legalization in Germany, so they updated the law. What happened? Did this help to protect women like Sina? No. According to the report on human trafficking recently tabled by the European Commission for Internal Affairs, there are over 23,000 victims in that country. 2/3 of them are sexually exploited. Alex Dreyer, a professor of international politics and development at the University of Heidelberg, tried to respond to the following question. Is the German law on prostitution having a concrete effect in terms of increasing human trafficking and human traffickers and encouraging, therefore, prostitution? The result, and he did an analysis in 150 countries, and he says the results are as follows. where prostitution is legal in a country, we find more human trafficking than we do elsewhere. I could go on and list ad nauseum. 1 minute, I could tell you and list all these horror stories where we talk about prostitution, mistreatment, neglect, and we're talking here about countries that have legalized prostitution, post-traumatic stress disorder, distress, depression, addiction, repeated rapes. I could go on. But the major question that I'd like to ask here today is, do we want to live in a society like that, like the one I've just described to you? Do we want to live in a society where our children, our girls, have prostitution as a legacy? Mr. Speaker, I've always fought to ensure that never this kind of society would be ours. I don't want our boys to grow up in that kind of society where women are merchandise. Thank you, Mr. Speaker.
Questions and comments.
Questions and comments. The Honourable Member for Brossard-La Prairie. Thank you, Mr. Speaker, and I'd like to congratulate my colleague from the HoC for her bill and for having fought hard in this area. I know that she worked very hard with regard to the bill, and that is why we're very proud to support the bill. One of the things that I wanted to talk about when we looked at the bill in committee, the Standing Committee on Justice, there was a discussion, and very clearly with regard to sexual exploitation, but also this bill goes further and will protect with regard to human trafficking and sexual exploitation. If we talk about forced labor or domestic labor, I'd like my colleague to talk more about that aspect as well. Thank you, Mr. Speaker. The Honourable Member for Huntsic. Thank you, Mr. Speaker. And I want to thank my colleague for that question. In fact, he is quite right. This is a bill that concerns human trafficking, and we know that human trafficking involves, yes, most victims, I would say, the majority of victims in Canada are in fact people who are victims of sexual exploitation, about 80%, sometimes even 90%. But yes, in fact, there is a minority here in Canada, but elsewhere in the world. I'm talking about large figures. I could give you figures in the world. We're talking about 115 million children around the world. I fell off my chair when I heard that. We're talking about 115 million children. But there are those who have forced labor, who are in servitude. We talked about that aspect with a number of witnesses, and we see this in the cases of the domestic laborers, and this bill will protect those individuals as well. Questions and comments?
For Kildonan St. Paul.
Thank you, Mr. Speaker, and I'd like to congratulate the member from the HoC for bringing forth this bill. You know, in the comments, you had the member had a very compelling speech today, Speaker. And I think in this House sometimes we hear many speeches and we forget to listen to the kind of thing that very young people go through. And I would like, for those that missed what the member said, go through the pain that these young people go through when they are exploited and trafficked in such a horrendous manner.
Member for Huntsic. Yes, I want to thank you, and I want to thank my colleague. I know that she is somebody who, as soon as I met her, she has been fighting to ensure that there is effective legislation on human trafficking. And yes, it's true. There is a lot of people who are suffering here in Canada at present because of this phenomenon. We must stop believing that human trafficking and prostitution are different things. They are not. And I would like to tell my colleague and to the government, it is high time for Canada to table real legislation to fight procuring and prostitution, to eradicate this type of crime, and for the government to be forward-looking. And if I was with you, I would say, let's pass that legislation altogether, and we could be that generation of MPs who have allowed Canada to be as modern and as to protect the victims as we see in the Scandinavian countries, including Sweden. Let's be those kinds of people.
Questions and comments. The honourable member for Vancouver Quadra.
Merci, Monsieur le Président.
Thank you, Mr. Speaker. And I want to congratulate my colleague from HoC for her bill, as well as for her speech. It's a very important subject. We're talking about the protection here of women and very vulnerable individuals, and I agree that prostitution is rather an issue of violence against women and children. We're talking about a form of exploitation. And I want to ask my colleague, since I heard that there is the idea that legalization will ensure better lives for those who are being prostituted. Women on the streets could therefore work in brothels and they would be better protected. And this is probably not the case. And they would not be safer as a result of legalization.
The honourable member for Hunsik. Thank you, Mr. Speaker, and I thank my colleague very much. It's an excellent question. My opinion is that no, brothels do not protect, and I gave you the example of Germany, which has 2,500 or 3,000 brothels, and it does not protect women in any way. It doesn't diminish human trafficking, and furthermore, I gave you the example of the mega brothels, where, pardon the expression, Mr. Speaker, but women are treated like dogs. There were 1,500 men who'd go to these mega brothels near the airports, and they were complaining on the internet that she wasn't usable because 30 men had gone before. So brothels don't protect women, they just legalize the violence against women. I'll give you an example. Is the fact of legalizing, would the fact of legalizing homicide make it less violent? No. Prostitution is violence practiced against women and children, and we should eradicate it in this country. Resuming debate, the Honourable Parliamentary Secretary to the Minister of Justice. I'm pleased to rise in this debate today to support the private member's bill C-452, an act to amend the Criminal Code exploitation and trafficking in persons. I would like to thank the member for Hunsik for having tabled this important bill. Bill C-452 essentially is intended to strengthen the response of the justice system against one of the most heinous violations of our fundamental rights and freedoms, which is trafficking. It is generally recognized that trafficking in persons includes 3 stages: recruitment, transport, and harboring of another person for a specific end: exploitation, usually it's sexual, or for forced labor. The existence of any of these factors is enough so that the behavior be considered trafficking in persons. Someone who recruits a victim in order to exploit them is just as guilty of trafficking as the person who transports or harbors that person for those ends. Traffickers force victims to work or offer their services under circumstances where they believe that a refusal on their part would put their lives in danger, or that of a person they know. The expression labor or a service includes all kinds of sexual services, domestic services, farm work, work in a factory, or others. The victims are subject to physical, sexual, and psychological violence, and they have to face the threats of violence to their nearest and dearest, particularly physical violence, and this can be carried out. Such a serious crime requires taking the most rigorous measures in our criminal law. My member, in fact, the member from Kildone and St. Paul, tabled 2 bills to fight against these reprehensible crimes. We have to all do our part in this regard. I have seen that the Justice and Human Rights Committee has made amendments to this bill. Furthermore, I believe that my colleague who tabled the bill is of the opinion that the amendments contribute to the important aims of the bill, particularly to oblige the offenders to be responsible for their acts, that it provides for penalties that take into account the gravity of the crimes and ensure that these people cannot benefit from the proceeds of their illegal actions. Before making comments on this bill, I would like to say why I want to support it, and I'd like to put it in context. This bill allows for the broadening of the comprehensive framework of the legislative provisions to fight against the trafficking in persons. In 2005, 3 offenses were added to the criminal code in this regard. In 2010, a new offense dealing with trafficking in children was added following the enactment of Bill C-268, sponsored by the member for Kildone and St. Paul. This offense is subject to mandatory minimum sentences when the victim is under the age of 18. In 2012, another bill sponsored by the member for Kildone and St. Paul gave extraterritorial or territorial jurisdiction on all offenses dealing with trafficking in the criminal code, and created a tool to help the courts in the interpretation of these provisions. This prevents transnational trafficking in persons, and this is under Section 118 of the Immigration and Refugee Protection Act, and it also deals with forcible confinement, kidnapping, sexual assault, and uttering threats. It is possible to do more, however. Bill C-452 provides, first of all, for the creation of a presumption of evidence that allows us to help the Crown prosecutors establish the perpetration of such a crime. We know that these victims are vulnerable and that they fear the traffickers. They would certainly hesitate to testify, and the presumption allows prosecutors to establish the perpetration of the offense for the accused when the accused lives with or is habitually in the company of the person who was exploited. The Justice Committee amended this provision in order to make it more compatible with other similar presumptions already provided for in the criminal code, particularly under Section 212.3, which establishes a presumption that is applied in the context of provisions on procuring, under subsection 212.1J and subsections 212.2 and 212.2.1. Prosecutors also have difficulty with the evidence of the perpetration of an offense when the victims are so afraid of their pimps, too afraid to testify against them. In 1992, the Supreme Court of Canada confirmed the constitutional validity of this presumption in R versus Downey. The final observations of the majority justices said the following, and I quote, "Prostitutes are a particularly vulnerable segment of society. The cruel abuse they suffer, inflicted by their parasitic pimps, has been well documented. The impugned section is aimed not only at remedying a social problem, but also at providing some measure of protection for the prostitute by eliminating the necessity of testifying." That's paragraph 57. No one would deny that the same considerations would apply to victims of trafficking in persons. Bill C-452 also requires sentences being imposed on a person for an offense and that they be served consecutively after any other sentence in connection with the same offense. The establishment of mandatory consecutive sentences sends a clear message The carrying out of such a crime represents a long prison sentence. Is this not a message that we want to send to the people guilty of such a crime? There are very few offenses that deserve such a heavy sentence, and I applaud this proposal. Bill C-452 also requires that an offender refute the fact that he would not keep his proceeds of the crime under the provisions of the criminal code. Trafficking in persons necessarily means that someone is benefiting from another's suffering. In fact, they estimate that $10 billion per year is generated by this crime on a global scale. And, Mr. Speaker, this is unacceptable. Trafficking in persons, therefore, figures among the 3 most lucrative activities for organized crime. We have to ensure that this not be allowed and that these traffickers not be allowed to keep their ill-gotten gains. It is essential to deprive them of this financial benefit in order to guarantee the capacity of the criminal justice system to bring these people to justice and bring them before the courts. Justice is not served if these offenders can benefit from the suffering that they've inflicted on others. These provisions provided for in Bill C-452 bring a contribution to the legislative framework to fight against this crime, and it completes this multifaceted response to a complex problem. I'm particularly pleased to say that the government on June 6 launched its National Action Plan against traffic in persons, and this recognizes our exhaustive approach, comprehensive approach to this crime by consolidating our efforts and emphasizing the 4 Ps: protection of victims, prosecution of offenders, partnerships with key stakeholders, and, of course, prevention. All of these activities are coordinated by the Working Group on Trafficking in Persons, which is led by Public Safety Canada. This demonstrates that Canada currently has robust ways of dealing with this problem. However, that doesn't mean that we cannot do more. We have to be vigilant and do everything that we can in order to ensure that this initiative be rigorous, as rigorous as possible, and to ensure that we can do the most we can. Bill C-452 is precisely an example of what we can do. We support Bill C-452. It allows us to contribute to getting guilty pleas to guarantee the punishment fits the crime and to deprive delinquents of their ill-gotten gains. Mr. Speaker, I'm of the opinion that all members of this House should join me and support this bill. Thank you. Resuming debate, the Honourable Member for Brossard-la-Prairie. Thank you, Mr. Speaker. It's an honor for me to rise in the House today to talk about Bill C-452, which is a bill to amend the Criminal Code, exploitation and trafficking in persons. First of all, allow me to congratulate my colleague from HoC for her work. I know she has worked a tremendous amount on this bill, and she has brought this bill to Parliament so that we can debate and discuss it, and it's a wonderful work that she's done. And I really want to emphasize the work that has been done to this effect, and also the support that the NDP will provide for this bill. Of course, when we're talking about such a bill, let's say there is a lot of emotion. As the assistant critic for justice for the official opposition, I have had the opportunity to hear many witnesses who came to testify before the committee about on this bill. And often, Mr. Speaker, I would have to say that it's very moving, and it really does something to us when we become aware of the realities. And if you heard the victims who came and testified before the committee, have all of my sympathies, and once again I really commend them for their courage for coming and testifying about what's happened to them. We also heard from experts who came and testified from various community associations and from police associations as well. So they all talked about how important this bill was and to what degree this really could change things and move this issue forward. This is a real concrete problem that exists in Canada when we're talking about trafficking in persons, human trafficking. It's a heinous crime, and indeed we need to amend the criminal code to ensure that we deal with this. So this is one more step that we could take in that direction. Unfortunately, we did hear some testimony about the lack of resources. So it's well and good to have this kind of a bill, but we need resources on the front lines, and we'll continue to push the government to ensure that that's the case, to make sure that it doesn't remain just a bill, it's not just words on paper, but that we really will be able to do something for you. Now, I'll talk rapidly about what C-452 does. We're at the third reading stage.
Actually, the Bill C-452 actually amend the criminal code to provide consecutive sentences for offenses related to procuring and trafficking in persons. It creates a presumption regarding the exploitation of one person by another and adds circumstances that are deemed to constitute exploitation. It adds the offenses of procuring and trafficking in persons to the list of offenses to which the forfeiture of proceeds of crime apply. On l'a entendu justement de la part.
And indeed, we heard from witnesses that this whole aspect of the changes made to the criminal code is so important, both in terms of the presumption and the additional resources required. All is important. And when you talk about consecutive sentences, that's sometimes a bit controversial, but we can support it in this context because these are very serious crimes. So what is human trafficking? Well, according to the RCMP, human trafficking involves the recruitment, transportation, or harboring of persons for the purpose of exploitation, typically in the sex trade or for forced labor. Traffickers use various methods to maintain control over their victims, including force, sexual assault, threats of violence, and physical or emotional abuse. So it's an issue that I raised talking to the sponsor of the bill. It's important to see that, yes, we are attacking that sex industry aspect of it, but also the forced labor, because that's a very serious problem as well. Perhaps even worse abroad, but it does exist in Canada as well. It was important for me at the committee to really emphasize the fact that it's a problem that exists here. And happily, this bill deals with both aspects of the problem, and sometimes we're talking about domestic workers too. So in terms of victims, as was mentioned when we were in the committee, it was very touching, very moving, it was very emotional. And what we saw was that there are many different people who are affected. So when we hear people who've talked about their experiences, someone who's been kidnapped, for example, there's no one who could remain unmoved by hearing that kind of testimony. So once again, I had so much sympathy and empathy for the victims. It's important for them to talk about it. It's important for them to get out and get help and talk about the problem, and we have to act on this. The person has to be aware. People in the police forces have to be aware of this and listening to them as well. When we talk about this, the RCMP estimates that some 600 women and children come into Canada every year for the purpose of sexual exploitation, and it goes up to 800 if you take into account the people who come illegally into the country from other kinds of forced labor. So there are, as I said, two aspects of this bill. When we look at the numbers of victims, unfortunately, they are mostly women who are exploited, and even worse, in my opinion, there are a great many of Aboriginal women, so there's a tremendous problem in that regard. Not only are women exploited, but also when we talk about Aboriginal women, sometimes we see this with the government as well, that there's just a lack of resources for Aboriginal communities, and It's another indication of the problems that exist in that regard. We'd like the government to work more on providing those resources where they're needed. Of course, there's the whole issue of collaboration. We have to work with First Nations and Métis and attack this problem and work to fight against this.
And unfortunately, once again, there's not enough funding for these communities, and this just aggravates the situation. Mr. Speaker, we have the impression that when we talk about human smuggling, that it's impossible that something like that could happen in as developed a country as Canada, but unfortunately it does exist. And even in my writing, I met with people from the Longueuil Association who clearly explained to me that even in my writing, when we talk about the discount, the 1030 area, there is this scourge exists, and so it makes us realize that this is a real problem, and that is why I'm proud to support this bill so that we can tackle this problem. But the reason I mentioned my writing is that we have to realize as parliamentarians that this problem exists. We need to open our eyes, we need to discuss it, and that is why I'm very proud today to support this bill. Now, I had also pointed out the issue of resources. It's very important, Mr. Speaker. We need to offer the resources that are needed. There was a plan that involved policemen, police officers, to provide them with the resources they need to tackle this problem. I mentioned this. This is a step in the right direction, but the people who work on the ground need these resources, and unfortunately when we look at what's happening, and once again I mentioned my writing, but in my writing what I had learned is that there was a group that was called Project Eclipse. There were 10 to 15 people, police officers from a number of municipalities who were assigned directly to this problem to tackle street gangs, everything around human smuggling, and unfortunately the federal government cut the funding for that project, and that was on April 1st, 2013. And so what I was told on the ground is that those people had to go back to their offices. All the expertise that they had accumulated had to be shelved. They had to work on these files, but they had to turn over these files to people who had no expertise. And so when we say that, yes, it's good to have a bill, but we also need the resources. The government does not tangibly act in some cases, so it's kind of hypocritical on the part of the government to say, yes, we're fighting this problem, we're putting forward bills, but concretely, this was a group who was working in my writing, and they have no more funding to do the work that they were doing, so I find that regrettable. Do I have any time left, Mr. Speaker? Does it all? All right. So I would just like to close by saying how important it is to fight trafficking in persons. We in the NDP, we say that it is not a partisan issue, and that is why we are proud to support this bill, so that we can eradicate this scourge. Thank you.
Reprise de débat.
Resuming debate, the honourable member for Saint-Maurice Champlain. Thank you, Mr. Speaker. The tabling of a bill concerning the trafficking in persons, supported by the Liberal Party, highlights in this House the darkest aspects of the human soul. Women, children, and men are deprived of their freedom and their dignity. Examples of abuse and torture are flagrant in many countries on all continents. It is virtually impossible to restrict human smuggling to one country, city, or community. Children become soldiers in regional conflicts. Women are sexually exploited in the Western world, and men are forced into slave labor in farming enterprises in the Old and the New World. Often, we are powerless witnesses to all kinds of exploitation. In previous centuries, the slave trade was the foundation for colonial establishments in Dominica, Haiti, and Senegal. From the countries of the Andes to Asia, this form of exploitation of humans prospered. We wrongly believed that the elimination of the slave networks during the colonial period had ended, but we can see the reality today, and this dates back to this colonialism where servitude played a fundamental role for the very basis of our economy. Today, we try to pinpoint these new networks of exploitation that are part of our systems of production, distribution, and consumption. Children who toil away on machines to produce consumer goods exist in the thousands across this planet. Women who sell their bodies to support pimps are so numerous that we can't count them anymore. And men are exploited on farms with no hygiene, where they are worked to exhaustion. All products and services are used to exploit, abuse, and discriminate all these young women and young girls who are raped and held against their will. And all this is because of reasons of power and the lack of justice. So this bill has been brought forward. Bill C-452 asks a fundamental question with regard to the trafficking in persons. How can we stamp out this phenomenon, which is growing increasingly and is taking on unusual forms? The world is becoming more interdependent and allows us to put forward principles that underpin democratic systems, but it also allows for the proliferation of criminal systems of individual exploitation. Canada's role with regard to protecting individuals has become more complex given the new human mobility that is allowed by modern forms of transport. So how can we protect children, for example, from mandatory enrollment in armed conflicts? Joint action has been taken by different countries who have followed the lead of people such as General Romeo Dallaire, and this has called upon us to sign international treaties and conventions. The same applies to the exploitation of stateless workers who must benefit from international labor organizations. Women who are exploited for sexual purposes cannot be pushed back outside of our borders. They also need our protection and that of other nations in the free world. However, Canada's ratification of the additional protocol of the UN on the repression of human smuggling, particularly women and children, is a step in the right direction, but it must also be supported by criminal constraints that will limit the leeway of people who abuse and exploit others. Obviously, this is a good bill, and its purpose is laudable. We are listening to the needs of victims of these exploitation systems, and we believe that the parliamentarians in this House are all aware of the social ravages caused by trafficking in persons. In other eras, abolitionist legislation had a certain effect. The slavery put in place by colonialists no longer exists, but has been transformed into another insidious form. We strongly support this bill and its goal to eliminate trafficking in children, women, and men. We are with you in this fight for freedom and dignity, but given the scope of this phenomenon and its consequences, we can only realize how limited we are with legal interventions. Today, humans have the financial and technical means to eliminate human trafficking, but do human beings have the empathy and awareness necessary to do so? The debate brought forward today by these amendments to the Criminal Code must go beyond parliamentary life, and this is a step in the right direction. But the supervision of the consecutive sentences provided for in this bill and the presumption of guilt, which were created by the fact of living with an unexploited person, is it contrary to the principles that this bill claims to defend? In Canada, for the past few years, we have unfortunately witnessed major restrictions of judicial discretion with regard to sentences imposed under the Criminal Code. How can we reconcile the eradication of systems of trafficking in person while respecting the fundamental rights enshrined in the Canadian Charter? How can we reconcile the imposition of new criminal restrictions with modern slavery in symbiosis with the Universal Declaration on Human Rights? We are faced with a huge challenge, that is, of making our domestic legislation consistent with major humanistic principles that guide our society. It is an inspiration to see the initiative of our colleague who is seeking with us to stamp out this scourge. We believe that the elimination of these practices calls for other political actions, such as those presented under this bill. The federal policy is clear as to the education actions to be taken here and abroad to change this abject behavior. The different types of trafficking in persons in Canada is raised in a report published in 2010, which leaves no doubt as to the dimensions and the forms of modern slavery. We must tackle this 21st century challenge, which is to restore to millions of individuals their rightful place in dignity and in respect. Therefore, we must be vigilant with regard to all of our actions that would have an impact on victims of trafficking in persons. Our policies regarding refugee protection and foreign affairs, as well as our financial investments and our criminal system, are all elements that can contribute to eliminating trafficking in persons. I repeat that the Liberal Party will be supporting this bill. Thank you.
Before I recognize the honourable member for Kildonan and St. Paul on resuming debate, I'll just let her know there remains only 7 minutes in the time allocated for private members' business this evening. So, of course, she'll have the remaining of her 10 minutes when the House, of course, next resumes debate on the question. The honourable member for Kildonan and St. Paul.
Thank you, Mr. Speaker. And I would very much like to thank the member again from Luhansk for Bill 452. It's a very important bill, and we've talked tonight about the importance of the bill, the consecutive sentencing, and the elements are in the bill that's going to enhance the criminal code here in our country. And that's very important. Our government on this side of the House, Mr. Speaker, is supporting this bill. And I have to say, I would like to comment on some of the other comments that have been put forth in this House, because just a week ago I was in Ukraine. I led the Canadian delegation against human trafficking to Ukraine. Ukraine was hosting a summit, a meeting on human trafficking. 52 countries attended. And I have to say that as I was sitting there, each country was talking about what happens to the victims of human trafficking, what happens to the victims who are pushed into the brothels. And the member from Luhansk spoke very eloquently about what happened to the girls, young women and young men who are forced into those brothels. And for one moment, parliamentarians all across the nations were sitting together, non-governmental organizations were sitting together, and they were talking about what we all know about. And up on the screen came those gateways and those routes that the human traffickers use with their victims. They were all over the map. And in this country, in Canada, the traffickers use certain routes where they send their victims, and their victims go through their own private hell. What a lot of people don't know is that they target the young people under 18 years of age. Why? Because they're easy to manipulate, they're easy to scare, they're easy to be told what to do, and they're afraid and ashamed. As soon as they service one man, they're afraid and ashamed. And the predators use that so they can manipulate and coerce the girls. A victim brings in between $250,000 and $260,000 per year for their predator. That is really a lot of money. If you have one victim, that is one thing, but many of them have a lot of victims that they traffic across this country. And for one moment in this Parliament tonight, I would like you to imagine your own daughter, your own grandchild, and how you relate to them, how the community out there listening to this telecast tonight relates to their whole families. Because these are children who watch Sesame Street as young children. These are children who give you hugs when they go to bed at night. And then they become beautiful young girls, beautiful young boys. And that's when they're targeted. And how the predators work, and you must know this, all parliamentarians must know this, that the predators approach their victims in a very friendly manner. They get their trust. And what their objective is to get their trust so they can start influencing them. And sometimes it's young men or women who give the kids anything that they want. It can be friendship. It can be parties. It can be sometimes drugs. It can be a lot of things. But their objective is to get them away from their support systems. Those support systems can be schools. Those support systems can be families, can be friends, can be sports teams. They want to get them away and separate them from their support systems. Once they get them away, they persuade them to give them their identification. That identification can be driver's licenses, it can be charge cards, it can be anything. And parliamentarians, if you think it can't happen to the girl next door and to your family, you would be mistaken. I have had hundreds of young girls who have shared with me the terrible experience they went through and to this day have not told their parents. And I have to say that it marks the victim forever. A lot of these girls never really get over it, but they do grow and get rehabilitated to a degree. And they do a lot to help others who are in the same predicament. So tonight when we talk about 452, let's put a face to the real people that it affects. The real people that have to live with it day to day. The real people that tonight are suffering, not 10 minutes from Parliament Hill, because we had Mrs. Emerson, as you know, a very well-known case here in Ottawa, and other cases in Ottawa, 10 minutes from Parliament Hill, whose victims were manipulated. And so as parliamentarians, we do have the wherewithal to take up the torch and to stop this horrendous crime. And in Ukraine, 52 countries were saying, Mr. Speaker, 52 countries were saying, we have the ability to stop human trafficking, and we will do it. And as I was sitting there in closing, I have to say to you that as I was sitting in Ukraine, in Kiev, Ukraine, there came an email from Calgary, Alberta. And in that email, Sergeant Rutledge and the Calgary police had taken down a trafficking ring and rescued some kids. So I stopped the meeting and I said, I have to read this email to you. I read the email and there was not a dry eye in the place. these very high-profile, very high-level conference people knew what this was all about. And so I said, this is why we're here today in Kiev. And I say to you tonight, this is why we're here in Parliament, working together as parliamentarians to stop this horrendous crime.
The honourable member for Kildonan St. Paul will have 3 minutes remaining, should she wish it, for her remarks when the House next returns to debate on the question. The time provided, la période prévue pour...
The time provided for the study of private members' business has now expired, and the order drops to the bottom of the order of priority.
Government bills comments. Reprise du débat.
Resuming debate at third stage of Bill C-54, an act to amend the Criminal Code.
Debate, the honourable member for Brampton West.
Well, thank you very much, Mr. Speaker, and I am very pleased tonight to be speaking to Bill C-54, which, as a member of the Justice Committee, I had the opportunity to review the legislation in detail. I had the benefit of hearing witnesses who would come to the committee and testify with respect to this piece of legislation. And, of course, we heard people that were both strongly in favor of the legislation, and that, of course, were people who had, of course, been victimized and were victims of people who ultimately became NCR accused. They had certain things that they thought this legislation would do to help them. They had some other comments. We also heard, Mr. Speaker, from some people that had concerns with respect to the legislation. I would respectfully submit that when we deconstructed most of those arguments or concerns that people raised at the committee, those concerns were in fact as a result of either not understanding the legislation or having not read the legislation, or perhaps a combination of both, because most of the criticisms really did not withstand an examination by members of the committee. I want to talk a bit about what this legislation does, and I want to start off with some of the key changes. In my view, one of the key changes that we have, and I'm going to go through 4 of these, in C-54, starts off with making safety of the public to be the paramount consideration when determining whether or not somebody who has been found not criminally responsible is going to be released into the public. And so, as I've often done when I get up and I talk about these particular pieces of legislation, criminal justice legislation, many of the things that we've brought forward, I say that so many of these things that we put forward, they actually just make sense. They make common sense. When you talk to the average Canadian on the street, or, you know, for me, Mr. Speaker, when I go and talk to them in my riding of Brampton West, and you explain some of these things, and you say, this is the change that we're going to make with this particular bill. Oftentimes, the response is, really? You had to make that change? Boy, it just makes common sense that that would be the law. Why would you have to make that change? So when we talk about safety of the public is paramount, what you look at is when a court or a review board is going to make a disposition with respect to an NCR accused, they're going to take safety of the public as the paramount consideration. Now, not only does that make sense, Mr. Speaker, it is, of course, we're codifying some of Supreme Court jurisprudence in that area. So, in R versus Conway, it was made very clear by the Supreme Court that safety of the public should be the paramount consideration. So when we go through that and when we amend that section, which is section 672.54 of the Criminal Code, we make it clear that when a court or a review board makes a disposition, it shall, taking into account the safety of the public, which is the paramount consideration, the mental condition of the accused, the reintegration of the accused into society, and other needs of the accused, make one of the following dispositions, and here's the next change, that is necessary and appropriate in the circumstances. Again, that just makes sense. You're going to make a disposition that's necessary and appropriate in the circumstances. The next major substantive change is incorporating what we call a high-risk accused. Now, there have been many that have come to this committee and are saying, well, this is going to stigmatize people. I mean, how dare you call somebody high risk? This is a person that has perhaps a significant mental disorder and you're stigmatizing them. Well, I would say the exact opposite, Mr. Speaker. In fact, you're not stigmatizing people that have mental health issues, because what you're actually doing is saying there's a select few that might be high risk. You're destigmatizing everybody else because people then know they are not high risk. So when you look at the section, when you talk about this, and this is where I went back to over and over again at committee when I would talk to people that were raising concerns about these issues. Let's look at the section. Quite clearly, section 672.64, it states, on application made by the prosecutor before any disposition to discharge an accused absolutely, the court may, at the conclusion of a hearing, find the accused to be high risk. So first of all, we've got a number of processes that are taking place here. Number one, it's an application that may be brought by a Crown attorney. It's not saying a Crown attorney is going to bring this application for every single person who is found to be NCR. Quite the contrary. I know Crown attorneys. In fact, you know, my wife's a Crown attorney. They're hardworking people. They're not looking for extra work to do. They're not going to go through and try and dig up case files and say, let's try and make this person high risk. No. It'll be reserved for cases where there's a significant concern. And even then, though, even if a Crown prosecutor has that significant concern, it does not mean that that person is going to be designated high risk, because it's a twofold test there. First, the Crown prosecutor has to bring the application. Second, they have to convince a judge that the high-risk designation is necessary in the circumstances. And when we go back to that, we look at what the test is. And so if I go back to the section, at the conclusion of the hearing, the court may find the accused to be a high-risk accused if the accused has been found not criminally responsible on account of mental disorder for a serious personal injury offense, and the court is satisfied that there is a substantial likelihood that the accused would use violence that could endanger the life or safety of another person. When you listen to that section, I mean, when you really take the time to listen to that section, what it's saying is that for a person to be designated high risk, a court has to be satisfied that there is a substantial likelihood that the accused would use violence that could endanger the life or safety of another person. Again, this to me seems absolutely common sense. Why would we consider an absolute discharge where a person is going to be released into the community if they may be at a high risk, a substantial likelihood that they will use violence that could endanger the life or safety of another person? So that's the part of the test that's being changed. I'm quite sure it's going to be used both judiciously by our judges, and it won't be used all the time by Crown attorneys. The second way that someone can be found high risk is if the court is of the opinion that the acts that constitute the offence were of such a brutal nature as to indicate a grave risk of physical or psychological harm to another person. Now, that is a section that a number of people have come to this committee and they've said, oh, wait a minute, no, there's something wrong here. You're going to say it's brutal. You're going to say if it's a brutal offence, that person is therefore high risk. Well, that's actually not true. And a number of witnesses came and made that statement to committee. They actually said, oh, you know, if it's a brutal offence, that person's going to be high risk. So again, Mr. Speaker, I had to walk them through the section. First of all, it does not just say brutal. I mean, when you look at these things, just look at the section. It doesn't say that. It says, if the court is of the opinion that the acts that constitute the offence were of such a brutal nature as to indicate a risk of grave physical or psychological harm to another person. Again, it's saying there has to be some correlation. What we're saying is it's not just brutal. It's brutal such that there's a risk of grave physical or psychological harm to another person. So if anyone wants to get up and suggest that you're saying brutal, high risk, they're not being truthful, Mr. Speaker, or they didn't take the time to read the section and understand what it says. Now, that's not enough, actually. It doesn't just mean that you have to indicate a grave risk of physical or psychological harm to another person. That's not it, because there's another section. Subsection 2 goes on to say factors to consider in deciding whether to find the accused is a high-risk accused. Now, that could be under that first part of the test that I talked about or the second part of the test. In either case, a court has to be satisfied, and they take into consider all relevant evidence. All relevant evidence. It gives a list, says including, but when you use the phrase all relevant evidence, it doesn't mean actually that you're constrained by the list of factors in the list for a judge to consider. It's a non-exhaustive list. But when you look at it, so not only, even if you accept that argument brutal, you then go down and look at what else has to be considered. The nature and the circumstances of the offense. Any pattern of repetitive behavior which the offense forms a part. The accused's current mental condition. The opinions of experts who have examined the accused. So even if someone tried to bring an application under the so-called brutal nature section, a court is going to have to look at all the evidence, which would include such things as the opinions of experts who've examined the accused. So, Mr. Speaker, I think the criticism with respect to, and if I can call it that this might lead to a brutal crime, meaning the person is high risk, is just, it doesn't hold water. It's not a legitimate argument because the section in the statute says something very different. Another issue that was raised at the committee is that the review board, if somebody is designated high risk, that person has to wait 3 years for their review, and that this is not a good thing. Well, I can tell you, Mr. Speaker, that's absolutely not true. You do not, it is not automatically 3 years. In certain circumstances, the review for a person who has been designated high risk can be moved to 3 years. But it's not automatic. And it's interesting, actually, because the person that raised that this is automatic 3 years was Justice Richard Schneider, who came to the committee, provided us with his evidence on this, and suggested that the 3 years is mandatory. Well, I asked him if he could show me where it says that in the section, and I understand there was constraints of time. We were talking. He couldn't find it. But when I look at the section, which is right here on page 8 of the statute, look at around line 20, there's 2 ways in which this review can be extended to 3 years. So number 1, it can be moved to 36 months after reviewing a disposition if the accused is represented by counsel and the accused and the Attorney General consent to the extension. So that's number 1. It has to be on the consent of the accused. And of course, because we're dealing with an accused, and in this case in particular an NCR accused, it has to be represented by counsel and with consent of the Attorney General, because of course you want to make sure that you have real and legitimate consent to extend something to 36 months. Now, the other extension is, and I go to the section again, and I keep going back to this, Mr. Speaker, because you have to read the section before you decide to make the commentary. It talks about, at the conclusion of a hearing under subsection 672.47 sub 4 of this section, in respect of a high-risk accused, the review board may, after making a disposition, extend the time for holding a subsequent hearing under this section to a maximum of 36 months, and here's the reason. If the review board is satisfied on the basis of any relevant information, including disposition information, and an assessment report made and offered under a certain paragraph, and here's the key, that the accused's condition is not likely to improve and that the detention remains necessary for the period of extension. So there's a burden of proof that has to be met in order to do that extension. Now, one of the things that was quite clear at committee, this was virtually unanimous, is that review boards do good work. They work hard, they understand the law, and we're putting that decision, the 36 months, back with the review board. Now it's interesting because we did have a witness who came to the committee and who was suggesting that that there's a problem with this 36-month review. Now, again, when you look at the section, it's only if the accused condition is not likely to improve and that detention remains necessary for the period of the extension. Well, interestingly enough, Catherine Latimer, from the John Howard Society, when I had the opportunity to discuss that with her, her response was that, yes, I noticed that, but you will find if you give very burdened organizations and review boards an option to extend the review periods, they always take it to the outer limit. So she's basically suggesting that a review board doesn't care about what the test is. They don't care if the accused condition is likely to improve or not. They're just going to do it to 36 months because they don't want to work, because they have too much work. This is one of the people that came to the committee to suggest this bill shouldn't pass, and that was the argument. Well, Mr. Speaker, I vehemently disagree with that position being put forward. Now, finally, Mr. Speaker, I'm going to talk quickly about the rights of victims, which is an important aspect of this legislation. I can tell you I heard what I consider to be, in very many circumstances, absolutely heartbreaking testimony from people who came to talk about family members who had been killed by an NCR accused, to talk about children, their children being killed. These things, you hear them, and it is very difficult to listen to that kind of testimony. But what I can tell you is some of the things that they were unhappy with and things that we want to fix. We can't fix what happened, and we all know that. But some of the stories, for example, and I can't remember who came and told us this story, but they were walking in a mall, and bang, they bumped into the person that had, the NCR accused who had committed those acts of violence against their family member, and they were in a panic. So guess what? One of the things we have in here in this section, in the revision in this act, is notice of discharge of an NCR accused to the victims. So they're going to receive a notice when an NCR accused is going to receive an absolute discharge. What a huge step up that is. Now, victim impact statements. We're also making victim impact statements mandatory to be, if the victims want to make a statement, they have to be considered before a disposition is made. Non-communication orders, again, so that if a victim does not want communication from an NCR accused, they don't have to have it. Common sense seems to make sense. And, Mr. Speaker, what I can say in a great example of some bipartisanship at the committee, an amendment was brought forward by my colleagues in the NDP with respect to let victims know the intended place of residence of the NCR accused. Now, again, that goes back to that story of someone bumping into the NCR accused in the mall. If you know they're being discharged, you know where they're being discharged to, you increase the chance that you're not going to have that unfortunate incident. I know I'm running out of time, Mr. Speaker, but I want to point out another thing that was raised at committee was that NCR accused are going to be put in jail. That's what this legislation does. That was put forward by Mr. Fedorov, Dr. Paul J. Fedorov. And so I asked him, where in the section, where in the legislation does it say that an NCR accused is going to go to jail? Couldn't point it out. In fact, I then walked him through the section to talk about what happens. And when you deal with an NCR, when you deal with someone being deemed high risk, they get put into treatment. And you go back to terms of disposition, which is section 672.54, sub C. And it says, by order, direct that the accused be detained in custody, and here's the key, in a hospital. So somebody who's designated high risk is not going to jail. I don't know where that came from. It's not true in the legislation. They will be put in a hospital for treatment. And when I pointed that out, the response was that, well, before they are declared NCR, they're going to be put in a jail, and that's the problem. Well, the answer to that is that's what the system, how it currently exists. And when somebody has committed a serious crime and they're awaiting trial, if they don't get bail, they're in jail. This does not change that. Mr. Speaker, this is a piece of legislation that is going to be moderately used. It's a tool. I like to call it, it's a double check. When a review board is about to absolutely discharge somebody, an NCR accused, there can be an application to court to say, hey, wait a minute. We think this person might be high risk and could reoffend and commit violence. Court, can you please look at this and make sure this is the right disposition? It's a sensible, reasonable safety check, and I hope it has the support of all members in the House of Commons. Thank you, Mr. Speaker.
Questions and commentaires.
Questions and comments. The Honourable Member for Abitibi-Témiscamingue. Thank you very much, Mr. Speaker. When we talk about cases of those who are not criminally responsible due to mental illness, in a number of highly media-sized cases, in Quebec often there was an opinion that came out, and I haven't necessarily taken a position, but I'd like to know if it was talked about in committee, is that a number of people said that the complexity of understanding the mental illness, and does this make the person not criminally responsible? For example, you could be schizophrenic but haven't been aware of what you were doing at the time you were doing it and therefore be criminally responsible, or you could be not criminally responsible. So the complexity of the mental illness meant that people said that when someone says that they're not criminally responsible, they should be tried not by a normal jury, but by a panel of health experts in order to really determine the complexity of that mental illness. And as I said, I don't necessarily have a position on this, but I think that this is particularly appropriate in this instance. So I'd like to know if this was talked about in committee, if this issue was talked about or not.
For Brampton West.
Thank you, Mr. Speaker, and I thank my colleague for the question. She raises certainly an interesting point. Changing the system of how somebody is designated an NCR accused was certainly not discussed at committee, but what I can say quite clearly from listening to the evidence from people, victims who came, there is certainly a concern about how people are designated an NCR accused. And I'm paraphrasing to an extent, but I think many victims feel that the NCR accused designation is applied too easily and too liberally. Of course, this legislation has nothing to do with that determination, and I can certainly understand and sympathize with why victims would feel that way, because to an extent they feel that there is no one who is therefore responsible for, in some cases, the murder of someone's children. But I thank the member for the question.
Questions and comments. The Honourable Member for Winnipeg North.
Yes, thank you, Mr. Speaker. In debating this bill, there's two issues that come to mind for me personally. One is in regards to the issue of victims. You know, I, for one, representing Winnipeg North, very much concerned about victims. In fact, to the degree in which I believe this government is doing very little to prevent victims in the first place by being more progressive in terms of coming up with ideas and dealing with some of the causes of crime. That's something in which the government has fallen short on. The other issue, and speaking specifically to the bill, I think it's important for us to recognize, and maybe the member can provide brief comment on regards to the Chief Justice of Canada from the Supreme Court has indicated that this bill is really not necessary in dealing with the mental disorders or NCRs, and that's an issue that I'd appreciate a comment on. And the other issue, very briefly, Mr. Speaker, is why it is, again, that we have this bill being rushed through in the fashion that it is being rushed through. And this is something in which we've seen a disturbing behavior from the Prime Minister's office in wanting to prevent members from being able to have proper debate on important issues that Canadians want us to be able to address. Maybe you can provide comment as to one.
The honourable member for Brampton West.
Well, thank you, Mr. Speaker. I find it a bit rich that a member from that party is somehow suggesting we're not doing enough for victims. It's, you know, it would be funny if it wasn't so tragic. We do a lot for victims. We can talk about the victims ombudsman. We can talk about the victim doubling the victim surcharge. Those are just a couple of things off the top of my head. This party, we've put in significant reforms within the NCR regime to support the requests of victims so that they're not re-victimized by the system. They're going to vote against this bill, which is enshrining significant rights for victims. So it's I don't know what the comment is to say we're not supporting victims when they're going to vote against this legislation. Yes, there has been a critic, and a good critic, obviously a former Supreme Court Justice. I respectfully disagree. I think this is necessary, it's reasonable, it's prudent, it's a second check just to make sure that we've got things right. I don't see how it can't be supported.
Questions and comments. The honourable member for Burlington.
Thank you, Mr. Speaker. And I want to thank my colleague from the Conservative Party, who is a very good member of the Justice Committee. As chair, it's been all been. I think I mentioned that, Mr. Speaker, to make sure that people know just because he's sitting on that side of the House doesn't mean he's not conservative. In fact, he's more conservative than many of us on this side of the House. But my question is this. What I find with this member that he's very, very good at is actually reading the legislation as it is placed out in front of a committee and reading the actual legislation and challenging witnesses on statements. My question, Mr. Speaker, is this. Why is it important to have the facts in front of you, whether you're a witness or a member of Parliament, in dealing with a legislative committee like the Justice Committee? Thank you, Mr.
For Brampton West.
Well, I thank my colleague for the question. It's a good one. I have to say that I was exceptionally disappointed with the number of witnesses that came to the committee to give evidence and testimony to the committee to try and help us make our decision with respect to this legislation who had clearly not read the legislation, or if they read it, didn't understand it. We can talk about the issue, and I raised it in my speech, the issue of brutality, saying, oh, if it's brutal, it's going to be high risk. Not true. Oh, you're going to put NCR-accused people in jail. No, not true. You're going to mandatorily make these assessments go on for 3 years. It's mandatory. No, not true. You know, the Justice Committee works very hard. We sat for extended hours to make sure we had as many witnesses as possible come forward, to make sure we looked at all different ways that we could perhaps improve upon this legislation. And I have to say that the majority of people that came that had concerns or objections to the legislation did not seem to understand it or hadn't read it, and I think that's disappointing.
Questions and comments. The honourable member for St. John's East.
Thank you, Mr. Speaker. I know a lot of concern has been raised about the possible stigmatization of bills like this, but I think it's important to put in perspective the kind of numbers we're talking about. There was evidence that in Ontario, only 0.001% of those convicted of a crime are found not criminally responsible. That's 1 in 100,000. So, and of those, the recidivism rate is between 2.5% and 7.5%. For other people who are before the courts and convicted of a crime, the recidivism rate is between 41% and 44%. So for those who think this is about people who are mentally ill being the problems in society, the other 99,999 people who are before the courts have nothing to do with mental illness. So this is not really about this. A very small percentage of people that are involved, and a very small percentage of them who would be in the category of having to be considered a high-risk, potential high-risk offender.
Very good point. Honourable member for Brampton West.
Well, I hate to say it, but yeah, that's an excellent point by my colleague. It's hard to say these praising things. I've done it twice today, so you know it's a good day. Look, the truth is exactly what he says. First of all, the number of people who are NCR in the criminal justice system is quite small. When you look at the other factors, which is number one, a Crown attorney is going to have to bring the application. That's going to whittle that number down significantly for the reasons that I raised in my speech. Finally, then, Crown attorneys don't win 100% of their cases. You know, being the husband of a Crown attorney, I wish that they did win 100% of their cases, but they don't. So that'll whittle it down again because the judge is going to make that determination as to whether or not the person should be high risk. So yes, when we talk about things like stigmatization, no. And I want to make it clear and have it on the record, this is not stigmatizing mental illness. It's doing the exact opposite because very few people are going to be designated as high risk, which means the people who are not designated to be high risk, the Canadian public has no reason to fear them or to stigmatize them. They're not high risk. This legislation is going to destigmatize. Thank you, Mr. Speaker.
Resuming debate. The honourable member for Esquimalt, Wanda Fuca.
Thank you very much, Mr. Speaker. I'll be splitting my time with the member for Montmorency, Charlevoix, Hope Nord. I rise tonight to speak in favour of C-54 at third reading. I must say from the day the government first announced its intention to introduce this bill, I have supported the bill in principle. I believe the matters that we are seized with in C-54 are very important, even though the number of individuals affected are very small. The unfortunate incidents which have brought us to this debate tonight are obviously extremely wrenching for all the victims and their families. Yet at the same time, there's a real danger that the very small number of extreme incidents resulting from mental illness will cloud our collective judgment when it comes to the need to address the broader issues of mental health in Canadian society. Mr. Speaker, I believe the bill we have before us today is a reasonably balanced bill. Certainly not as good as it might have been, but better in some key ways than when it was originally introduced. And to me, the most important improvement was the addition of an amendment proposed by the NDP to add a legislatively mandated 5-year review of this bill by Parliament. This is a very good way to make sure we've actually gotten this right. We'll look at it again in 5 years and see what the impacts have been. However, for me, the most important reason for supporting this bill is the significant progress it makes in enhancing victims' rights, especially in these cases where the accused is found not criminally responsible for his or her actions. And I want to draw attention to 4 ways in which the rights, and in particular the safety of victims, are improved in C-54. Most important to me is entrenching in law the right of victims, upon request, to be notified when the perpetrator is discharged. Obviously, it can be very shocking, and we've had one case of this, when someone runs into someone outside in the community who they thought was still in custody. And so, yes, it'll be upon request, but certainly victims should have that right. Second is the provision to allow orders to be made forbidding communication between the perpetrator and the victim. And third is the provision which adds a requirement for the review boards who make these decisions on the release of perpetrators to consider the safety of victims when decisions are being made about the perpetrator. And the fourth major improvement, again, was not in the original bill, but was added via an NDP amendment. And this is the provision closely related to the first improvement, which gives victims the right to be notified of the address of the perpetrator if the perpetrator is released, and thus obviously make it less possible or less likely they will have inadvertent contact with the perpetrator again, which can obviously be very traumatic. The second reason I have for supporting this bill is the fact that it now makes public safety the paramount consideration for provincial review boards in decisions relating to those found unfit to stand trial or found not criminally responsible for their actions. The change here is that public safety becomes the most important consideration, not just one of a list of considerations. And obviously our criminal justice system always ought to function with public safety in mind, so these cases should be no different. Yet, we also need to remind ourselves that public safety as the main priority does not diminish our responsibility to consider these cases and make sure that they function within the bedrock of our legal system, which is the Charter of Rights and Freedoms. The third reason I have for supporting this bill is the fact that it creates a high-risk designation for those who are found not criminally responsible for the most violent incidents. And I want to stress that we are talking about a very small number of cases where the perpetrator is found not criminally responsible. So starting with a small number of those decisions and then a very small number among that group. The definition that's provided in the bill, I think, is quite sound. It talks about applying a high-risk designation to those found not criminally responsible for serious personal injury offences where there is a substantial likelihood for further violence that would endanger the public, or where acts were so brutal as to indicate a risk of grave harm to the public. So we are not saying all of those found not criminally responsible will end up falling into this high-risk category, but only those who provide a grave risk to the public. So this is a designation that would be made by a court and a designation that could only be removed by a court. And the result of such a designation would be to deny granting unescorted absences from a secure health facility. It would place limits on the reasons for escorted absences, and it would provide the possibility, just the possibility, of lengthening the period for review of the status of the perpetrator from 1 year to a maximum of 3 years, again, at the discretion of the court. So when we are talking about creating this high-risk designation, it is important to remember the context. When considering the case of someone found not criminally responsible, provincial review boards have 3 choices. Their first choice is an absolute discharge if the person does not pose a significant threat to public safety. This means release back into society with no restrictions or supervision. I want to emphasize that very few of those who are found not criminally responsible are granted an absolute discharge at their first hearing. This is due to the obvious necessity of taking time to allow therapy to work. In fact, at the annual reviews in BC, only 18% of cases are granted an absolute discharge, while the rate in Ontario is even lower at only 5%. And if we look over time, a study has revealed that 35% of those found not criminally responsible spend more than 10 years in the system. So it is not true that those who are found not criminally responsible are released immediately as the system exists now. But the change we're making here is to make sure that there's additional consideration, a second set of eyes to look at those decisions when those high-risk designated perpetrators are considered for release. The second choice available to the expert provincial review boards is a conditional discharge. Just as it sounds, this option allows a return to society under conditions which include things like specifying a place of residence, a treatment regime, or reporting requirements. And these are conditions very similar to those used in the parole system. And of course, finally, the third choice is to retain the perpetrator in custody in a secure health facility. I know there are those who are very worried about creation of this high-risk designation, but I think its importance here is the reassurance that it will offer to both victims and the public alike, as the person designated as high risk will not be eligible for conditional or absolute discharge until both the review board and the court are convinced that the perpetrator is no longer high risk. There is now no doubt that the current system has left the public and families of victims feeling exposed. This is true if we are talking about the case of the beheading of Tim McLean on a Greyhound bus in Manitoba in 2008, where the perpetrator was held in a facility where the grounds were not fenced and was allowed out on his own onto those grounds very soon after the offense, and where the perpetrator was allowed escorted absences that were perceived to be much too early and caused a very strong public outcry. Many were not reassured by the explanation that the perpetrator was fine, quote, so long as he was taking his medications. This reassurance is also needed if we're talking about a case like the 3 Schonborn children who were killed by their father in BC, again in 2008. His ex-wife was understandably concerned when the perpetrator was granted escorted absences in the same suburban Vancouver community where she lived. From the moment the government introduced this legislation, I felt it would be in the public interest to adopt it in principle. And I believe we've had significant improvements at the committee level. But before concluding, I would like to take just a moment to address some of the concerns expressed by those opposed to the bill. First, I would say there should be no confusion. This bill in no way affects the availability, or the use of the defense of not criminally responsible by anyone accused of an offense. Second, I would say that I understand the concern that the focus on the most violent incidents involving mental illness may inadvertently contribute to the unfortunate stigma surrounding mental illness in our society. However, it's my hope that in fact this bill will accomplish the opposite by helping reduce the fears surrounding these extreme incidents. And finally, I would say that I share the concern of all those who pointed out the deficiencies in the way we deal with mental illness in our society, especially in terms of the lack of services and supports for those individuals and families struggling to deal with the impacts of mental illness on a daily basis. In conclusion, I believe that in C-54 we have before us a balanced bill, one that could have been further improved with the additional amendments that were offered by the NDP, but nevertheless a balanced bill. Most importantly, I believe that C-54 will deal more justly with victims and their families in cases where the perpetrator is found not criminally responsible. We have a bill before us that will make it clear that public safety must be the paramount consideration in all these cases. And finally, we have a bill in front of us which will address those very few cases involving extreme violence and high risk of recurrence. And it will do so in a way that will ensure a thorough review of the case in order to guarantee public safety and to reassure the families of victims. Mr. Speaker, for these reasons, I will be supporting Bill C-54 at third reading. Thank you.
Questions and comments? Questions et commentaires? The honourable member for Skeena-Bulkley Valley.
Very much, Mr. Speaker. I listened to my friend's comments on this bill. So often the case when Conservatives have brought forward so-called justice legislation, they've gotten the balance completely wrong, taking often a hammer to a problem that is of small significance or is of low numbers. As has been pointed out by my friend from Newfoundland, the actual numbers of Canadians we're talking about in this case is incredibly small, yet important. These cases often tend to be high profile, often because of the violent nature that takes place, extreme violence in some regard. I suppose what my friend has offered, that you don't want to sacrifice the good for the perfect. In seeking to find a way to better achieve the balance, we didn't get all the way there, but a great stride there. In the general question about justice and how we write laws for that area, is this a good example in which the government and the opposition can build upon to strike a better, more equal balance with respect to things? And the fact that we're under time allocation for this motion doesn't speak to a lot of confidence on the government side that they do have the right balance struck so often that they have to invoke, as today was the 50th time, to shut down debate in Parliament.
Member for Esquimalt, Wanda Fuca.
Well, I thank the honourable member for his question. Yes, I think there's some irony that the government quite often here won't take yes for an answer. So we worked together in committee, and we did have a lot more improvements that we felt could have been made to further defend victims' rights in this bill and to further increase the public confidence in what we were doing. But I think what saved it for me was the willingness of the government to accept the 5-year review, so that Parliament will come back and look at this again. And as you say, we're making an improvement, we're taking a step forward. It's not a perfect bill, but to me, having a 5-year review by Parliament will allow us to look at this again and see if we have, in fact, done the right thing or if there's more we could do to improve the situation.
Questions and comments? Questions et commentaires? The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. And I heard the speech of my friend from Esquimalt, Wanda Fuca. I am disappointed that the official opposition is supporting this bill as is. I've read it carefully and studied it, and I still do not find that it achieves the right balance between the approach to ensure that not criminally responsible system, which is currently, there is no empirical evidence whatsoever that that system isn't working and working for Canadians. We do need, I'm very supportive of the sections that give advance notice to victims. I think we could have done a better job of balancing the interests for victims' rights at the same time that we didn't need to create, for instance, the word brutal. Brutal is a word which now it's a one or the other for a high-risk accused, and if the crime committed is of a brutal category, even if it not resulting in death or other serious crime, but the brutality of the offense is in the Act as a single reason to put someone in high-risk accused category. The word brutal has no definition in criminal law, nor does it have a definition in mental health academic and scientific understanding, and therefore it creates a vast uncertainty for people who might be assigned high-risk accused. And I asked my friend about that weakness in the bill.
Well, member for Esquimalt, Wanda Fuca.
Thank you very much, Mr. Speaker, and I thank the honourable member for Saanich Gulf Islands for her question. I guess I'm bemused when she says there's no empirical evidence of a need to do something in this bill. Has she not heard the voice of victims? Has she not seen the things that have happened with victims all across the country? So I believe there is, in fact, quite a lot of empirical evidence. But what I want to say again is that I think that this bill will actually help reduce the stigma around mental illness by separating out these very few high-risk offenders who have committed what I would say are quite brutal acts. No other way to describe a beheading in public than brutal. And it will help assure the public that we have measures in place to take care of those so that we can then turn our minds to the other mental health issues in society without being worried about these extreme cases.
We have time for one short question and response. The Honourable Parliamentary Secretary to the Minister of Finance.
Thank you, Mr. Speaker. I do want to thank my colleague from the NDP for his comments with regards to the case involving Tim McLean. Tim McLean's family is a family that I'm quite close to, and Carol Dedelli will be very pleased to hear that the NDP member is supportive of this bill. I do want to assist my NDP colleague and friend by perhaps adding to the answer he just provided to our colleague from the Green Party, and just remind her that the term brutal nature has in fact been interpreted to mean, and I quote, conduct that is coarse, savage, and cruel, and which is capable of inflicting severe physical or psychological damage on the victim, end quote. That's from R versus Langevin in the Ontario Court of Appeal. So I did want to help my learned friend across the way from the NDP in answering that question, and once again thank him for his comments with regards to protecting victims and for supporting this very important bill. Thank you.
Well, member for Esquimalt, Wanda Fuca.
Well, thank you very much. I thank the member for comments, and I struggled when thinking about this speech whether to talk about the individual cases of victims, because I know it's often quite difficult for them to relive this over and over. And my hope is that in the use of these examples in this bill will help the victims' families to feel that they have, in fact, contributed something when we come to the cases of future victims. And so I do believe they will make a contribution there. And I very carefully, as I do when I talk about criminal law, rarely use the name of the perpetrator. I don't think that even in these cases the perpetrators should become famous. It's the victims that we should remember.
Resuming debate. Reprise de débat. L'honorable député de
The honourable member.
Montmorency,
Charlevoix, Haute-Côte-Nord. Thank you, Mr. Speaker. Before going to the heart of this topic, I would like to underscore an unhappy anniversary. Earlier today, we received a 50th time allocation motion, a 50th gag order. So in this 41st Parliament on Tuesday, June 17th, it is a very sad anniversary. I remember there are certain bills that I would have liked to contribute to bring an angle to the debate, coming from my riding, coming from my constituents, but I was not able to do so because there was a time allocation motion that was imposed once again that is curtailing debate, and I'm convinced that there are just as many people on the Conservative side as in the opposition who are in the same situation as I am. And I think that is the case for many government bills and other bills. With regard to this bill, I would like to say that this bill has developed greatly over its different stages of the legislative process, and that is why I'm going to be voting in support of Bill C-54. It is not perfect. There are amendments that we brought forward that were refused, but we were promised that in 5 years this bill was going to be reviewed to see whether everything was functioning as we hope it will. Public safety and the attention that is given to victims of crime are issues that we have to deal with. We managed to address problems with regard to the changes made while listening to specialists and victims. First, we must realize what public safety is. I agree that it is vital to ensure the safety of our communities, but it is necessary also to ensure the respect of the rule of law and the Canadian Charter of Rights and Freedoms. We must ensure that the way in which we manage the cases of the accused suffering from mental disorders is important. Therefore, I would like to commend the legislators for their work who drafted and especially amended this bill. A number of witnesses were consulted before and during the study in committee. We took the time to listen to victims, families, and our communities. We therefore succeeded in amending this bill to reflect certain testimony that we heard in committee, and I must say that I am reasonably satisfied with the final result. However, it is important to point out that the mental disorder regime in the criminal code applies to only a very limited number of accused. So it is always very interesting in a House to listen to debate, to be able to ask questions afterwards. That's just a bit of a digression. So people who are not criminally responsible due to mental disorder must go before a provincial or territorial review board who will determine a plan of action. So that person is neither charged nor acquitted. Once again, we're talking about a very limited number of individuals, and some of them have not actually committed crimes. Certain apprehensions were expressed with regard to this bill, and we had to ensure that we were not going to uselessly fearmonger, and we did not want to harm the integration of people who were declared not criminally responsible due to mental disorder. So we legitimately reviewed the criminal code with regard to mental disorder, which is an important matter for many Canadians. Some cases that were the object of a great deal of media attention allowed us to correct the flaws in the bill with regard to victims' rights. Bill C-54 also affects the participation of victims in the process. The ideas put forward go in the right direction. In the NDP, we certainly wanted to know above all how we could help victims in this process. The bill stipulates that victims will be advised when the criminals are released, and that the safety of victims must be taken into account when decisions are made regarding the accused. I have no problem with those proposals, but, Mr. Speaker, I do think that we need to do more to help victims. The Conservatives have often applied the same formula in past, but they do not assist victims. With this bill, at least, this is a step in the right direction. What else could we do? For example, Catherine Latimer from the John Howard Society is calling for more programs and services for victims of sexual abuse. In her opinion, she also feels that the government should invest more in preventing crime, something that often lacks in conservative ideology is prevention. So I could not agree more. Each year in Canada, the total cost of crime is some $100 billion, which is a very stiff bill for our society. With regard to people who are not criminally responsible due to mental disorder, it is important to work with key actors such as the Canadian Society for Schizophrenia to prevent crimes. But all of that costs money, engendered by all these amendments. So once again, it is the provinces who will be stuck with the bill. But with the Conservatives, we are used to seeing them stick someone else with the bill. And they also like to enforce laws according to their ideology without consulting the provinces. And I'm just wondering whether this is a centralizing government. Perhaps the Conservatives are. Provincial prisons in Canada, the governments of provinces and territories are already forced to do what they can with the needless reforms that the Conservatives have adopted. I'm not saying that any change to the criminal code is needless, but there are certain provisions that need to be studied. And in fact, I will be supporting this bill. However, certain changes made by the Conservatives did not succeed in improving the safety of our communities. All they did was to create more bottlenecks in the system. Can the Conservatives tell us whether they do have an actual funding plan to allow the provinces to apply the changes made under C-54? I would like to have the answer to that. It is important to ensure that the provinces and territories will not once again receive a bill that they do not have the resources to pay. the government could learn from its mistakes and at least accompany its reforms with compensation for the provinces, because, Mr. Speaker, you will agree that it is very easy to adopt legislation when we don't have to pay to apply those bills. Thank you, Mr. Speaker. So really, this is a simple question of justice. We in the NDP have over past months spoke with experts in mental disease, with victims and with the provinces to find out which approach they thought was best. We did not play political games. We are focused on what is the most important, that is, the studies of the merits of this policy, which, I might point out, must be adequately funded by the federal government. In closing, I would like to reiterate that public safety must be protected as a priority while respecting the rule of law and the Canadian Charter of Rights and Freedoms. It is also essential to take into account the needs of victims. This bill meets these concerns. With regard to the amendments moved by the NDP, for example, with regard to the clarification of the term brutal, which was not accepted by the government side, at least we had the guarantee that in 5 years, this bill will be reviewed to see whether this amendment was beneficial. So, Mr. Speaker, we in the NDP, we are not closed to change. We accept change. We have done our duty. We've done our homework, and we managed to improve this bill. I recognize the effort put into this bill, and that's why I will be voting in support of this bill. Thank you.
Before we go to questions and comments, I see the Honourable Government House Leader is rising on a point.
Yes, Mr. Speaker, and before I do what I'm going to do, I just did want to, at the outset, say that we have had a lot to thank the staff for here on Parliament Hill, particularly the last 4.5 weeks, but in fact the entire session and the entire time since the last election. But the last 4.5 weeks, of course, with our working the late hours till past midnight just about every night, a lot of people have been putting in a lot of work. Those who serve us, the clerks, the journalists. Security staff and the like, but I particularly like to point out at this time of year the service provided by our pages. When this House rises for the summer, they will have completed a remarkable year that they have served with us. Being a parliamentary page is a real special honour, and it's a story I know that pages always go back and or an experience for which they get to go back and tell stories for months, years, indeed for much of the rest of their life, because the experience of being a page is a very, very special one. I say this, I know we actually have, there is life after being a page, and we have within our caucus 2 people who are former pages. My own wife was, some years before I was elected a member of Parliament, indeed, a page in this place. In the same cohort, it's interesting to observe the same year as the now Chief of Staff to the current leader of the Liberal Party. So there is indeed life after this remarkable experience, but we want to thank you all for the tremendous work you do on behalf of all of us here in the House of Commons, quietly and efficiently serving all our needs here, and we appreciate that a great deal. However, those thank yous being in place, I now would like to propose the following motion for consideration of the House. I believe, Mr. Speaker, if you seek it, you will find unanimous consent for this motion, and bear with me, it takes a little bit of time. I move that, notwithstanding any standing or special order or usual practice of the House, that A, Bill C-54, an act to amend the Criminal Code and the National Defence Act, mental disorder, shall be deemed read a third time and passed on division. B, Bill S-14, an act to amend the Corruption of Foreign Public Officials Act, shall be deemed read a third time and passed. C, Bill S-17, an act to implement conventions, protocols, agreements, and a supplementary convention concluded between Canada and Namibia, Serbia, Poland, Hong Kong, Luxembourg, and Switzerland for the avoidance of double taxation and the prevention of fiscal evasion with respect to taxes, shall be deemed concurred in at report stage and deemed read a third time and passed. D, Bill S-15, an act to amend the Canada National Parks Act and the Canada-Nova Scotia Offshore Petroleum Resources Accord Implementation Act, and to make consequential amendments to the Canada Shipping Act 2001 be deemed concurrent at the report stage and deemed read a third time and passed. E, Bill C-32, an act to amend the Civil Marriage Act shall be 1. Deemed read a second time and referred to a committee of the whole. 2. Deemed considered in a committee of the whole and reported with the following amendment, quote, that Bill C-32 in Clause 4 be amended by replacing line 10 on page 3 with the following consent, quote, on presentation of an order from the court or A, unquote. 3. Deemed concurred in at the report stage as amended and deemed read a third time and passed. F. Bill C-425, an act to amend the Citizenship Act honouring the Canadian Armed Forces, shall be deemed reported back from the Standing Committee on Citizenship and Immigration without amendment. G. In order to bring full transparency and accountability to the House of Commons spending, the Standing Committee on Procedure and House Affairs be instructed to 1. Conduct open and public hearings with a view to replace the Board of Internal Economy with an independent oversight body. 2. Invite the Auditor General, the Clerk, and the Chief Financial Officer of the House of Commons to participate fully in these hearings. 3. Study the practices of provincial and territorial legislatures, as well as other jurisdictions and Westminster-style parliaments, in order to compare and contrast their administrative oversight. 4. Propose modifications to the Parliament of Canada Act, the Financial Administration Act, the Auditor General Act, and any other acts as deemed necessary. 5. Propose any necessary modifications to the administrative policies and practices of the House of Commons. 6. Examine the subject matter of the motions standing in the name of the member for Papineau placed on the order paper on June 10, 2013. 7. Report its findings to the House no later than December 2, 2013, in order to have any proposed changes to expense disclosure and reporting in place for the beginning of the next fiscal year. H. When the Standing Committee on Procedure and House Affairs meets pursuant to the order of reference set out in paragraph G of this order, one member who is not a member of a recognized party shall be allowed to participate in the hearings as a temporary, non-voting member of that committee. I. On Tuesday, June 18, 2013, the House shall adjourn at 12 midnight or after each of Bills C-54, S-14, S-15, C-32, and S-17 have been read at the third time, whichever comes first, and J. Upon the adjournment of the House on Tuesday, June 18, 2013, the House shall stand adjourned until Monday, September 16, 2013, provided that, for the purposes of any standing order, the House shall be deemed to stand adjourned pursuant to Standing Order 28.
Before we proceed to the question on the consent for the motion, the Honourable Opposition House Leader, I believe, is rising on a point.
Thank you, Mr. Speaker, and thank you for the consideration. My only additions to this are just a series of thanks. I join my friend across the way, the Government House Leader, in thanking the incredible work that the staff do to support our work here as members of Parliament. This has been an extremely long last session with long hours. And to my friends across the way and to our side, sometimes hours filled with somewhat acrimonious debate. I would only like to particularly point out and give thanks both to the government side and also to my friends in the Liberal Party and the Independents in the acceptance of this motion, that the moves towards accountability and transparency that were contained in my friend's motion today, I think are quite precedent-setting and important for the House, as well as the modifications to Bill C-32, modifications that we looked for, and I thank my friend from Wanda Fuca, as well as the great work of all the folks on the Citizenship and Immigration Committee, who I know pulled many long and arduous hours together. But mostly, I rise, as these are the final moments, I believe, of this session, to wish all my honourable colleagues on all sides of the House a very enjoyable time with their families and their friends. It's been a long session, a difficult session, sometimes even productive session. And to you, Mr. Speaker, and with your family, that you have an enjoyable time back in the prairies, and all the best to you and yours. Thank you.
I rise to add my appreciation and that of the Liberals to those that have been expressed by the Government House Leader and by the Opposition House Leader. Again, to say thank you to those who make it possible for this institution to work as effectively as it does and as efficiently as it does. There are times when we question each other and why we're here, but I think the bottom line is we all know that we're here to represent people who made it possible for us to be here on Parliament Hill. We're here to represent Canadians and to do it to the best of our ability, and I think we do that on a daily basis. So it's good to be here. It's good to be involved in this consensus tonight and to express appreciation to all who made it possible and a sincere thank you to all who make it possible for Parliament to run as effectively as it does. So thank you.
Well, at the risk of anticipating the House's response to this motion, I want to thank all honourable members for their contribution for this session and wish everyone a very productive summer at home in the constituencies, keeping in touch with the voters that send us here to do work on their behalf. So, does the Honourable Government House Leader have the unanimous consent of the House to propose these motions? Did I hear a no? Okay. Yes? Yes! The House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? Yes! Agreed and so ordered. Pursuant to the order adopted earlier today, the House shall stand adjourned until Monday, September 16, 2013, at 11 o'clock, pursuant to Standing Order 28.